stand alongside people who might be having some difficulty getting their judgments out. It's a bit of a pressure cooker situation there, because every term there's something like 70 appeals that are heard. And if you don't get all those judgments out and you carry through into the recesses, you're meant to be now preparing your next lot of 70 appeals for the following session. And it's very, very difficult. So it's the kind of court where mutual support is absolutely crucial, and where I feel, having had that sort of service, I'm able to advance that to my colleagues there.
Over to you, President.
Thank you, Professor.
I'm sorry again, President. Let me apologize to you again. The same mistake. Colleagues, may I have your name, please? Commissioners, may I have your names, please?
Nyambi, Matonsela,
Lucas, Schlemmer,
Barnard,
Tsepe,
Thank you. Over to you, President.
Thank you, CJ. Good afternoon, Judge Govan.
Good afternoon, President Meyer.
Well, here we meet again. Let me start by thanking you for making yourself available yet again, and just explain that you do so because of pressure from colleagues at the SCA who keep begging you to do that when you fail. Well, as I said last time, in your 2019 interview, the evidence of your competence, your efficiency, your diligence, your integrity, your collegiality, your contribution to the transformation of the professions and the judiciary, and your community work is all on record, and I won't ask you any questions on those areas. I just want to raise a couple or so issues with you. One, which we talked about last time, your age. You turn 67, I believe, in a week, although one wouldn't say just by looking at you. What contribution, if any, do you think you may still make in the few years you have left in active service? And should advanced age be an issue in a court such as the SCA in any event?
Well, I think age can be a two-edged sword. I think having some advanced age with experience allows you to have had extra additional experience and to make a contribution. Having had the time at the SCA where I have had, I can hit the floor running and make a contribution. In the more than 3 years that are left to me, I will get involved, if I'm in the SCA, in approximately 180 judgments still. So there's a lot of work to be done and achieved within the 3-year period of time. Add that to my 3¼ years that I've already served, and one has the kind of experience that I think can stand alongside of people who might have been appointed recently and not quite yet found their feet, or dealing with areas of law haven't been exposed to for whatever reason. In 2019, the 5 judges whose vacancies were filled had between them 93 years as judges. In this occasion, the 5 judges whose places are to be filled have had a total of 92 years experience. That's 40%. That's 40% of the court that's been changed in the last 2 sessions, and it leaves something of an experience gap, which I think I can fill. And it's a good time, 3 years or so, to stand in the gap, to allow those people to get going, find their feet, and move forward.
Well, you've given us your impressions of the court. What, if anything, do you think we could improve in the way we do things, and how so?
The way judgments are allocated might be looked at to have a slightly more even-handed approach. One might introduce, very often straight after a hearing, for those who don't know, a conference is heard by the panel of judges, who go through the arguments that have been advanced and give a prima facie view of how they think the judgment should go and what it should deal with. It might be helpful to have another interim conference before the person has to actually produce a judgment. Once the dust has settled somewhat, you've been able to go back and research areas of law which might have been raised in argument that hadn't been fully dealt with in heads. So that might be one area of improving the performance of the court. But it's, as I say, it's a high pressure court, and things need to get brought out quite quickly.
Well, regarding conferences, I can just point out that it's always been open to colleagues to indicate, even after the hearing, if they're not ready, they still need time to let the issues marinate before they venture their opinion, and ask the presider to call a conference, an interim conference, or whatever you may want to call it, before the final one. Maybe we just need to spread that message more emphatically. But I just want to hear more about your first point, that we could improve on the way we allocate work. What exactly is not quite right now?
I wouldn't say there's things that are not necessarily quite right, but when presiders allocate judgments, there has been in the past something of a perception that maybe the presiders are somewhat cherry-picking judgments, which are interesting and maybe reportable. And it might be that there's a more of a melting pot system that can be utilized. I'm afraid I don't really know exactly how I'd go about that, but that might be an area where perceptions of not being allocated, as it were, interesting or challenging or whatever it might be, judgments can change.
Yeah. Well, thanks for that point taken. But again, it's something DPPZ and I and the rest of the presiding judges actually have been working very hard at over the past while. First, to ensure that, unlike in the past where you had people ending up not having any judgment to write, when there were people who had maybe as many as 4, to themselves, everyone, especially the acting judges, who we want to give as many opportunities to prove themselves and ease into the culture of the court as much as possible, they get their fair shake. I'm just looking at the May 2021 case allocation now, and all the acting judges, each among them have 2 judgments to write, except 2, and that's it's Judge Patswani, who's brand new, and I thought there are reasons behind that, and Judge Ledwaba. But we know how we'll make up for that in the petitions that keep flooding in, and in the past term he had got more than others. But I want to point out that even 4 permanent judges, including the deputy president, have 1 judgment to write to themselves to make way for the acting judges. Now, about the quality of those judgments that people get to write, that's something that we've sorted out. And one just needs to go to the website and check the judgments that are, the appeals that are there, and watch who will get to write the judgments in those matters. And junior colleagues and acting judges, especially black judges, because that's where issues always around. They get a fair chance to write meaningful judgments and get enough chance to write as other colleagues. So I think we are on the right path to addressing the issues you raised. Is there anything else?
No, and I want to just say that I do recognize that situation has changed, and hopefully those perceptions won't last as a result of that. It is quite clear that there's a much more equal distribution, and those interventions have been very useful.
Well, lastly, I just want to add to your list of judgments. One I picked up yesterday. It was delivered yesterday. Tramo Property Group against Postula Square CC. And the remarkable thing is that it was heard exactly a month ago, and as with all your other judgments, it was the final judgment was delivered 4 weeks later, despite all the pressures of the SA. And that actually is one of the reasons you keep being invited to come back, time and time again. Most often at very short notice where we have an unexpected gap. And thank you for that.
Not at
Thank
all,
you for
President.
saying
In fact, that judgment would have been quicker, but one of the judges was indisposed in hospital for a while and wasn't able to make comments in the judgment.
Well, thank you, just Govan. Thank you, CJ.
Thank you, President. Honorable Nyambi.
Thank you, CJ. Afternoon, Judge Goven.
Good afternoon.
I'm just going to ask one question. As you have quite correctly indicated that not so long ago you were here, probably anything that you think is significant that happened between then and now that we must consider when dealing with all the candidates that you might wish to share with us. Any development that is more than relevant and significant in terms of the position you have applied.
The only relevance is that I have acted again in the Supreme Court of Appeal since then and gained additional experience and formed deeper bonds with colleagues there to be able to deal and work with them at the time. And I've also had lots of personal messages where people have taken the trouble to contact me, colleagues in that court, to say that they are very pleased that I'm appearing and they would very much like me to be on the court. That's the only developments I can think of.
Thanks, Judge Goven. Thanks, CJ.
Thank you, Honorable Nyambi. Commissioner Madonsela.
Thank you, Chief Justice. Judge Goven, good afternoon.
Good afternoon, Commissioner.
The question that I have, one question for you, and you may or may not want to answer it. We have 5 vacancies for the SCA, and one of the applicants is of the same position, in the same running for the position, is a judge who is white, like you, from KZN, and who comes from the same bar that you practice from. I know this because we come from the same area, and who may very well be your friend. You practice together in Pietermaritzburg. Why can't you just settle this issue amongst yourself and say one of us should go and I will support you? I mean, it has happened in the previous, we're interviewing some candidates before you, and they seem to, I got a sense that they've settled amongst themselves as to who's going to take which position, who's going to apply for which one. Is it not possible to make our lives easier? You or him?
Yes.
You know who I'm talking about.
Yes, I do. Yes, and we are friends and colleagues. So, but I think we probably both thought that we might bring something a little bit different, which the Commission would want to consider to the situation. And I certainly have no reason to ask him to stand back, and I presume he felt he had no reason to ask me to stand back. I don't know if I can give you a better answer than that.
Okay, thank you. Thank you, Chief Justice.
Thank you, Madam Sela. SC, Honorable Lucas.
Thank you very much, Chief Justice. Good afternoon, Justice Govan.
Good afternoon.
I see really you are one courageous person to come over and over again. I hope after this, it will be third time lucky.
Thank you.
No, I was going through some of the submissions that you have made, and you are aware that in South Africa we've got a second pandemic of gender-based violence, particularly against women and children. And I've seen that you have adjudicated on some of the issues. But in our findings that we did after a countrywide project of Parliament on the Women's Charter, one of the issues was that we found that particularly the women of South Africa felt that the courts doesn't show enough compassion with what they are going through. I would love to understand what is your take on the issues that you have been dealing with, and what is your view around the whole issue of what is going on.
Thank you. I don't know that the courts are dealing sufficiently sensitively with it. I think victims are often not dealt with a great deal of compassion right from the first instance when they want to report an incident. And I think courts can do better. I think measures have been put in place now with the way people can testify in camera or by remote hearings, which might ameliorate things somewhat. I have to say that my own experience of matters like that is at this stage, both in the High Court and the Supreme Court of Appeal, only the experience of reading on paper what other courts have done in respect of these matters. And I think so often the prosecution doesn't utilize all the evidence that's available. It's in a situation where, by its very nature, there is almost always only one single witness. And as a result, one has to, as a prosecution, bring to bear whatever other evidence you might have, such as DNA samples and collateral people who've seen movements in the area and so on, to try to buttress that version so you don't have a he said, she said kind of scenario. There should also be massive sensitivity to the fact that victims of gender-based violence and violence against children are suffering a second time when they come before the court, and so often go through that and relive that same trauma, but it almost deepens perhaps the wounds which have been suffered. So I do think courts need to be very, very sensitive and very welcoming of those kind of people and the evidence in situations such as that.
Thank you very much, Justice. Thank you, CJ.
Thank you, Honorable Lucas. Prof.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Professor.
I had a discussion with the JP of the Gauteng division this afternoon, and I would just like to hear your opinion. To what extent does the argument of legal counsel lead to good motivated judgments?
It makes a huge difference to have really competent legal counsel argue before you. Without that, the judge is left more or less to their own devices and to their own research. And it's very, very difficult to make sure that that research covers all the angles. That's one of the reasons we have the adversarial system, because you hear properly prepared, well-motivated arguments from both sides, and you're, as a result, shown all the angles, or as many angles as possible, hopefully, in any particular case. So competent argument makes a huge difference to the outcome of good judgments which stand the test of time.
Thank you, Judge. Thank you, CJ.
Thank you, Prof. Commissioner Barnard.
Thank you, CJ. Good afternoon, Judge Gorvin.
Sorry, I can't see you. Oh.
What would you say to allay perceptions? I want to take the matter just from a different perspective, that you are given your prosecutorial background, that you are more of a prosecutor's judge, and that might to some extent compromise the rights of innocent accused. I'm just having a look at the judgments that you shared with us and some of the comments, and for example, the intermediaries where there are rules about how they should be dealt with, and despite non-compliance, the evidence is still upheld. But adding to that, for example, State versus Scott, where two of the accused convictions were later set aside on appeal, successful appeal, and the accused number one, that was also the sentence was made to run concurrently. What would you say to allay those fears or concerns?
Well, I was a prosecutor for 2 years. I was defense counsel for 20. So there's no bias, and my most recent experience as counsel was in the defense side rather than the prosecution side. And judges sometimes get things wrong.
Thank you, Chief Justice. Thank you, Judge.
Thank you, Commissioner Barnard. Commissioner Tsepe.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
CJ, Justice Maya asked one of the questions I wanted to ask, and it was answered promptly by Judge, and thank you very much. It related to the speed with which you deliver your judgments, and that's quite impressive. The one issue I wanted to talk about, Justice Maya touched on it as well, is your contribution to transformation. I see on your CV your contribution, particularly of training of to the bars and to the Black Lawyers Association. What I wanted to find out is what has been your contribution on transfer of skills and training of other judges, both in the High Court where you are appointed and in the SCA. Although you're not appointed permanently, you've been acting there for quite a while. Thank you.
Thank you. I've made it my business when acting judges come to the High Court and I'm sitting to stand alongside them to find out when they're in court and what matters they might have, and to offer my services. Particularly where something like the motion court, which is a very high pressure kind of court situation, a person's going to sit for the very first time. I have invited acting judges to sit with me in my motion court. I've given them the files to go through. When they've gone through it, we've gone into court, and the person, she sat next to me, the acting judge, on occasion, many occasions, right through the motion court proceedings. And then afterwards, we discuss what she would have done better, what I could have done better. And so there is a skills transfer directly there. As regards the other skills transfers, I have on many, many occasions been asked, having offered my services, to look at draft judgments to see if their style could be improved, or rather, that it all was going logically and so on. I have always made it my business to offer to assist anyone who might be having some difficulties with things, whether it's in the SCA, any judge, or in the local High Court. And I've been taken up on that. So it's wonderful to be able to do that. But of course, by its very nature, those aren't really formal proceedings. It's always an informal skills transfer process.
Thank you, Judge. Thank you, CJ.
CJ Siritlaba.
Thank you, Commissioner Tsepe. Honorable Klaba.
Thanks, CJ. Good afternoon.
Good afternoon.
Yes. There was a concern raised regarding the speed with which judges leave the division for a senior position in another in a higher court or a superior court, and they come in for less than 24 months or 2 years, and then avail themselves for appointment to a senior position. Is it not the same as considering a person who only has about 2 to 3 years before retirement? What is your comment on that? Thanks.
No, I think it's the opposite, actually. I think if you've served a lengthy time in the division, you're definitely more likely to make a good contribution within an appeal situation. It's a very good thing, for appeal judges to have sat as judges in the High Court and perhaps below as well, because when you sit as a judge of appeal, it's very, very easy to take an armchair view. And the professor asked me a question about submissions and so on. In the High Court, your level of representation and the level of submissions often isn't as good in the Supreme Court of Appeal. And it's very easy for an appeal judge to sort of somewhat even denigrate judges of first instance when they haven't had the assistance they've had or the opportunity to read a prior judgment from that court. So I think the experience that one has is a good thing. It means that for the time you have on the appeal court, you can make a genuine, real contribution. And of course, having had 3.25 years of experience already, I believe I'm more than ready to make a very good contribution in an appeal court.
Thank you so much,
Thank you.
Judge. Thank you so much, CJ.
Thank you, Honorable Klaver. Thank you very much, Judge Govan. You're excused.
Thank you very much.
Good afternoon, Judge Hughes.
Good afternoon, Chief Justice.
Are you well?
I'm as well as can be.
All right.
I'm just out of breath.
It is well. It is well. Just relax. Be very caring.
Thank you.
Which of the two courts in Gauteng are you attached to?
Pretoria.
And you've been there for how long?
Since 2012 in an acting capacity for 1 year, and then I was appointed in 2013.
A few of your judgments have served before the Constitutional Court. If you want to quickly just say something about how that made you feel and how that might have boosted your confidence as a judge.
It really is good when your judgments go up the ladder, and that's basically what happened in terms of my judgments. Tasima is well quoted all the time. It moved up from the High Court of Pretoria to the SCA. The SCA didn't find favor with me, but the Con Court reinstated my order, and it was on a host of issues in terms of maladministration, contempt of court, delay, condonation. So really, it lets one feel that one is doing one's duty and that one is basically exercising one's self-independence as a judge. It really does. The other one was Big Five and ASCA. Airports Company, that also went up, and that was in terms of dealing with making settlements an order of court, and that went through to the SCA. The SCA shot me down, but the Con Court found favor with me, and they reinstated my order. And that's quite a profound one for me, because we find especially in our division being Pretoria, the hub of where all the matters come through, we find that there is quite a large amount of matters where judges just make orders of court willy-nilly, and that judgment really sets it that it's not allowed, and what's to come if one goes that route. So yes, it has been an accomplishment that I'm proud of, that those two cases have done well right up to the apex court.
Not long after your appointment, your judgments began to surface at Constitutional Court level.
Mm-hmm.
I must say, so much so that the former Deputy Chief Justice asked me to appoint you to act, and I said, no, she hasn't greeted us yet, so it's too early. What did the invitation to serve or to come and act at the SCA do to you? What did that say to you? What message did it communicate to you?
The main message that it communicated to me was that, you can come from whatever walk of life and you can make it. I say so because of the circumstances that I come from. Just today is basically what I can boast about, that I could actually come this far. So having an invitation to the SCA really boosts my morale and also my esteem, and basically confirmed and fortified my view that I am a jurist. I don't have to be of any specific color or creed, but I am a jurist and I'm being recognized. And that's what being invited to the SCA did for me.
My last question, to try and make you comfortable or to cement you in your comfort zone. What is it that you believe has made you ready for the position you are applying for?
Many of
You
us.
don't have to be elaborate, just very
Okay.
briefly. This, that, or the other thing.
Okay. Well, my years of experience, I'm an attorney. I've come from the realms of an attorney. I'm not a senior counsel or an advocate. I come from the realms of an attorney. I'm hardworking. And I make sure I'm diligent. I do the best that I can do. And I think I've had experience in most fields of the law, especially so being in Pretoria. Every single thing comes across your table. So I think on that score, I'm ready. I get my judgments out. I do my work. I am ready. If the commission sees that I'm ready, of course.
Colleagues, before I invite the president, may I have your names, please?
Matonsela.
Tsepe.
Makwanisha.
Schlimmer.
Mlambo.
After Honorable Magwanisha, I didn't hear who was.
JP. Yes. Sorry, Club. JP, did you get you?
Do you have
Wait
my,
a minute.
Do you have my name, CJ?
Is that Honorable Malema?
JP Mlambo.
JP before.
I've got you here, JP. After, I've got you here, Honorable Klaba. Thank you.
Lamola.
You got Jenny,
Lamola.
Jenny Kane.
Thank you.
Breitenbach, please, Chief Justice.
I beg your pardon?
Breitenbach, please, Chief Justice.
Okay, all right, okay. Over to you, President.
Thank you, Chief Justice.
Oh, okay.
Good afternoon, Judge Hughes. It's been a long time, and it's good to see you again, even if it's on the virtual platform.
True, thank
Are you
you.
well?
Yes, I am,
Are you well?
President. Yes,
Have you caught your breath?
yes, I've caught my breath now.
First, I want to vouch for the strong declaration you just made that you are hardworking, and we experienced that at the SCA in the first stint, during your first acting stint, which was extremely tough for you, as you were dealing with seriously ailing parents far away from home and them. And the remarkable thing, they ultimately died during that period.
Yes.
And the remarkable thing that I've not forgotten is that throughout those challenges, you never asked for any favors. You did not ask for time off unduly. You kept working, and you just kept your nose on the grind, and you produced work. And I just found that commendable. I also want to note your long record of gender activism in organizations such as the South African Women Lawyers Association and the South African chapter of the International Association of Women Judges and other community-based women groupings. And notably, the Gauteng branch of the International Association of Women Judges, of which you are a member, is very active and does a lot of good work, especially with the young and upcoming, would-be lawyers, and that's something to be applauded. Now, to come closer to the business of the day, you acted at the SPA for 4 terms, right?
Yes, I did.
How was your experience at the court? And I ask in this context, the SPA style of judgment is quite different from how we write as uni judges. And it's you'll agree that it's not easy to adjust to it. And you suddenly find yourself sitting in all your matters with 4 other colleagues who are going to question every word and each punctuation mark in your judgments. How did you find that transition? Did you struggle at all?
It's not an easy transition because, you know, when you presiding as a single judge, you don't have that oversight or others looking over your shoulder. And when you come to the SCA, you have that sort of a scenario. I found it helpful at times. Yes, I found it helpful, insightful, and of course something a learning curve. That's what I found. But at other times, I found that other colleagues wouldn't be so helpful like others. But you get that from division to division. It just depends on how you deal with it yourself as a person. And if you one that basically puts your head on the block and works, then you can overcome. But it is not an easy transition. The style is clearly totally different. Less facts and more straight to the point, more analytic than telling a story, sort of a saga. That's what I found. The difference between writing in Pretoria and writing at the SCA.
How many judgments did you get to write at the SCA?
I think it was about, let me just check, I think it was about 8. I just want to double check if I can. Sorry about that.
And whilst you are checking, how were your draft judgments received by the other members of your panels, especially the presiding judges?
I didn't have many difficulties. Yes, it's seven judgments. Sorry to interrupt. But I didn't have many difficulties. But of course, you do have instances where sometimes you're not taken seriously by others, you know, in terms of your writing abilities. But ultimately, I dealt with it and I produced my judgments, and my judgments went out with the approval, ultimately.
Yeah, I do recall an unpleasant incident during your second stint in 2019, I think.
Yes.
Where you tussled with a presiding judge who was extremely unhappy with your draft judgment. And as I recall, his concern was that you misconceived the basic criminal law principle and even misunderstood the import of a judgment upon which you relied for your reasoning. And you'll remind me, but I think the case was a simple criminal appeal, and it concerned the admissibility of dog identification.
Yes.
There was this big hullabaloo about it, and you, on the other hand, were very unhappy with the uncollegial manner in which he raised these concerns. Did you find common ground with that colleague?
Well, since I've been at the SCA in that term and I'd finished off, I haven't been back to the SCA. But whilst
No, I mean in respect of the judgment.
Oh yes, okay. Well, in respect of the judgments itself, the presider was not the one that found issue. It was actually down the chain, and it was the yes, it was number 3. Number 3 had issues, and so it wasn't the presider. I'm number 5, so he was number 3, and he had issues about the issue, and he went to the presider. The circumstances were I had written the judgment, I circulated it, I waited, nothing came forward. I got a response from number 4 of the panel. And I made the necessary amendments and spoke to the person in terms of her suggestions. I waited, no response from the top 3 of the panel. And then on the last day, I think it was the Friday before you guys were going for your diversity, on the Friday, the third one on the panel came to my chambers and he said, well, I've spoken to the presider. In respect to their judgment, Wendy, I've spoken to the presider and I'm writing my own judgment. So I said, oh, so he says, yes, I just wanted to let you know. I said, okay, so you've spoken to the presider already. He says, yes, I've spoken to the presider. And he left. And then I sat and I thought about it and I said, no, man. I know for a fact, I mean, even if it's full court appeals or full bench appeals, the quorum must discuss before anybody decides to do anything outside of the quorum. I mean, that's basically courtesy. So I then approached you and I said, look, maybe I don't understand the operations of the SCA. Maybe I'm not au fait with it. Could you just enlighten me as to what the position is? Because the way things were said to me, I feel that that I'm being ousted from writing the judgment. And then you said, no, it doesn't work like this, but you'll deal with it. And what I must appreciate is that y'all went on y'all's diversity. We then went through the realms of dealing with the judgment, because as you said, no, continue with your judgment, carry on what you need to do with the quorum, and then decide whether you want to go with them or you want to issue out your own judgment. And I did the necessary with my judgment. We had quorum. As a quorum, 3 of them went with his judgment. 2 of us stood on my judgment. And they said, well, there's going to be 2 judgments on the same aspect, dealing with the same issues. And they agreed with my order, but they were going to have their own judgment because they felt that I hadn't dealt with the issues that they wanted to deal with in their judgment, which they had not told me about, by the way. But be that as it may, ultimately, the judgment was handed down. After the judgment was handed down, then you said you deal with it, and you spoke to them, and they came to come and see me in my chambers. And when they came to come and see me in my chambers, they weren't very happy with the fact that I had gone to you and not to them. And I made it clear. I said, unfortunately, you 2 decided on your own, without me, to deal with the issue. So how did you expect me to come to you when y'all had already dealt with the issue without me? So I stood my ground, and I appreciated the fact that they knew that I was not happy with the manner in which they had treated me. You had made that known, and they had to take the initiative and come through and settle that issue with me. So I appreciate that you've done that, because that shows that you cannot just disrespect somebody else. You can't. Not in a place of work, especially when one is at work in the SCA. For the whole month, nobody goes home. So you're basically there 24 hours a day with these people. So you have to be cordial and you have to respect each other. That's basically what I'd like to say about that incident.
Well, happily, those people have retired now. I just want to find out, other than this incident, were there other occasions where you found that you were unwelcome in the court, and how was your relationship with the rest of the other colleagues?
No, other than this incident, not at all. I felt very welcome in their court, and but for this incident that left a sour taste in my mouth, I was very happy. And I must commend them as well, because I mean, I went through a difficult period in the first time I was at the SCA, first time ever, when I lost my mom, and then 8 weeks later I lost my dad, in a succession, and I had to bury them whilst I was there. And as everybody knows now, I'm from KZN, so it was a difficult period, and they were really collegial towards me then. And I was looking to come through for the second time, as I did, to basically show them my worth, because they didn't see the Wendy that I am, because of the fact that I was going through my parents being ill and grieving, and I wanted to show them the person that I am. So the second stint, I thought it would be better, but I'm a strong person. I can deal with it.
And what happened with the rest of your judgments? Did they go through smoothly?
No, all of them, yeah, all of them. The other 6 went through very smoothly. Thank you.
All right. No one questioned your intellect or
No.
or worth to be at the SCA.
No, no one did.
All right. Now, I raise these issues as a precursor to my next question, which is a comment by the GCB, which raises a number of concerns about your competence as a judge of appeal. They take issue with the quality of your legal reasoning and writing, your ability to discern the material issues in the case, your understanding of basic principles of civil procedure, your writing style and inability to follow a logical structure, and even your command of the written English language. How would you comment to these criticisms?
With regards to the comment, it's the opinion of the GCB, but my judgments were at the SCA with those who work at the SCA. If there was issue with those judgments, you would be sitting today with comments from those judges who I sat with. I can't take it any further. There are instances where one is not perfect in the English language. One could say it better. One could have written it better. One could say that. But in those judgments that they point out, they go through a host of judgments that I've done. And out of the host of judgment, they pull 3 or 4 out. And out of those 4, they then extrapolate from the 4 the paragraphs that they feel are not up to scratch in terms of the English language and or phrases used by myself. One can do better. One cannot say that one can't do better. One can do better. But in these circumstances, those judgments went out. They went out to the attorneys. They went out to the parties. They went out to the council. None of them have come back that we need leave to appeal because the judge didn't know what she was doing. We can't understand her. We can't discern what she's saying, as they have said in their comments. So that's basically what I've got to say about the complaint. But I'm humbled that they even took the time out to make a comment.
So in sum, you say you're good enough for the SCA?
I think I am, and I assert that I am.
Thank you, Judge Hughes. Thank you, Sujay.
Thank you.
Thank you, President. Advocate Madonsela SC.
Thank you, Chief Justice. Hi, Wendy. Judge
Mr. Madonsela is far from his mic, I think.
Good afternoon, Judge Hughes.
Good afternoon, Commissioner.
I should start by saying that I long for the day. I'm longing for the day when we can sit in judgment and judge the linguistic proficiency of English speakers when they have to write in Zulu or any of the vernacular languages. I'm longing for that day. But that's not my question.
Commissioner Madonsela, I appreciate that, but let's cut down on preambles, please.
The question is this. I would like you to recount how it came about that when I started at the bar, you were the only person ever who managed to brief me on a Transnet brief, ever. And I've never seen it since you left. What did it take for you to do that and transport me and ask me to come and argue a matter in another division in Joburg? And it has never happened. And what is your experience about the appearances of black counsel before you as a judge in the courts where you have appeared?
Okay, well, just full disclosure that the commissioner, Madonsela, started off at the Durban Bar, and my firm is proud to say, well, my firm that I had is definitely proud that we've taken you so far, and I congratulate you. But being that as it may, let me move on. In terms of instructing counsel, I did my articles at a firm called Mlaba Mackay and Partners, and we did mainly political work. We were sponsored by SALDEF in those days, and you only encounter those counsel who are thrown and shunned by the wayside, that are prepared to come and do pro bono work. So my entire ethos when I formulated my own practice was to ensure that I did pro bono work. And in doing so, you actually enhance the pool of those advocates who are not briefed by the so-called big firms. And in doing so, you also enhance yourself and themselves to enhance others. And in the Transnet matter, we were instructed by, of course, in those days, it was only the white legal advisors, and they were of the view that I should instruct X, Y, and Z. And I said, no, I've got somebody who's competent. He can do the work. But it's in Joburg. I said, we'll come up to Joburg. We'll find our own way to Joburg, but we'll get there. And we won that case, and we did well. And thereafter, they trusted me in terms of my judgment of who to appoint and when to appoint. I also had the opportunity myself to also impart the little skill that I had picked up along the way working with my client to actually guide my counsel so that he doesn't disappoint my client, and that we empower each other as we fight the fight of trying to make sure that we try to do work together so we can move out of the realm of not having work, you know, as black counsel and as black attorneys.
Thank you, Chief Justice.
Thank you very much, SC. Advocate Mpofu SC.
Thank you. Good afternoon. Is it still afternoon?
It's
Good afternoon, Judge.
Afternoon,
Thank-
Commissioner.
Good to see you again.
Oh, nice to see you as well.
Yes. Look, I don't even want to waste time about the issue that Mr. Madonsela was talking about on language. As you know, I'm one of the representatives of the GCB. So the protocol prevents me from commenting on some of those issues.
Understandable.
So but I can just assure you that that is not the view of all persons like Mr. Madonsela who are part of the GCB. But be that as it may, I thought maybe I'll just talk about my own personal experiences, particularly on this language thing. I remember specifically, and I'd like you to comment on this. One of the cases which we appeared before you, I think you were sitting with the JP on a full bench, one of the most important cases in the history of this country, which was the President versus the Public Protector, without which there would be no Zondo Commission today, if we had not argued that case successfully. Sometimes it gets forgotten. But in particular, the reason why I'm raising this is because I was just going through the judgment now, trying to find the passage, but I can't find it. But I remember specifically that one of the issues which was decisive in that case was the difference between, sometimes cases can turn on a small thing. It was the difference between the and a. And I remember when we argued this, you were it's in the judgment, but you are the first person who picked up that point. And every time the counsel from the other side came up, you were saying, but it doesn't say the, it says a, and so on. And that was a pivotal issue in the argument that we had advanced. Now, if somebody who can dissect a matter at that level of that minute level of the Queen's language, then I find it a bit strange that you are accused of being bad in English. I just wanted to know, firstly, whether you remember that, and whether in your general experience of interpretation, you've ever struggled with interpreting statutes in their English technical sense.
Well, in terms of the memory, I remember that. I think even the JP can attest to that, because that was brought out in our consultations, prior, and that was advanced by me. The JP can attest to that. In terms of interpretation, if you look at the list of judgments that I've put up, or you've appeared in my court and I've delivered judgments for you, you would know that most of the work that I get allocated is technical interpretation, statutes, civil litigation, custom and exercise, interpreting clauses, interpreting legislation. Most of the work that I get is that way inclined. So in all the more than 300 cases that I've been doing, I feel that I do so adequately, and I've had no problem with doing so. That's basically it.
Thank you very much. Yeah. And then on a separate but maybe a related topic, I also appeared before you in a very complex intellectual property matter. And in my experience, the judgment was delivered promptly. It was more than technically good. I think I was partially successful. I can't remember.
Yes.
Yes, I can't remember the outcome. But the point of the matter is that for someone like you and me, this was a field that was not our daily bread.
Yes.
But obviously, when the work is there, it doesn't matter how complex it is. But we had to navigate through it. And I think it was against the people who fancy themselves as the specialists in those areas. The real question is, how do you rate the question of application for a judge or counsel for that matter? Because nobody can be familiar with all areas of law. It doesn't matter whether it's competition law, intellectual property, or criminal law, or whatever it is. What does a judge have to do when confronted with an area which may not have been their specialty of practice, or a completely new area, which I'm sure has happened to you?
Well, my modus operandi is that, and I knuckle down and I read my file. I make sure I do my reading. Having done my reading, then I do my research. One just needs to research. Once one has researched, then one questions oneself, and that in turn helps you to ultimately find the answer. So I regard it akin to when you start varsity. You've never ever had a law of contract when you were in school. But when you get to varsity, you listen to the lecture, you do the research, you go to the exam and you write the exam, and then you get sum cum laude or cum laude, or you get B, C, or whatever. So it's likewise, if you've got that passion in you to research, then you can overcome any aspect of the law that you're not familiar with.
Thank you. Thank you, Sujay.
Thank you.
Thank you, Commissioner Mpofu. Commissioner Matolo Zepu.
Thank you, CJ, and good afternoon, Judge.
Good afternoon, Commissioner.
Right, one of the things I love about our female colleagues, especially judges in Gauteng division, is their sisterhood, you know, and their willingness to train mentor young female legal practitioners. But what I want to find out from you is, in your experience, are there a lot of young female attorneys appearing before you? And if not, what can be done to encourage and upskill them to, because I'm really proud of attorneys who are judges now, like myself, but I still feel that we need to do something extra, you know, to upskill them, to appear and not depend on
Counsel.
Advocating officer.
With the upskilling of attorneys, I think attorneys should take time out to observe. You know, they need to take time to observe first. Come through and observe, and it's difficult because you're running a practice. But come through and observe, because once you observe, the phobia is gone. The scare of being in the court realm where advocates are, sulks are, flies through the window because you've observed what they do. And then you realize that, in fact, I can do this. So mainly observing, and also issuing work to advocates that you know are going to enhance your skill. They're going to enhance your skill. You brief your advocate, he does the opening, he does part A, and he says, the attorney who has right of appearance is going to argue on the cost, which is a small portion, but it's part B. You empowered. You empowered. The judge knows you. You have basically shown your worth. So that's basically what I would suggest or recommend that could be done, if it helps to answer your question.
Yeah, just a follow-up. I know that you are part of the female judges who participate in workshops,
Yes.
you know, empowering female attorneys. I'm worried that if we have to take you to Bloemfontein, will I be able to get you again to come and train?
Well, the JP has a training platform of training aspirant judges, not only from the bar, but also from the magistracy and from the fraternity of attorneys. So if you would maybe keep in contact with the JP, he could give you dates on when they go through and do the necessary trainings, and that's how you can still keep in touch with judges like myself.
Thank you, CJ.
Thank you.
Thank you very much, Commissioner. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, I'll ask one question because the other has been covered.
Okay.
Judge, my question relates to a comment from the GCB relating to commitment to the values of the Constitution. The GCB says there's nothing in your application or history that answers this question. So I wanted to then ask this question of you, that as you know, the Constitution requires courts, when interpreting any legislation, when developing the common law and customary law, to promote the spirit, purport, and objects of the Bill of Rights. Can you point to cases that you wrote that reflects your observance of this obligation?
The same GCB made mention of the case that I made reference to in respect of the same comment that you're seeking, and that was in Center of Child Law versus Media 24, where basically it dealt with the interpretation of dealing with child witnesses, child victims, and child accused, and it went all the way up to the Constitutional Court. So that's my answer to your question.
Thank you, Judge. Thank you, CJ.
Thank you, Commissioner Tsepe. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon to you, Judge Hughes.
Okay.
I'm on the screen.
Okay.
Thank you. I think it's quite a coincidence that today we have had two judges appearing before us, Judge Carrols and yourself, both ex-Durban, having schooled in Durban, and both of you are applying, both of you are alumni of University of Durban Westville, and both of you are applying for positions to the SDA. And I can also relate to the area you come from, because I'm also a Durban boy, although south of Durban, but a bit of a rural area. But my question, Judge Hughes, and I'm very proud of your growth.
Thank you.
My question relates to your career path in the judiciary. Because when I see in your questionnaire, you acted as a judge in 2009 in KwaZulu-Natal. But thereafter, you went to the Northern Cape for 2 years, Pretoria, acting judge, then Gauteng, and then Pretoria, and then even a stint in the Lesotho High Court as an acting judge in the Constitutional Court division. Could you just elucidate on what gave rise to these moves? Is it the fact that you didn't have opportunities in KZN, which is your home province, or any other reasons? Thank you.
To answer you on that question, in 2009, I started my acting stint after I'd finished the aspirant women's judicial training. And then I was invited by one of the conveners of that course, JP Homo, to be mentored in his court. And then I took that leave and I went to Kimberley, and I was mentored in Kimberley. Thereafter, I got an invitation. I got an invitation from JP Mlambo to come through to his court, because he had basically heard of my work in Kimberley, and that's when I got through to Pretoria in 2012. On all those occasions that I moved to Kimberley, to Pretoria, it was by invitation by the relevant JPs, who basically saw the potential in me, and they basically invited me, and I basically put my hand up and I went through. In respect of the Lesotho acting appointment, we were seconded, Colopin, Judge Mahoka, and he's in the SCA now, and myself was seconded to deal with an issue on a constitutional matter in Lesotho, which dealt with the impeachment of the Chief Justice at that time. That's how I got to preside in a matter in Lesotho.
Thank you very much, Judge. CJ, what I've learned today is that even the JPs go on a fishing expedition to catch the best fish for their course. So thank you for that. Thank you very much, Chief Justice, and thank you, Judge.
Thank you, Honorable Singh. Thank you, Honorable Magwanisha.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
And my condolences on your loss.
Oh, thank you so much. Appreciate that.
No, I have only one question for you. You are a judge of a very active court with a lot of workload. How has the case line assisted the judges in that division to make your work much easier?
Oh, it's heaven sent. You just can't understand how our lives have been made so much easier. We deal with very complex matters where you're carrying around maybe 100 to 80 lever arch files if you're dealing with it physically. But in this instance, this is the first portion that I'd like to deal with. In this instance, everything is on case lines. It's uploaded onto case lines. You in the comfort of your study, you read whenever you want to read. You don't have to now say somebody hasn't put the file on your table. Everything is logged onto case lines. It's really made life easier. It's also made our lives easy in the sense of delivering of judgments. There's no delays that you need to look for a court, or you need to ensure that you assign a day that you'll deliver the judgment, because electronically, today I finish the judgment. Tomorrow morning, when you get to your office or your chambers, it's electronically delivered in terms of the protocol. So it makes things much simpler. More so, with the comorbidities that we have, and with the situation of COVID, you're able to work from home for like most parts of the lockdown, especially the serious lockdown, where you can't basically give justice to others by going to the court, you are able to do so from the comfort of your study, or if you don't have a study, from the comfort of your bedroom. You're able to do that. So that's how much easier it has made life for the judges. I was just speaking to a colleague of mine, and he was saying that he's in this investigation unit, and he was saying it's so difficult because they're not on case lines, and he's lugging around files, and life is so much difficult. I don't know how we'll manage without case lines.
So if you are appointed to the Supreme Court, you will miss it.
I will. And I might have to advocate that they get it.
Thank you very much. Thank you, Chief Justice.
The SCA is on case lines. Thank you, CJ.
Okay.
Thank you, Honorable Magwanisha. Thank you. JP?
Thank you, Chief Justice. Judge Hughes,
Yes.
you were referred to some judgments in the GCB comments where you could have got things wrong. Is it not correct that in your life as a judge, you'll get certain things wrong?
Yes, you would. Yes, you would.
And it's not because you're stupid or you don't apply yourself. You will, it's a human trait, you'll get things wrong sometimes.
Yeah, well, clearly it has been indicated in this forum that even those who have the acumen from abroad can even get things wrong.
And is it not correct too that in your life as a judge, you can never start your career as a judge and retire as a judge without having been reversed on appeal?
Oh, you have to deal with that. You have to deal with that because it's part of the makeup of being a judge.
Yes.
Just like you have to deal with when somebody comes through and they say, we want leave to appeal. And we say, you erred or you misdirected yourself. It's part of the makeup of being a judge.
Yes. I think, CJ, one last question, sorry. Your experience of number 3 talking to number 1 and coming with things, you join some of us who've been there. Number 5, who was an acting judge, got through to number 1 to criticize a judgment I'd written when I was permanent and when I was number 3 without talking to me, and circulated a judgment without talking to me. And when you look at it, Justice Siriti will tell you, as you said, it deals with the same issues, same facts, same conclusion. But simply because number 5 has got an English name, you are going to be forced to try and adopt that draft. You join that club. Thank you, CJ.
Thank you, JP. It looks like you might just be an authority on the top 6. I think I need to talk more to.
Yeah.
Honorable.
I agree. Chief Justice, thank you. I'm covered. Thanks, Chief Justice.
Thank you, Honorable Klaba. Advocate KNSC.
Thank you, Chief Justice. Good afternoon, Judge.
Okay.
Sorry, Judge, are you able to hear me?
Yeah, now I'm able to see you and hear you.
Yes, good afternoon.
Good afternoon to you.
What has been so evident from your interview is a comment made by the GCB, which is a report back that you are pleasant in court and that you engage actively with counsel. You put your views to them and you give them a proper opportunity to respond. And frankly, that's just such a fantastic review and report of you and the type of interaction that counsel really value in court. I just wanted to commend you on that.
Thank you.
In relation to the GCB review, many of my colleagues have taken up what is said in it, but it pertains mostly to quibbles about your language, and I don't want to take that up. What I would like you to deal with, if you could, and just have a look at it, the JP has suggested it may have been an error, but in the I would say the criticism against you and the main thrust of it is that in a review application, you dealt with one ground of review when there were others that also required to be dealt with and perhaps overlooked the other grounds of review. Now, given that correction on appeal and so on, is there anything you would like to say about that?
In respect of that matter, I would like to say that the aspect that I dealt with was a jurisdictional aspect, and I found that it was dispositive of the entire review. That's the stance that I had taken. The issue of me not dealing with the other elements of the review, in my view, when I dealt with the review, did not fall within the realm of a review because they weren't raised with the committee before. So when it went to the SCA, I acknowledge that the SCA says I should have dealt with them because one of them could have been successful for the applicant. I acknowledge that. However, I also want to point out that in terms of the issue that I dealt with, the applicant did not take issue with that on appeal. So that issue was clearly good enough and stood. And that's basically what I'd like to say about that. But I acknowledge that the SCA has made a pronouncement on the manner in which I dealt with the matter.
Thank you very much. Thank you for that answer. Thank you, Chief Justice.
Thank you very much, Commissioner. Honorable Minister.
Thank you, CJ. I'm covered.
Thank you very much, Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, there's a perception, or there's a reluctance, or a perceived reluctance by members of the judiciary, including the magistracy, to deal with matters of rape, sexual violence, gender-based violence. In your view, what can be done to address this matter?
Some colleagues of mine, we had some discussion in respect of dealing with criminal matters across the board, not only with rape matters, but criminal matters where there's gruesome deaths and there's hijackings and there's incidents of molestation and the like. And we said, maybe we should instill some debriefing and or a sense of trying to have an opportunity to speak about how we handle matters of that kind in our courts. But what I've noticed is that wherever you are deployed by the JP, you have to go and deal with it. It is more so that those who have a civil background shy away from that sort of work. But the JP makes certain that everyone who is a judge must do all spectrums of work, especially so in the Gauteng division. You can't shy away from the work. But I get that there are those who don't want to do that work. But unfortunately, you decided to basically work for the public, so you're going to have to put your issues aside and get on with the work. That's the best answer I can give you.
Thank you very much.
Thank you, Judge Hughes. You are excused now.
Okay, thank you. Thank you to the Commission for having me, and thank you, Chief Justice. Thank you, Commissioners.
Thank you.
Chief Justice, the candidate is ready.
Thank you, JP. Good afternoon, Judge Kuhn.
Good afternoon, Chief Justice.
How are you, sir?
I'm very well, thank you, and I hope you and the commissioners are as well.
We are trying. For how many years have you been a judge?
I was appointed on the 1st of November, 2006, so it's now 14 and a half years. I'll have 15 years at the end of this year.
And how many acting stints have you had at the Supreme Court of Appeal?
I've had, what is it now, 4, if I remember correctly. The first one was from the end of 2014 into 15. Then thereafter, I had from October 2019 for that session, the succeeding session, and the one thereafter, terminating on the 31st of May 2020.
Please, as briefly as you can, just brag and demonstrate to us how best suited you are to be appointed to the SCA.
Well, I've endeavored to summarize that in the questionnaire, which I completed, but if I may just speak about it briefly. I would like to think that I could make a very positive and constructive contribution arising from my experience over 14 and a half years in the KwaZulu-Natal division of the High Court. I have, apart from that experience, also prior experience at the sidebar. After graduating, I was a part-time lecturer at the University of Natal, now the University of KwaZulu-Natal, in the law of contract and also civil procedure. I thereafter, or after my graduation, did articles of clerkship. I qualified as an attorney, as a notary public and a conveyancer in 1987, and practiced as a professional assistant with a firm of attorneys until January 1988, when I went to the bar. So I have sidebar experience. I have the qualifications and experience also as a notary public and as a conveyancer in the property field. I have experience as a junior advocate for 10 years, from 1988, I beg your pardon, to November 1997, when I was elevated to senior counsel status, and I practiced as a senior counsel until I was elevated to the bench on the 1st of November 2006. I pride myself on the fact that I endeavor to deliver speedy justice. My judgments are normally complete within a couple of weeks. I think I've only had 2 judgments ever outstanding for more than 3 months. And in the one instance where that happened, it was in fact a very difficult matter. It took me rewriting the judgment 3 times before I eventually ended up with a version that I thought was correct. I enjoy working as part of a team, which is obviously what I have some experience of, having been the senior presiding judge in full court appeals in the division which I sit, and then also being part of a team of judges, a panel of 5, in the Supreme Court of Appeal context. I've always endeavored to be independent, objective, and dispassionate. I believe, particularly in the appeal court setting, that delivery of justice is a team effort. The benefit of the Supreme Court of Appeal, to me in particular, lies in the fact that there are various or experience, disciplines, and expertise of the members of the bench which are pooled and which, by a proper process of discussion and exchange of views, will hopefully result in the best possible judgment. I have a background academically in the commercial field, having graduated with a BCom. I've also completed a certificate in arbitration from the Arbitration Foundation of South Africa. I'm well equipped, having majored in accounting, to read financial statements, which I have found very useful in insolvency matters that I deal with, and also when dealing with the assessment of different business plans which are submitted in proceedings where business rescue is at stake. I've mentioned the fact that I was previously an attorney in strike-off applications and the like. I'm well familiar with and feel myself equipped to assess the position of the conduct of attorneys who the particular legal practice council might be seeking to have struck off the roll or otherwise punished. Yes, I think that possibly, without laboring the other facts, are the contributions that I would like to make to the Supreme Court of Appeal, should I be appointed to that bench. Thank you.
Thank you, Judge Goon. Before I hand over to you, President, may I have the list of colleagues who would want to put questions to Judge Goon, please?
Muimang.
Matolo Jeku.
Dodovu.
President?
Thank you, Chief Justice. Good afternoon, Judge Kun.
Good afternoon, Judge Mandisa.
Are you well?
I'm very well, thank you.
Good. I won't keep you. I only have two issues that I'd like to raise with you. That you are an experienced and competent judge is not in doubt at all, and you've proved yourself at the SCA. First is this: you know the demographics of the Supreme Court of Appeal. It is a court under reconstruction in terms of gender and race representation. Out of a complement of 25 judges, we have only 8 women. I won't do the breakdown in respect of the males, but we have 3 white males and 1 white female. You are one of 5 white males in this in this process we're busy with now, who I think it can be fairly said as endowed as you are. Now, what special attributes would you bring to the SCA if appointed that the other 10 candidates do not possess?
I think the points that I've raised earlier on are the attributes that I will be able to bring to the Supreme Court of Appeal. I appreciate, though, the point that you've raised with me. I'm well alive to the provisions of Section 174(2) of the Constitution, which requires that when there's an appointment of judicial officers, that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. Obviously, I'm a white male. I can only refer to the contributions I mentioned earlier as contributions that I can make. The decision ultimately is a difficult one, but it's one that you will have to make as this esteemed body to consider, I would think, matters such as those contributions which I've referred to, which I believe I can make, weighed against the imperatives of Section 174 subsection 2, and taking into account, and this is something that I'm not necessarily privy to, but which you would be privy to, Justice Mandisa, Maya, I beg your pardon, because you no doubt have certain objectives in mind in deciding what you want on your court, who you want on your court, the experience that is required, and effectively what I suppose I'm referring to is some sort of a succession plan. So it's a multidisciplinary inquiry, I suppose, because you would have to look at how many judges you have who will still have, say, 8 or 10 years left on the Supreme Court of Appeal bench, where they can make a contribution and where they can establish a certain jurisprudential philosophy. You would have to look at who is retired, who will be retiring soon as part of that succession plan, and then weigh the contributions which I said I can make, and I make them with due humility, against the imperatives of Section 174(2) in deciding on whether my application should be successful or not. I'm afraid if that sounds a little bit vague, I don't think I can be any more specific than that. I enjoyed the time that I worked on the Supreme Court of Appeal. I got on very well with the various colleagues there, and I would very much like to continue and contribute to that court. I'm fairly well poised, I believe, at the moment. I have nearly 14 and a half years of experience on the High Court bench. Having been appointed at a fairly young age, I have an exit date from the judiciary in September 2029. So that means I have approximately still another 8.5 years left that I can be a member of the Supreme Court of Appeal. I hope that has answered your answer.
Yeah. No, it does, and it's not a vague answer at all. It's actually useful. It's useful. The last point is something you mentioned in your application form, that you had had surgery some years ago in 2010. If you'd not mentioned it, I would never have known. Has that impacted your ability to execute your work in any way?
No, not at all. No, as I mentioned, it was an unfortunate thing. It happened. I had single bypass surgery, open heart surgery. That was on the 1st of November 2010. I was fortunate. I was very fit at the time, doing long distance running and other sporting activities. I recovered fully from it. Obviously, I'm a member of the Zip Club, as they call it. I have a long cut in the front of my chest, but I've recovered fully. I have no problems. I'm not even on statin medications, which some of you might know is normally customary to be prescribed to patients formerly in that position to reduce their cholesterol count. I don't have a problem with that. I go for regular checkups at least once a year with my cardiologist, and every checkup since 2010 has come back completely clean. It doesn't affect my workability, and in fact, end of 2019, I went and walked the Camino from Portugal into Spain without any problems. Yes, I lead an active life, and it certainly has not impacted on my health in any way that would affect my ability to work.
Thank you, Judge Kun. That's all from me, CJ.
Thank you.
Thank you, President. Honorable Muiman.
Thank you.
CJ, could you add me, please? I'm sorry. Singh.
Thank you, Chief Justice. Good afternoon, Judge Kun.
Good afternoon.
Just two matters from two questions from my side. The first one relates to the the matter that you dealt with that is reflected in your profile. The one that involved the Cape Bar Council and Judicial Services Commission.
Yes.
The thrust that you made around the importance of compliance with the Constitution when it entrusts a creature of itself for that structure to function efficiently and effectively. I would like to get a sense in terms of what drove the motivation behind the judgment that you penned. The second one relates to the attack that sometimes you sense from the public, particularly around judgment that the court might make against either the executive or the legislature, whether it is the court condemning the government allowing al-Bashir to flee the country. What is it that can be done to educate our public around the importance that the court has in terms of ensuring that their judgment is understood, particularly within the context of our history, where we come from, but at the same time, the fact that we are a young democracy. Constitutional democracy sometimes can be very complicated, and therefore you need to ensure that we educate our public around the difference between parliamentary democracy and constitutional democracy, majoritarianism, vis-a-vis the confines that you need to operate within as a constitutional democratic state. Thank you, Judge Kuhn. Thank you, Chief Justice.
Thank you.
Thank you, Honorable.
Thank you. I hope I answer your questions fully, or as fully as I can. As regards the first one, that is the Cape Bar Council versus the Judicial Service Commission. The primary point there, and it wasn't really a novel issue, I think it was based mainly on a previous judgment in Ski Road, and then also a judgment in the Cape. I think it was the Democratic Alliance versus the Judicial Service Commission. The facts in that matter had been not too different from those that confronted me, but the member of the Judicial Service Commission that was absent on that occasion was the Premier or the Premier's representative. It was a Judicial Service Commission meeting to deal with the appointment of judges in a particular provincial division. In other words, where this commission consists not of 23 members, but of 25, the last two being the Premier of that province and then the Judge President of that province. Now, in that case, the Premier of the province, for reasons which I cannot recall, wasn't there. But based on that judgment, the one in, I think it was Ski Road, if I remember correctly, the 1954 judgment dealing with administrative law, and that if you have a body which has to take a decision, then it means a body as properly constituted in terms of the legislation. I came to the conclusion, as subsequently also endorsed by the Supreme Court of Appeal in a unanimous judgment written by Justice Brandt, that the Judicial Service Commission hadn't been properly constituted. And that was the basis for that finding. As regards the second issue, it is a burning issue, and it's something that's quite close to my heart as well. Let me just firstly say that I tend to err rather on the side of showing some deference to executive action than being too progressive in possibly penning a judgment which might encroach on an aspect of the executive which ideally should be left to the executive, if you understand what I say by that. Having said that, I write judgments for the loser. That's always been my approach. it is important that when I make a finding, that the person who has lost must understand why he or she or it lost. The victor will collect a copy of the judgment, probably never read it, because he or she has the order that they want. But it's important to write for the loser, and it's even more important to write in language not always necessarily reminiscent of the legalese that we so easily use and intersperse with Latin phrases, but rather in intelligible language which a layperson can hopefully also understand. So that one must reduce what might be fairly complex issues of law to as simple terms as you can. Now, I would like to think that I don't suffer too much of a problem in that regard, because the language in which I write English is my second language. So I have an adequate command of it, but I'm not necessarily privy to particularly highfalutin words which men in the street might not understand. But it's important to emphasize that issue, that judgments must be intelligible, they must be able to be understood by the person that I'm writing for, particularly if in a criminal context. And it's not looking down on accused persons at all, but often they are people with a lower level of education because of circumstances, very unfortunate circumstances at times. And you've got to be able to explain to that person. Now, how do we get the message out there to the public? It's a more difficult issue. I've never understood why some courses at schools, some that are often scorned as perhaps of less academic value, and I think here particularly of life orientation, for those who might have children or have recently had children at school, that's a subject that's often prescribed. It's mandatory. It doesn't carry points for admission purposes at universities, but it's a general sort of a life orientation, as the name indicates. And I think, like with the American example, there's scope for a component to be added to that course on familiarizing young children, high school children now, with the Bill of Rights, for example, that they become acutely aware of what their rights are, not only as children in terms of Section 26 and the other sections, but of all the fundamental rights. I think if that is taught, and it comes through the ages as the population grows older, and they have that basic knowledge, then hopefully judgments will also become more intelligible. But that's, I think, the only recommendation I can suggest at the moment as I sit here.
Thank you, Judge.
Thank you.
Thank you, Chief Justice.
Thank you, Honorable Moeman. Commissioner Matolo Depu.
Okay, thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
I heard you earlier speaking about some of the judgment, the cases that come before you involve the conduct of legal practitioners. The conduct of legal practitioners and what I want to find out, the Legal Practice Council and the Legal Practice Act, its main mandate is to protect the public, and secondly, to improve the standard and uphold the integrity of practitioners. So, in your view, I'm very curious to know that what can be done. What do you see as a problem of the conduct of legal practitioners, both advocates and we don't have it's legal practitioners now.
Yes.
What do you see as that problem that comes before you frequently, and if so, what can be done to try and curb it?
Yes. Thank you. If I may just firstly say, although I refer to dealing with these matters, I don't deal with them that often. It's not as though we have a huge influx of that kind of cases in KZN, but when they do arise, I often preside on a full bench, or then sometimes even in a full court. Many of them involve a failure to apply timeously for the audit certificate. There are many young practitioners in KZN who, I think, firstly battle to find articles of clerkship. When they do, upon completion thereof, they have difficulty in finding employment with bigger firms. It's pretty much for a select group. So the next best thing is that many open by force, almost, their own practices. And they might be talented lawyers, but they're not necessarily very talented accountants. And the bookkeeping falls behind, and soon they cannot get a clean audit certificate, or they simply omit because of pressures of practice, or whatever the situation might be, to renew the certificate timeously. Then there's a complaint by the Law Society or the Internal Audit Department, I beg your pardon, Law Society, LPC. The LPC picks that up, and they commence proceedings against them. And then you often find an application is brought for their suspension, pending them providing the required audit certificate. And they do so after the application is brought and it's maybe adjourned for a month. They produce that certificate, but now they also face the costs on an attorney and client scale of this application that's been brought. So one leg of it is a failure to, or an inability to adequately appreciate the commercial requirements, the accounting requirements of conducting a legal practice. I am not, in answering this question, including those who have opened a trust account and there is now a huge sum of money coming through in the trust account, and being young practitioners, they might be tempted to borrow that amount on a Friday afternoon with the expectation of putting it back on the Monday, and it's going to be doubled at the casino, or whatever the case may be, and it doesn't happen. Those are clear cases of theft of trust monies or fraud or whatever particular situation it might be. That clearly is a more serious situation. But I think there you're a fit and proper person, you have a sense of responsibility, a sense of honesty, and you avoid that kind of conduct, or you don't and you're unfit to practice. But even then, our inclination is to look at serial defaulters on not providing audit certificates, that they perhaps be suspended subject to certain conditions, such as, for example, that they don't practice for their own account, but nevertheless still practice, but with a larger firm, where there's an infrastructure in place dealing with accountancy issues, and then hopefully they acquire the skills. That's the only suggestion I can make. I think the LPC has improved its act a lot on that in that regard. They have these or some of their personnel going out, doing routine checks and trying to assist wherever they can. But it's generally a problem with young practitioners having just started off, and I think not quite appreciating fully the extent of what is required by the accounting side of a legal practice.
Just a follow-up. I thank you for that. The reason I'm asking, we are trying to introduce programs of trying to assist them to improve the running of practice. Thank you.
Yes. Thank you.
CJ.
Thank you, Commissioner. Honorable Dodovu.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon, sir.
Now that you referred to Section 174, that provision of the Constitution enjoins this body, the JSC, to look at, to consider the racial and gender balance in terms of the composition of this body. Do you think, in your view, that there could be other considerations that we apply in selecting the candidates, like, for example, looking at the ideological orientation or the class disposition of the candidates who appear before us? Do you think we must look at those as well as considerations for candidates?
Yes, I wouldn't like to to fetter your discretion on deciding on an appropriate candidate. 174(1), as you are aware, refers to an appropriately qualified person and then a person who is a fit and proper person to be appointed. Now, I know that various organizations, amongst others, the Government Democratic Rights Unit of the University of Cape Town, which produces or some of the comments on judgments that we have submitted, have expressed the view that this is Section 174(2) is not just a numbers issue, if I may call it that, or a quota type system. 174(2) in its wording to me appears to differ, for example, from equity legislation and legislation that requires that the employment equity, that there be a certain number of a certain racial group. So in other words, it's not a SARS versus the name of the lady escapes me now, but the policewoman situation of she couldn't qualify because the next stage of the motion there were already certain numbers of population groups. It's a polycentric inquiry. It requires that it broadly reflects race, gender are important in making your decision, but so are appropriately qualified, experience, fit and proper person, and considerations such as the work ethic, for example, of the applicant, possibly a particular jurisprudential leaning, and that's where I try to combine it with
Personally, I singled out two. I said ideological orientation and class disposition. I want you to speak to the two. I know that there could be others that we look at, but I want those two.
Sorry, I don't want to answer a question with a question, but ideological, if it's as wide an ideology as whether one has a libertarian approach to law or a positivist approach to law, then I would think that those are considerations which should be given attention to ensure an adequate spread within that particular court of various representative ideologies.
Looking at yourself, lastly, Chief Justice, could you classify yourself as a conservative, a progressive, or even a Pan-Africanist?
Yeah, I would have some difficulty in putting myself in a pigeonhole. In legal terminology and philosophy, I'm probably a more positivist in the sense that I look at what the law says. By virtue of my training, I'm rather a positivist looking at what the law means than what the law perhaps should be. Having said that, I believe there's a role for the judiciary. We don't go out and select cases. We deal with cases that come before us. We're not proactive. We, in a sense, I suppose, reactive in having to decide what comes before us. We don't control, as is often said, the sword or the purse. We're not the executive. We're not the legislature. So it's quite difficult for a judge to say that you subscribe to a certain philosophy. Certainly, as a South African judge, I have sworn true to the Constitution, and I embrace the lifestyle and the society that we have. A multicultural, multiracial society where I believe every person should have his place in the sun. Those that have been disadvantaged, there are provisions in the Constitution, historically disadvantaged, that we must be very sensitive to.
If I had more time, I would follow up, but it's okay.
Sorry, if I haven't answered your
no,
question,
it's okay.
please forgive me, but I think that's the best I can do in the.
No, it's okay, except that you look composed and confident, and thanks for that.
Thank you.
Honorable Singh.
Thank you very much, Chief Justice. Chief Justice, I just had a follow-up with regard to the issue raised by Commissioner Moemang when he referred to the Cape Bar Council and the JSC and another. Now, I know, Judge, good afternoon, Judge.
Good afternoon, Mr. Singh.
I know that you did tell us the reason for that kind of judgment and that the appeal was also dismissed in the SCA. But I'm trying to understand your comment there on page 7, where you say, and I want to quote, "I granted the order without fear, demonstrating my independence and objectivity, and regardless of the consequence that it might possibly not endear me to this commission in the future." Now, for myself, I must say that, there will be no prejudice when you've taken the decision based on law and the facts. And I don't think this commission, I can't speak for the commission, but I don't think this commission will consider you in any bad light because you ruled against the JSC at that moment in time.
Yes.
And perhaps this is the only time that you've appeared before the JSC since 2012. So I'd just like your brief comment on that.
Yes, Mr. Singh, thank you. If what I recorded there suggested any sort of malicious possible approach by this commission to punish me for having decided a particular matter against it in 2012, then I've overstated it, and I apologize. That is certainly not the intention. What happened after that judgment was delivered was that the then spokesman or spokespersons of the JSC were critical, very critical. Perhaps that's putting it too strongly too. Were critical of my judgment. Sorry, when I say my judgment, I wrote it, but it was concurred in by a fellow judge, who's in fact now on the Supreme Court of Appeal. I didn't take that personally. I welcome situations where others might disagree with my judgment, and I readily accepted when the application for leave to appeal was argued before me. I granted the application for leave to appeal without reservation to the Supreme Court of Appeal. All I sought to convey was some judges might, I'm not saying will, when dealing with a sensitive case like that, possibly have an eye on the future. I've always wanted to be a judge. I was hoping to advance my career as a judge. If it should ever have transpired, unfortunately it hasn't, that it would be said of me that I have previously found against this commission with costs, and therefore I would not be fit to be promoted, and I must remain a puny judge. Well, then so be it. Unfortunately, I would be very disappointed, but and that's all I sought to convey. I was prepared to speak out without fear, favor, or prejudice. If it means I remain a puny judge for the rest of my life, I've been true to my oath of office, and I can sleep well at night. That's all I was seeking to convey.
Thank you, Judge, and I think that's something we respect as commissioners.
Thank you.
Your judgment.
Thank you.
Thank you, Chief Justice.
Thank you, Honorable Singh. Judge Kun, I'm last. As you are aware, I caused documentation to be circulated to you so that I can put one or two questions to you.
Yes.
I'll summarize what I have to put to you in a form of a statement to avoid a long discussion and afford you the opportunity to comment. During the course of 2016, after a meeting of the heads of the three arms of the state, it became necessary that every arm embarks on cost-cutting measures. And part of the documentation that you are furnished with encapsulates measures that the heads of courts, after discussion with the different courts, in other words, after discussion with judges in their divisions, including with the magistracy in certain respects, came up with as a contribution towards ensuring that the courts with the limited resources at their command are able to get core business attended to. Now, thereafter, there were comments from different divisions, and the KwaZulu-Natal division is one of those divisions. When I became aware that there were concerns and there was some media inquiries, I caused a statement to be published on the 1st of September 2016, having already undertaken to meet the judges of KZN division the next day. I got there. I had never seen a judge president as terrified as Judge President Japie was. I had never seen Deputy Judge President Madondo as terrified as I found him to be. He's a man I started Cause One with. I didn't understand until I had a meeting with you together with the officials from the administrative arm of the judiciary, the Office of the Chief Justice. Now, I want to focus only on you. There were three of you who spoke in a way that caused grave concern. But maybe just to highlight features of the cost-cutting measures. Our proposals, which were never intended to be binding on any judge, but as we indicated in the statement, it was a matter of an appeal to the conscience of a judge, an appeal to a judge's sense of responsibility towards his or her country, where, among others, let us move from an S-Class to an E-Class, E400. Let us move from a 7 Series BMW or the equivalent in price to, I think we said 540. Let us not travel with spouses, or if we do, let us not claim subsistence allowance for them. Let us not travel with our secretaries or PAs because they will have to have accommodation and meals paid for them, and they will also have to claim from the lean budget that we already have, and a number of other proposals that are in the documentation that are furnished to fellow commissioners as well. I focus only on you, although there were three of you who were leading. The JP didn't have a say, the DJP didn't have a say, or chose not to have a say. There were three of you, and you were one of the leading voices in that meeting, which I would characterize as one of the most unfortunate meetings judges should ever have. Now, your comments in particular, and I'm putting it at the lightest possible level, were the most discourteous comments I've ever heard a judge make to his own colleague. I left the meeting deeply concerned about how Judge President Japie will ever be able to run a division like that. Deeply concerned about how well, let me focus only on you. How you treat the advocates who appear before you. How you treat litigants and witnesses. How you treat members of the public, in other words. I was shocked. I said to myself, how did he become a judge? I remember leaving the meeting, one member of the executive of the Office of the Chief Justice, who is a white Afrikaner, said to me, Chief Justice, I'm ashamed to be a white man. I said to him, Kasi, you don't have to be ashamed. you'll come across discourteous people regardless of color. And in any event, the 3 judges who were leading in this most unprecedented way of communicating their concerns to another judge, 2 are white and another is not white. Another, I think, was either colored or Indian. So I didn't see it like him as a racial issue. But as I said, it's one of the worst experiences I ever thought judges were capable of in communicating with fellow judges. Now, I want your comment there, if any, because that's the experience I have, and I promise I'll do my best not to engage in any dialogue with you.
Yes, thank you, Chief Justice. This matter must be seen in its context with respect. What we had in KZN was that we were initially provided for a meeting which we had in April of 2016 with a document-headed resolution. That resolution, at the time that we received it prior to that meeting, was the first time that we had heard of anything like that. It was raised at our judges' meeting on the 16th of April 2016, if I remember the date correctly. And we were told that it was not yet a resolution, that was by the Judge President, but that we could make representations in respect thereof. And certain of my colleagues started compiling such representations. I was not involved in that process. At a subsequent stage, we received a circular number 15 of 2016. That circular then recorded that certain cost-cutting measures had already been put in place at a time when my colleagues thought that an opportunity was still being allowed for representations to be made. Anyhow, the circular was received and it became a hotly contested or hotly debated issue. The circular involved the application of, amongst others, Section 176(3) of the, or implicated, I should say, the provisions of Section 176(3) of the Constitution, which provides that a judge's salary and other benefits may not be reduced. Concern was expressed by colleagues about the scaled down motor vehicles that they would qualify for in the future. They also expressed concern about the accommodation rates, that's the subsistence and travel allowances, which were being reduced insofar as spouses were concerned. It was a matter of some concern because in KZN, we would travel to outlying circuits for periods of at times 5 to 6 weeks. And colleagues were expressing much concern that they would be gone for 5 to 6 weeks and would not be allowed to be accompanied by spouses or partners. In fact, one particular judge had an experience that when he was absent, his wife, who had remained at home, was confronted by home invaders, 4 home invaders, and fortunately, she wasn't too badly injured, but she had been confronted. And he had decided that she should accompany him, certainly, on future times when he was away. These issues didn't affect me directly. I was not in line to have a replacement vehicle in the foreseeable future. I had in fact received one prior or shortly prior to even the meeting that we had in KZN in April of 2016. I did not have a spouse, do not have a spouse. So when I travel, I didn't have the concerns that colleagues had. But this certainly became a highly debated issue at our morning teas that we have in the respective centers in both in Durban and in Pietermaritzburg. And my recollection is, it goes back 5 years, so please excuse me, but I have endeavored to read I have read the documents that you furnished to me, and I've also extracted various emails which I was able to retrieve, and I've also got a transcript of the meeting which you referred to, which you came to address us in KZN. Based on that, my recollection is that I was, I think, the senior judge after the judge president in Pietermaritzburg at that time. And I was asked to draft a memorandum to obtain clarification on what the position was regarding the judges no longer qualifying for the vehicles or the models as per the judge's handbook, but for those that are now suggested in the circular. During that time, I also became aware of a motivation that had been submitted by Judge President Wagley, in which it was made clear from that motivation that this would be a voluntary measure in the sense that if a particular judge did not want to accede to the request to take a cheaper vehicle, or then to not take his wife or spouse or partner with them on circuit, or any of the other cost-cutting measures that were suggested, then he didn't have to do so, or she didn't have to do so. I prepared a very short memo raising what I considered to be the misunderstanding that had arisen. And that is that the resolution of the heads of court suggesting the cost-cutting measures was not one that was violating the provisions of section 176(3) of the Constitution and reducing benefits of judges at all. However, there were provisions in the circular that dealt with the implementation of that circular. And amongst others, and I can quote, it said, this was the circular of the 27th of May, 2016. With immediate effect, all hotel bookings, rental vehicles, and travel arrangements for judges should be scaled down in accordance with these resolutions. Bookings confirmed prior to today's date should, however, not be amended. The Judicial Support Unit should note that all vehicles which are currently on order but not yet delivered and exceeding the amount of 900,000 Rand should be brought to the attention of the Chief Financial Officer. All vehicles for which only quotations have been obtained and no orders have been placed, a new quotation should be requested in line with the 900,000 threshold. Colleagues were seeing or viewing that as new immutable rules, which didn't give them the election to decide, notwithstanding the request for cost-cutting, to request compliance with what they were entitled to in terms of the judge's handbook. In fact, there were at least two colleagues. The one circulated an email dated the 17th of August, and if I may just place this in historical context, the resolution was the 27th of May. I beg your pardon, not the resolution. The circular was the 27th of May, 2016. This was before the meeting in September. On the 17th of August, this email that she circulated was one received from a Miss Claudine Schubart, Assistant Director, Judicial Support, and it read, "The current value for judges' motor vehicles is 900,000. you can email your request for a replacement to rmakwane@justice.gov.za. Another circular, well, I beg your pardon, not a circular, an email from one of my other colleagues, who in fact also spoke at that meeting, and I've checked it again last night against the transcript of that meeting. She said as follows: "Dear all, I requested a motor vehicle from as early as the beginning of this year, but till today, I'm still waiting. I was misled when Rosemary and company," that's Mrs. R. Makwane, "requested a motivation from me and my JP when the price of a motor vehicle I requested was over the 900,000 limit, only by 75,000 Rand. We motivated only to receive a curt response to the effect that if I liked the motor vehicle so much, I must pay the 75,000 Rand to G Fleet. I then submitted a quote for a 2-litre engine BMW X4 in June 2016 to Rosemary, etc., etc. I don't have to refer to the rest." These colleagues were all of the view that this wasn't just a request to save costs, but was in fact interpreted and was being implied as precluding them from ordering, using the example of the vehicle, a vehicle of more than 900,000 Rand. In other words, precluding them from insisting, if they were not disposed to acceding to the cost-cutting measures, to a vehicle that they would otherwise be entitled to in terms of the the judge's handbook and their conditions. It was in that environment that I was asked to write this little memo. I circulated it under cover of an email, which I have with me. And important, attached to that email was a document which I called KZN Business Plan, which was in fact a business plan which I had prepared, suggesting other methods of cost containment also in the province of KwaZulu-Natal. They included measures which were in fact subsequently implemented, dealing with reducing the amount of traveling that judges do between Pietermaritzburg and Durban, which have resulted in substantial cost savings because the S&T, subsistence and travel allowances, were being reduced. It also consisted of other things. But apart from this business plan which I circulated, I sent this little memo setting out that I believed that the circular which the Secretary General had prepared did not adequately or perhaps accurately record what had been decided by the heads of court. The invitation was that colleagues could add whatever reservations and concerns they had to this memorandum. And a number of colleagues responded. What was initially a short memo soon developed into a large document of many pages. I was not involved in that process, as further concerns and grounds of complaint, or whatever one would like to call it, were added to the memorandum, and in fact the wording was changed. The wording of what appears in the memorandum which you forwarded to me is not my wording. It's not the style in which I write. My contribution had been minimal, dealing initially with this question of the resolution and then the wording of the circular, which purported to record what the resolution was, possibly introducing ambiguity. I had no difficulty with the resolution of the heads of court, and I had no difficulty personally in accepting the cost-cutting measures. I had formulated the concerns that colleagues had, and that had been added to. That memorandum was eventually collated, not by me, but by another colleague, and it was sent by the Judge President to the Secretary General and the Chief Financial Officer. And if you had to ask me at the time, I would have expected, or I expected, that they were going to respond to clarify this issue. We were then told that you would be coming down to address the judges on the 2nd of September 2016. During that time, I also received, which I retrieved recently, after receiving your documents, the meetings of the heads of court of the 3rd of April 2016, which were held at the Protea Hotel in Midrand, vetted by Wagley JP. That minute, which now served as the true recordal of what was agreed, to my mind, in paragraph 5, recorded the actual resolutions of the heads of court. Paragraph 5.1.3 reflected the cost-cutting measures. It said the heads of court reflected extensively on the proposed cost containment measures and resolved that the measures be applied as follows. And then it deals with the spousal subsistence and traveling allowance, air transport, domestic accommodation, renting of vehicles, traveling with secretaries, use of assessors, motor vehicles for judges, acting judges, and the like. Paragraph 5.1.4 thereof then dealt with the issue of for how long these measures would apply. And it contained a paragraph, contained a sentence, which did not appear in the Circular 15 of 2016, but which reaffirmed or confirmed my interpretation of what I understood that resolution to be in the following terms, and I quote verbatim, quote, where judges do not want to participate in the cost containment measures, they should not be compelled to do it. To do so. It should be left to the individual judge's conscience on whether or not to support the measures, unquote. That gave me the comfort which I had always had, and the issue to me was purely that the circular, in not recording or referring to that paragraph, had caused confusion amongst colleagues. It was in that context that the meeting proceeded. I should just mention, please, that the press release of the 1st of September 2016, I was not aware of on the morning of the 2nd of September 2016. I think it was referred to at the meeting or shortly before the meeting that there was such a press release, but I only became aware of the contents thereof and at sight thereof after the meeting had already been concluded. As I say, the meeting proceeded. I have a transcript of that meeting, which comprises some 38 pages. I've read it, and the contents thereof is consistent with what I have just related to you. I do not want to quote extensively from it, but it's perhaps prudent that I do refer to the relevant parts thereof. I spoke second.
CJ.
Sorry, sir. May I tell you what my concern is?
Judge.
I'm not worried about you commenting. I'm worried about the discourtesy, and others may characterize the way you come across as extremely rude. That is the only issue I'm focusing on.
Okay, all right.
Not the merit or demerit.
Sorry.
I'm focusing. Is somebody speaking?
No.
My only focus is as colleagues, we've got to be courteous to one another, however concerned we are. As I said, I won't fault anybody who would say, characterize your communication with me, on which I wanted to afford you the opportunity to comment, as extremely rude, completely unbefitting of a judge. Not the merits or demerits, no. But before you comment, just 2 paragraphs from the statement that judges at that meeting already know. The public statement that you say you were not aware of, they raised it at the meeting. Let me just read it, the last paragraphs. These measures are to be departed from only when circumstances so demand. Colleagues were made to appreciate that this is the sacrifice we all have to make for the good of the country, particularly because budgets, including ours, are being cut from time to time. This is a survival strategy. The reversal of these measures is anticipated as soon as our economy recovers from the battering it has hitherto been exposed to. This is a difficult period for our country. The sacrifice judicial officers are willing to make for the good of the judiciary and our country is highly appreciated by the collective leadership and membership of the judiciary. We did this alive to the reality that the conditions of employment and benefits of judicial officers are constitutionally protected. If any judicial officer insists on his or her rights regardless, we will not stand in the way. It is primarily a matter of conscience and one's sense of responsibility. So I don't have a problem with you being opposed to the measures. I'm focusing on collegiality, treating people with respect. That's why I said even litigants, even practitioners are hearing from you. I left concern. What kind? That is the only issue, not the merits.
Yes, sorry.
Chief Justice, Julius.
Yes, sir.
I think we have agreed on what is going to be the approach. We still have 6 candidates to go.
Yes.
And we have canvassed a lot of time with this candidate. So I will request that you find a way of concluding, because we are all done with him except you.
Yes. No, that is true. That is my last question. Just a comment on whether you were your language, your communication bordered on rudeness or not. That's all. As briefly as you can.
Yes. I shall try, Chief Justice. I've read the minutes again last night. I respectfully submit that the contents thereof, the relevant part thereof, which I could read out, but which in the interest of brevity now, perhaps I should just paraphrase or shorten, were not intended to be rude, was not intended to be discourteous. Perception is, however, more important, and I hear what you've said about your concerns. Certainly, my intention was never to be discourteous or, as you've categorized it, rude. If it was construed as such, then I am very saddened by that fact, and I apologize unreservedly. I stood nothing to gain by this, with respect. The vehicles, the spouses, didn't involve me. I have proactively, since that time, and even before, not used assessors. I have not claimed traveling and subsistence. I have no spousal subsistence in traveling that I've claimed. Air transport, accommodation, I haven't used. When I go on circuit, I commute. I don't want to labor the point because that deals with what I did about cost cutting.
Yes.
But
yes.
The actual wording on pages 14 and 15 of the transcript of that meeting, I introduced myself. I said I was responsible for part of the drafting of the memorandum. And I said, I certainly interpreted the resolution.
Chief Justice.
I beg your pardon.
Chief Justice, no. I think the point, through you, Chief
yes,
Justice.
I think you've addressed the issue.
You have addressed the issue, you have even apologized. So everything else is not necessary.
Thank you. I hope the apology is accepted, Chief Justice.
No, it is accepted, sir. Thank you very much. Thank you. You are excused, Judge Kuhn.
Thank you. Thank you, Chief Justice, and thank you, Commissioners.
November 2005.
So you've been a judge for what? Is it 16 years, more or less?
Yeah, about 16 years, Chief Justice.
And for how long did you act at the Constitutional Court?
It was for 2 terms from January to June 2019.
For how many years have you been Deputy Judge President?
It's since 2013, it's about 7 years or so.
For how many terms did you act in the Supreme Court of Appeal?
It's almost 1.5 years, since last year, February.
Yes. As briefly as you can, please tell us how ready you are for the Supreme Court of Appeal.
Having been in the Supreme Court of Appeal for that period, even though I've spent about 6 weeks in the courtroom, the cases that I dealt with, the interaction that I had with my colleagues there, also taking into account the experience that I had in the Constitutional Court, I think I'm ready to make a contribution in the Supreme Court of Appeal.
Before I hand over to the President, let me just find out from colleagues, commissioners, who of you would like to put questions to the DJP. You have his CV. There was no need for me to go through much of who he is and what he has done. Who would want to put questions to the DJP?
Matonsela.
Lamola.
Breitenbach, please, Chief Justice.
Schlemmer.
And Dodovu.
Sigobo.
And Mpofu.
JP Mlambo.
Malema.
Thank you. President, over to you.
Thank you, Chief Justice. Good afternoon, DJP.
Good afternoon, President.
How are you?
I'm good.
Good. A greater portion of your acting stint has coincided with the COVID lockdown, unfortunately. Did that impede you in carrying out your work in any way, other than the inconvenience of being away from the actual building?
Not necessarily, President. I received the records on time. It gave me ample opportunity to do the preparations.
DJP, would you just bring your mic closer to you? I'm just struggling a little bit hearing you. Maybe your voice is soft, but I'm hard with hearing.
As I was saying, the impediment was minimal because I did get the records on time to do the preparations. And also the hearings, except some few hitches here and there, they went very smooth, President.
In your time with us, have you had an opportunity to write judgments, and how many have you been allocated and actually delivered?
Yes, I've written some judgments. I think in the first term, I wrote 2 judgments. And yeah, each time I wrote about 2 judgments when I was in the SCA.
How would you describe judgment writing at the court? Is it an individual effort or a collective exercise?
Judgment writing in the SCA, it's a collective, also it's an individual effort, because after the hearing, we have a conference where you get the views of the colleagues about the matter. And as a scribe, you'll also give them your view. And thereafter, the senior judge will wait for your draft. And there are some senior judges who would prefer that you send the draft to them before you send it to other colleagues. And there are others who would prefer that you just circulate it to all the judges who are on the bench.
I'm going to ask you a few uncomfortable questions. I'll be failing in my duty if I didn't do that. But I just want to preface this with this declaration that you and I have sat together in a few matters, and we have worked well together. But I have received some complaints from other colleagues with whom you sat. Now, first, there's a presiding judge. Well, I discussed this with you. I'm not ambushing you. We've talked about them. There's a presiding colleague who reported to me that he allocated you a judgment last year. It's in the matter of Central Development Chwane against the body corporate something. I say it deals with sectional titles. Now, he says you produced your draft late. You were supposed to produce it sometime in July. It came on the 31st of August. And the draft that he was finished with was just, it needed a lot of reworking, such that you ended up delivering a joint judgment. You because you put in so much effort into it, it came out in both your names. Then the other issue he raised was that he just did not have any luck with you. You had petitions together, and just as you know, when the way we deal with petitions is that the junior colleague will read the papers and call the senior colleague to find out if he or she is ready to discuss the matter, and then they can fix the time to discuss it. Now, he says he just struggled to get hold of you. You were totally inaccessible by phone, did not respond to emails. But then ultimately, you called back, and I believe you dealt with the matter. But he expressed his dissatisfaction with that. And indeed, if that is so, it is not acceptable, because you know you've been there for a while. You are supposed, even during recess, because we work well in Bloemfontein only 5 months of the year, and the rest of the year, 7 months, we work from home, but you remain available. You have, your phone must be in your pocket at all times in case a colleague wants to reach you. Perhaps let me just stop there for now and give you an opportunity to respond to these charges.
President, I'm surprised to hear that there's a complaint relating to petitions. After receiving the appointment from the minister, I did contact a few colleagues to check with them as to how does the SCA operate. And even in the High Court, it's a practice that petitions should be dealt with as soon as possible. I remember in December, I think one of my first petitions, it could have been delayed by a day, because I would phone the senior judges to indicate to them that I've read the documents and I'm ready. So this delay, I can vouch to you, President, that I have not had a petition for more than, let's say, 3 days or 4 days without contacting the senior judge in the matter.
Mm.
So I'm surprised to hear that there are colleagues who are complaining that they don't get me on when they phone me regarding petitions. And on petitions, I don't recall getting a phone from a senior judge asking me about it. I made sure that I'm ready. Should it happen that maybe after 2 days I'm not ready, I would phone that colleague to say that maybe I've got other things that I'm busy with, and I would contact him the following day. So on this issue of petitions, I'm really surprised to hear that there's a complaint.
Right. And about the delayed judgment?
This judgment, I looked at it. Actually, you mentioned that this colleague said that I delayed with the judgment. The judgment was set down for the 4th of September, if I'm not mistaken. But the parties...
No. Oh, yes.
Yes.
Carry on, please.
So we had a conference before the date. I think we could have had a conference about a month earlier, and we discussed the matter. The issue was very crisp in the judgment. I noted the judgment, and I sent this judgment to the senior colleague to look at it, to comment. And his comment the following day was that I did not deal with certain issues that he incorporated in the judgment. I compared the two judgments and incorporated what he suggested. And I may also mention that maybe this is what I need to put forward. My judgment was about, I think it's about 10 pages, and the colleague incorporated a background in respect of a certain section and rephrased some of the things, but basically the order, everything was okay. I think it's a question that the way he presented his judgment was what is called a scholarly judgment. But since the issue was very crisp, I mentioned exactly what the issue is, I summarized, and I gave reasons why should we arrive at such an order.
All right. Then there is another matter. It concerns a judgment of yours that was recently overturned by the STA, and there you presided in a full court matter that involved the business rescue practitioners in respect of certain Gupta companies and certain Mrs. Gupta. It is the case of Nuop and Global versus Chitali Gupta, you remember it. Now, a simple matter on the surface concerned the suspension of the operation of an order pending an urgent appeal. And you gave an order that reversed the automatic suspension of an order and granted leave to execute pending the appeal. This in breach of the explicit terms of Section 18.4 of the Superior Courts Act. Now, the judgment of the SCA overturning your judgment points out that this order had not been asked for, and the other side, the business rescue practitioners, were not even given a hearing, and you relied on one of the earlier judgments, dealing with this statutory provisions, the Clemesa judgment, which is actually an authority against the order that you gave. And so in the result, what happened is that you overrode the relevant statutory provisions governing the issue by exercising the court's inherent power to regulate this process, because that's what your judgment says, that the court had the power to do, to grant such an order. Now, would you like to comment on this judgment, and if you think the judgment of the SCA is right, just explain how three, seasoned lawyers got it so wrong.
President, in this matter, as you have indicated, three judges were sitting in the matter, and a colleague of mine wrote the judgment. We discussed the matter and we agreed. It was a matter involving mainly removal of the business practitioners. And we gave reasons in the matter why did we think that such business practitioners should be removed. I think one of the reasons that we said is that the business practitioners were also officers of the court and they should act in good faith. We applied our mind, and the decision that we arrived at, we thought it was a right decision. But if the higher court is of the view that we made a mistake in granting an order, because I think when we said the execution should proceed, it was after the registrar of the companies appointed new business practitioners in the matter. But I looked at the SCA judgment and I looked at our judgment, and since the higher court was of the view that we were wrong, and I accept that. But it's not a question that the three judges, we decided to sit there and say that we're not going to make a ruling that is in accordance with the Act.
Well, I won't belabor the point. The judgments are there for all to read for themselves, and you've given your answer. Now, lastly, I'm not sure about the appropriateness of my next question, and you don't have to answer it. But I'm going to put it out there anyway, because I've been directly confronted about inviting judges who have dark clouds hanging over their head to act at the SCA. Now, this is about these allegations that have been, doing the rounds on social media and elsewhere for a while now, about the so-called CR17 records that you allegedly improperly ordered to be sealed. Would you like to comment on this? In fact, let me just ask you a straight question. Are you a corrupt judge, as some have painted you?
No, President. Regarding this matter, I think I just need to explain. As a deputy judge president of the court, there are special motions that I manage. And special motions are cases wherein you find that they are urgent, they need to be given preference because the urgent court cannot handle them. In terms of our directives, we state that if the hearing is going to last for more than 4 hours, the matter should be referred to my office so that I can manage it, make sure that the matter is ready to proceed. If there are interlocutory applications, I should give directions as to how those interlocutory applications should be dealt with. For example, you find that you've got a special motion wherein there's an application to strike out certain portions of the founding affidavits. The parties would argue about whether should the application to strike out certain matters be dealt with first, or whether those issues should be dealt with together. I'll have to look at the documents and make a ruling on that. Now, on this matter involving the CR17, the so-called CR17 matter, I called all the parties for a meeting, and there was an issue as to whether that envelope should be available, the contents thereof should be available to the public or not. And I was also told that some of the information in the envelope involves third parties. This was not a court, it was just a meeting in my office. So I ruled that since there's an issue and interest of third parties are involved, I did not even see the contents of that envelope because it was sealed by then. I ruled that if any party is of the view that it should be available to the public, I'm willing to manage the matter and to allocate a date of hearing to the parties so that the matter can be argued in court. And that is a step that the parties took, and the matter has been before the court. I think judgment has now been reserved as to whether the contents should be made available to the public or not. So I failed to understand why there were rumors that I did not make an order that the contents of the envelope should be made available to the parties is because I was protecting my colleagues or I was protecting the president.
And that's the extent of your involvement in that matter.
Yeah, that was the extent of my involvement, President.
Thank you very much, JP.
Maybe a follow-up.
Yeah, just one last question. Did you have any reserved judgments at the SCA?
Yes,
I've
got reserved judgments.
From other terms, not this term.
No, from other terms, I don't have any reserved judgment.
All right. Okay. Thank you very much. Thank you, Chief Justice.
Thank you, President. Honorable Malema.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
What is the procedure? The procedure is such that a person can write a letter to you to seal documents without any court hearing, and you seal them, and you want to open them through a court hearing when you have not sealed them through a court hearing. Because in this instance, there was just a letter where there was an indication that they said sensitive information, third parties involved, and you sealed it. And then for you to open them, we had to go to court. But for those who wanted you to close them, they didn't go to court. Like you just said now, it was a discussion in the office, and then the documents were closed. So I want to understand, what is the procedure? Do you, for documents that are submitted to a public court, for them to be sealed, are you not supposed to make an application for such documents to be sealed, so that when now there's a counter to that, it can also be made in a public court to argue why those documents should not be sealed?
Commissioner Malema, this matter, there was an issue as to whether the documents should remain sealed or not. The issue was not that the contents of the documents are available to the public, I should seal them. I called the parties and to understand as to exactly what the issue is. And the issue was that those documents should remain sealed. And I told the parties that since the documents are sealed, there's an issue relating to the documents. I'll facilitate that this matter should go to court so that the court can make a ruling. It was a management meeting before me. It was not a court order that I made. It was just a direction that I gave that this is how the matter should proceed so that the court can hear the matter to get the version of all the parties. The allegation that there were interests of other parties who were involved, those parties were not before me, so that they could also get an opportunity to put their version before the court.
Thank you, CJ.
Thank you, Honorable Malema. Commissioner Madonsela.
Thank you. Thank you, Chief Justice. Good afternoon, Justice Ludova.
Good afternoon, Commissioner.
Yeah, when I received your application, which was two-pronged, in the sense that you applied for a position in the Constitutional Court as well as in the Supreme Court of Appeals, I got the distinct impression that all that you wanted was to leave Gauteng and go anywhere, either to the Constitutional Court or to either to go to the Constitutional Court or to Bloemfontein, to SA. Either to go to Bloemfontein or to Bloemfontein, but out of Johannesburg, out of your current position. Am I right about that impression? And I don't want to prejudice you when I would consider that, and I take that view without giving you an opportunity to comment on it. Can you?
Yes. No, that was not my intention. The positions were advertised, and I was nominated that I should apply for the two positions. I need to make it clear that I've been in the High Court for almost 7 years. I've had a good working relationship with my JP, with the colleagues there, and I'm happy that I'm a judge. And even if I'm not recommended, maybe to the SEA, since I've withdrawn the other one, I'm looking forward to continue with the work that I did in Pretoria. So it was not a question that I just want to leave Pretoria. I've been working here and I've enjoyed my stay, or I'm enjoying my stay in Pretoria, because even now, when there are issues like the drafting of the directives, the JP still sends some information to me, and we do discuss issues involving the division.
Thank you, Chief Justice.
Thank you very much, SC. Honorable Singh.
Thank you very much, Chief Justice. I just get a feeling this is going to be a long interview, but so I'm going to be brief. I just want to follow. Good afternoon, Judge. I just want to follow on Commissioner Madonsela. You know, when JP Molamela was interviewed here in 2018, I asked this question about hierarchies and her movement from being JP to the SCA. And she gave us an explanation, and she was interviewed yesterday for another position. I'm trying to understand that if you've been the DJP from 2013, the next logical step in my own small mind would be to go for a position of JP, because that's where you've carved your niche. Now, I just like some explanation of why you want to apply for this position, or why you've applied for this position to the SCA. If it was for the Concord only, which you didn't withdraw, one would understand. But why the SCA? If you can just give us some explanation of that. Thank you. So I could understand better your thinking.
Well, after acting in the Constitutional Court and in the SCA, I thought it was an opportunity to apply to one of those courts and hear the appeals, write the judgments, because about 60% to 70% of the work that I was doing in the High Court was doing roll call, managing. And fortunately, I made an arrangement with my JP that we should also ensure that we also sit in court just to sharpen our skills of hearing arguments and writing judgments. But on your question, you said the logical thing to do for me was to be the JP, was to look forward to being the JP of the division. This issue of who could be the next JP of the division, it's something that I discussed with my JP before. And I must state that I'm not in that court for positions, if I need to put it very clear. And I can just disclose before this body that the other issue that I had in mind was that if I'm the JP of the division, it would be better if a JP could be somebody who could take those reins for a longer period. Because when we did the calculations, I think JP Mlambo would still be there unless maybe he changes his mind and goes somewhere for another 3 to 4 years. And by then I would be about 63 or so. And if he leaves, I'm appointed as a JP, it may be for a very short period. So we discussed this aspect, but we did not finalize it. So it's something that is hanging, but when this opportunity arose, after the nomination and after discussing it with various colleagues, the family, I opted to accept the nomination. I hope I've answered your question.
Yes.
If not, you can.
No, I'll have to accept your reasoning, because it's your thinking and your reasoning. Thank you very much, Chief Justice.
Thank you, Honorable Singh. Honorable Minister.
Thank you, Chief Justice. I just want to follow up on this one that President Maya asked you on, the case of the Gupta and the Nop and others. As she did allude to the fact that it seems a basic issue of the law. And what I am also observing from it, it also make a very kind of a dangerous remark or adverse remark against you with regards to the fact that it says that the judgment did not even deal with the evidence and whether it was sufficient to discharge the honors resting on Ms. Gupta. Instead, it contains a number of general statements and adverse findings concerning the BRPs without reference to the evidence. Do you have anything to say about this kind of a paragraph?
Honorable Minister, in my view, there are reasons why we arrived at the decision, and the allegation that we did not deal with the facts, we did not give reasons, I fail to understand, because there are reasons. We gave reasons why we arrived at our decision. However, the higher court was not satisfied with the reasons that are in our judgment.
These allegations in the public domain about, in particular, the North Gauteng High Court, that seemingly there's some conspiracy or corruption, whatever kind of a thing that from time to time pop up about the North Gauteng High Court. How does it make you as a DJP or a judge of that court feel, and how do you deal with it?
Well, Minister, these are just allegations. And some of these allegations, in my view, they contradict themselves, because there would be an allegation that the judges in the division are paid to make certain rulings. But when you look at the rulings that are made by that court, some of the rulings are against the government or were against the government. So if indeed judges in the divisions were bribed, all the rulings would have been, or all the orders would have been in favor of the government. So these are just mere allegations that some of the judges received X amount of monies, and while there's no proof. The Chief Justice indicated that if there are complaints, let those complainants file complaints so that these matters can be properly investigated.
So on, with your indulgence, CJ, this is my last follow-up on the same issue.
Please go ahead, Minister.
So failure to have this evidence or issues being processed as a proper complaint, what impact does it have on the rule of law or your job as a DJP or as a judge of the court?
Well, to some members of the public, it has got a negative impact. And in my view, some of the issues that are raised in the media, we've got a representative in the Office of the Chief Justice, and I think it's important that those allegations should be contested and let the public know that these are mere allegations and there's nothing supporting those negative allegations.
Thank you, CJ.
Thank you, Minister. Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Deputy Judge President. How are you?
Good afternoon, Commissioner. I'm well.
Good. I have one question, Judge Dwaba. There is a marked difference in the success of the use of case lines in the Gauteng High Court on the one hand and in the Gauteng North High Court on the other. Could you just briefly tell us what the reasons for this are? Thank you.
Commissioner, I haven't experienced the success of case lines because when the JP introduced them was at the moment when I started in the Constitutional Court, and thereafter I went to the SCA. However, I have had a lot of colleagues and some practitioners saying that they are happy with case line and they think this is something that should continue. But personally, I haven't experienced it.
Thank you very much.
Prof.
I'm covered, CJ.
Thank you, Prof. Honorable Dodovu.
Thank you, CJ. Afternoon, Justice.
Good afternoon, Commissioner Dodovu.
I'm aware that you also serve as the chairperson of the Magistrate Commission.
Yes.
And then last year, you convened all the commissioners, and in my view, propelled by a burning desire to solve two sticky problems. The one problem is training, to ensure that magistrates are trained, but secondly, to investigate matters of misconduct and all of that pertaining to the magistrates. That is good, but I just want you to share with us what is the extent and the magnitude of the problem of this ill discipline where in your areas of operation in the High Court, when you compare that with what is happening at the level of the magistrate courts. Thanks.
Thank you, Commissioner Dodovu. In the Magistrates Court, considering the number of magistrates that we've got, it's serious. Even last week, I received a complaint that the orders that were made by the magistrates, especially in respect of maintenance orders, were vague, were not clear, and were causing some confusion. And that to me also confirmed that there's a serious need for training to the magistrates. And there were some matters which have been outstanding for a long time involving magistrates. We've taken a conscious decision as a commission that we need to pursue these matters, and some of the serious matters at the moment, the charge sheet have been, I've signed the charge sheets, and the matters would be finalized soon. But there needs to be very serious interventions as far as the conducts of some of the magistrates are concerned, because they taint the whole judiciary if these matters are not attended to and are fixed, because most of the cases are heard in the magistrates court. So there's a serious need that the magistrates court need to be fixed.
All right, thank you very much. Thank you, CJ. Just between the two of us, I like how you are cool and measured. Thanks.
Thanks for the compliment, Commissioner Dodovu.
Commissioner Sigogo.
Thank you, JP. CJ. other issue which I wanted to raise with you has been covered by other commissioners at DJP. Good afternoon.
Good afternoon, Commissioner Stigogo.
I've seen the comments by the law bodies, and I believe you've seen them. Almost, in fact, all of them have recommended that this commission should consider you appointable. Did you see that?
Yes, I was humbled by the comments of different bodies that they recommend that I be appointed.
Thank you. Thank you, CJ.
Thank you.
Thank you, Commissioner Sigogo. Advocate Mpofu.
Thank you, Chief Justice. Good afternoon or evening, DJP.
Good afternoon, Commissioner Mpofu.
Thank you. I wanted just to touch on two things. First, it had to do with your work in Nadell, but I think that's partly covered by Commissioner Sigogo's question. The issue that I really want to raise is one that I raised with an earlier candidate, but which I want to raise obviously with more force in your case because it's you are a permanent DJP, and it was that I know that you're a person who's quite aware of the developments of transforming the judiciary at a broader level and so on. Now, if we have somebody like you who has developed expertise as a DJP, and if I can say so, I can say, I think without any fear of contradiction, that you and JP Mlambo are probably the most accessible and helpful leaders of the court, given the importance of the cases that end up in your court. Actually, I have more interactions with the Pretoria court than the Joburg court, even though I'm a Joburg practitioner, for that reason. Now, it's not easy to acquire those administrative skills of running a court of that magnitude. And wouldn't it be better if your skills were deployed, maybe not necessarily as a JP, even here, maybe even in another place, but rather than a person who has acquired those skills for almost 10 years at that level, the cold face of a busy division. As I was saying to that other candidate, going to become one of the most junior judges in Pretoria, in Bloemfontein, isn't that a loss to the capacity that we're trying to bring? And I mean, of course, there are personal considerations and development, and you've answered that part. But if you look at the broader picture, is it fair in the context of the capacity building and transformation that we're trying to build, to lose somebody of that caliber who just to go and write judgments? Not that writing judgments is not important, and maybe the administration of this court, I'm not saying it's going to collapse. Obviously, there'll be other people, but at least there'll be that gap. Did that consideration play any part in your mind when you were weighing these things, apart from the I don't want to say selfish, because that's probably putting it wrongly, but the individual considerations which we all make, obviously. You get the sense of my question?
Yes, I do, Commissioner.
Yes. Can you satisfy me that is at least one of the considerations that you made, and then you decided one way or the other, and why?
I still remember when I was appointed as a DJP of the division. Many people, many practitioners said, but are you going to suit to fit are you going to suit the shoes of the former DJP van der Merwe? They had some doubts. And I did my best because I believe that I'm here to serve my country. I've been away from the division for almost 2 years now. And I believe that there are competent colleagues who can take over if I am appointed. I haven't received any serious complaints that no comeback, things are not running well. I've got a JP who is hands-on, and he always makes it a point that he appoints competent people to be acting DJPs. And I believe that there are other colleagues who can do the job, and they may even do it better than me. But I did consider this aspect, and I felt that I shouldn't regard myself as a know-it-all, that the division will not be able to run with me. And I'm still of the view that if I'm appointed to the SCA, the experience that I've got, I may make a contribution to the court that I'll be going to.
Thank you. Then there's the issue of the issue that you mentioned, which was raised by President Maya. I'm sorry, maybe I'm not sure if I was. Maybe it's my fault. I was not listening properly. Did I understand that you accept that generally, in terms of case management, because I think you said that decision was made in the context of case management. When there are interlocutory issues that arise, generally those are referred to the court to be dealt with by the judge who was seized with the case management. But that in this particular case, there were exceptional. There was some exceptional circumstance. Can you just explain?
I don't quite understand the question.
Okay. When you were asked about the question of the sealing of the documents,
yes,
you gave an explanation as to what happened. Between you and me, as a practitioner, I got that what you are saying is that you were case managing that case at a particular time, meeting with the usual things that you and I have done in other cases. You're case managing, even though it was not yet allocated to whoever ended up with it. Am I right?
Yes.
Yes. Now, I'm saying, is it correct that in the context of case management, actually there are rules of case management or directions or guidelines? The normal thing to do is if an interlocutory issue arises, let's say one party wants a postponement, the other one or something, that interlocutory issue is normally then referred to court as an interlocutory issue in front of the judge who is case managing the case. Am I right?
It depends on the nature of the interlocutory application. There are other applications that are part of the main application. When I sit with the parties, I would explain to the parties why do I think that these matters should be heard together, considering that the cost that would be involved if I just send one issue to be dealt with by the court. I'd consider whether would it be convenient and for the interest of all the parties that those interlocutory applications be dealt with together with the main application. So it would depend on the circumstances and the facts of each case, which I discuss with the parties. And in most instances, you find that we reach an agreement and which would be reduced or would be incorporated in the directive that I would issue, that these matters would be held together. Maybe another aspect of the case would be held over until another important issue shall have been dealt with.
Yes, thanks. So in other words, okay, and I agree with that. It depends on the nature of the issue. If it's a small, frivolous issue, maybe the parties can't agree on a date of exchange of heads of argument. The judge can actually give a direction and say,
yes,
yeah,
definitely.
But
yes.
if it's a more serious issue, it can be referred to court.
Yes.
That's what you mean by it depends on the nature of the
Yeah,
issue.
if it's a more serious issue that needs the attention of the court, and maybe it's an issue that I realize that the public have got an interest in it, I refer it to the court so that there could be full arguments and the court can be able to make a ruling on it or an
Yes.
order.
Thank you. Thank you, Chief Justice.
Thank you so much. JP?
Thank you, Chief Justice. The Acting Justice Lidwaba, good afternoon.
Good afternoon, JP.
I'm happy you still recognize me as your JP. I just want to deal with two major issues that arose in your interview. The first one is the issue that the president of the SA raised with you about a colleague not being happy, no, about the judgment that was reversed. You've given your answer. But am I correct that you've said in many cases? You've said in many cases, and what's your view that if you slip up in one case, then that should destroy you completely?
JP, actually, I'm surprised that this aspect of this case where I was overruled was raised by a colleague in Bloemfontein, and I was also shocked to hear that there's an allegation that I delay in respect of petitions. But the record speaks for itself. There are comments by other bodies. And as you have rightly said, there are cases that I've dealt with. They went to the SCA. Some of them went to the Concord. And it is for this body to look at the record and evaluate and determine whether would I be a suitable candidate to be recommended for appointment in the SCA.
Yeah. Thanks, DJP. The next issue is these allegations that are flying around. I'm not on social media, but I was shown a poster a week or two ago which showed my face in a poster that said judicial capture or something like that. Haven't we had a discussion, me and you, because these cases come to Pretoria? Haven't we had a discussion about whether we should avoid sitting in these cases?
We did have a discussion, JP.
And we resolved that we'll be shirking our responsibilities if we should avoid sitting in these cases. Am I correct?
You are correct.
Thank you.
As leaders, we discussed that there are certain matters where we need to be part thereof, not to monopolize them, because there are other matters, important matters, that we would discuss and would be allocated to other judges, because there was also a perception that we want to be in the limelight by being in this case. But I think it's our responsibility that these matters, there are matters that deserve to be dealt with by the leadership, especially matters involving the president or senior members of political groups. And this has been happening. It's not something that we've started. Yeah. The JPs previously would sit in matters in which the public has got an interest, or even matters that involved presidents of the countries.
And in fact, I would imagine you're the only JP who allocates work to you. You're only DJP who allocates work to your JP. And it involves those matters. Am I correct?
And I'm glad that you comply.
On a more serious note, it is because of these allegations that we developed this principle of establishing full courts to hear these matters at first instance, so that you just don't put one judge to deal with these difficult matters. You establish a full court where you have 3 minds dealing with these things. It's better, isn't it?
That's correct, JP.
Right. The last issue, CJ, please indulge me. Is it also not correct? I'm just dealing with these issues to say, are you running away from Gauteng or whatever? That when you went to act in the Concord and then you went to act in the SCA, when President Maya approached me to extend your acting stint, I called you for a meeting. And it was not an easy meeting. You remember?
I still remember, JP.
Because I wanted to find out what's happening. I was expecting you back, isn't it?
That's correct.
And you expressed your interest very firmly that you've now rekindled your interest in writing and developing jurisprudence. Hence, you've accepted, and if there are posts advertised, you're going to apply.
Yes.
Thank you, CJ.
Thank you, JP.
Thank you, JP. Honorable Malema.
Thank you, CJ and DJP. The Constitutional Court had some strong remarks to make against the Northern High Court about the language that you use against the PP and the personal cost orders, like it has become fashionable, that if a PP's matter appears before your court, there will be some strong language used, including personal costs. Have you attended to that?
Commissioner Malema, in our meetings, we always emphasize that we need to be careful about the language that is used in our judgments. But you can do that up to a certain level, because when the judge sits there, he or she will make his or her decision as to how should the judgment be written. And also regarding the personal cost orders, if I remember well, the Constitutional Court confirmed the personal cost order that was made. The majority of the judges there confirmed the personal cost order that was made, or a punitive cost order that was made, because there were reasons why such a cost order was made, and the higher court can only interfere if there was a serious misdirection in respect of such an order.
Now, the second point, I'm struggling because I don't know those things of how you guys come to decisions of sealing documents. So you went to the office there, you have a meeting, and then you agree there, you seal documents. And the way you sealed them have actually contributed to this big problem we have, where now you have allowed the rumors to be spread and senior judges are being implicated and senior members of society and all of that. Don't you think it could have been handled differently to a point where it will not suggest that there was something that was hidden by sealing those documents? Because as we speak now, anyone who wants to discredit anyone just throws a name that this one is in the CR17 documents, because it was not argued in a proper public order. I mean, in a public court. I mean, there is an issue now at the Zondo Commission. Malusi Gigaba wants the evidence of his ex-wife to be heard in private or not to be heard at all. He's being called to come and argue that publicly as to why that evidence should not be heard publicly or should not be heard at all. That's what we expect the court to do. That when there is someone of the parties who says, no, you can't listen to this part, it must be heard publicly so that there is no impression created that something is being hidden from us. And if that was held in a public court, we wouldn't be where we are, because I think that you should accept that, in my opinion, it was not properly handled.
Commissioner Malam, let me put this into proper perspective. I didn't call the parties and say, I'm going to seal these documents. The legal representatives wrote to me and said, we want to have a meeting with you on this issue. That we want the contents to be available to the parties. They couldn't agree. And since they could not agree, I said, this is the issue that needs to be dealt with by the court. But in the meantime, let the envelope remain as it is. It was not a question that on my own, I invited the parties to come to me and I made a ruling. The parties wanted me to manage this issue. And the best way that I could do it was to say that there's still an issue here, let it be resolved by a court. I hope it's
No, I gave wishes. No, the last point, DJP.
We as judges, we don't go out and invite.
No, I agree with that one. I agree with that one. You didn't invite those documents. But my worry is, and which is something we'll argue with colleagues, they will educate us. My worry is, we cannot seal such documents of high-profile matter through a letter. And even the second phase of the court, DJP, there was not going to be a court if we had not intervened. The matter was heard, those issues were, there was no separate process to go and make an application for the documents to be unsealed. If we didn't come in as the EFF and make a fresh application for those documents to be unsealed, which were not party to when they were sealed, then it means those things would have remained sealed because there was no resolution that said, okay, let's proceed with this part. Then there's going to be part B where the argument is going to be led on unsealing of documents. So those things were sealed. And if the third party had not intervened, they would have remained sealed. They remain sealed as we speak now. They are before the court because a third party came and said, these things must be unsealed. So if we had not come in, they would have remained sealed because there was no outlined process of what's going to happen after sealing them. But it's a debate we'll have, and which I don't think it will cause any harm because anyway, the matter is before court now and we're awaiting.
And the order may go either way.
Absolutely.
Yes,
the last point is on the succession. If you had because I'm jealous of losing you to a higher court. Look, it is in our nature and even where we come from to be humble as you are, that no, the court can run without me, it has been running without me, and all those type of things. The reality of the situation is that since you left there, it's no longer the same. Especially the one who acted after you. It's no longer the same. The attitude and how people get to be treated there since you left is not the same. So that warmth, that type of cooperation, it's no longer there. We litigate in that court, you will know, half the time, because that's the seat of the administration of our government. So, and ordinarily, if such a discussion took place between you and JP, and there was that type of brotherhood, perhaps we should have, you should have persuaded JP to be the one that comes here, so that there is a proper succession. Because when you got appointed, at the back of our mind, since I joined this commission, we appoint DJPs with that understanding that if anything happens, they must take over. Now it is the other way around, and I think it was not well considered. I mean, JP can do very well as a member of the Constitutional Court, you know, and you remain there running things and appointing someone else.
And sealing.
And unsealing. No, you unseal. And you unseal what you have sealed yourself.
I understand your comments, Commissioner Malema, and maybe that's something that I'll think about. But at the end of the day, this body will decide as to what should happen with the application that I've brought before you.
Thank you, CJ. Thank you, DJP.
Thank you, Honorable Malema. Maybe just to pull the JP's leg, I invited him to come and act, and he didn't take the invitation. Thank you, DJP. You are excused.
Thank you very much, Chief Justice.
CJ, you can't accuse me and not give me a right to reply.
But it is true.
What is true, CJ?
That's what happens these days.
It's true. I was invited with DJP Mujapilo, and I said to you, CJ, please, I can't leave the division leaderless. Let DJP Mujapilo come. I'll come at another time. I think that completes that discussion, CJ. Thank you very much.
No,
But JP,
Ledwaba
why
was
do you
there
say you'd
as
leave
well.
it leaderless?
Ledwaba was there.
The door was there. But CJ never get tired. I think you must invite him again.
Yeah.
Thank you very much.
Chief Justice, the candidate is ready and able and waiting.
Thank you very much, JP. Good evening, Judge Mabindla Bakwana.
Good morning, good evening, Chief Justice. It's because I've been waiting from the morning, so I apologize for that.
I'm sorry.
And
No,
and good evening to the commissioners as well. Thank you.
well, I must apologize to you that we kept you waiting until now.
Not a problem. I fully understand.
How do you prefer that I address you, Mabindla Bakwana or Bakwana? I just don't want to make any error.
Whichever comes to mind, Chief Justice, because they're both part of my surname. But
All right,
is still part
okay.
of my surname, so it's fine.
Okay. All right. Thank you so much. For how long have you been a judge in the Eastern Cape? Is it the Eastern Cape? No,
Western Cape. It's just over 7 years now,
Yeah.
Chief Justice. And if you include my acting stints in the Labour Court and in the High Court, I think it would be close to 9 years.
And it's quite a busy division, that one, isn't it?
Very, very busy. Very busy. We
Has
actually
it
don't
equipped
have.
you well?
Yes, very well. We actually don't have weekends and evenings because of the work, the kind of work that we do in the division.
And for how long have you acted at the Supreme Court of Appeal?
I've acted for a year now, Chief Justice, from the 1st of April last year, and I'm still acting there.
Tell us what helped you to be as ready as you believe you are for SCA appointment.
Thank you, Chief Justice.
As briefly as you can, but don't compromise on the key issues
I will
that you want us to.
I will try to be brief, Chief Justice, taking into account that I've been before this body in 2013 and in 2017 for the positions of the High Court, and then thereafter the Competition Appeal Court. And I outlined at the time my experience from before I became a judge. But I will just give a snapshot of the fact that from when I became a judge, I was an attorney, admitted in 1998 as an attorney. I have been a person who's also worked in a large corporation, and I've also had a stint and tried as a small business owner. And also during my time, I've been involved in a number of bodies, including the Institute of Retirement Funds, and I had an interest in retirement fund work. So I got exposed during that time in a number of areas of the law, which would be labor law, obviously, and pension law. And within itself, pension law encapsulates a number of other areas of the law, which would be commercial law, because you deal with contracts, and you also deal with administrative law, because reviews are brought, as well as constitutional law. So I got exposed to a number of those, doing due diligences and contract work for clients. And while I was still there in practice, in fact, I got a call that would change the course of my career, which actually is the reason that I'm even here. Judge Mlambo, who's sitting over there, who was a Judge President Mlambo, was the Judge President of the Labour Court at the time. And he invited me to go and act at the Labour Court. And I remember his words that he said when we sat there with a colleague of mine, Judge Kate Savage. When we started, he said to us, remember, no one was born a judge. All these people that are sitting here started where you're starting now, and they developed and became judges who are now experienced. So don't fear anything. And that was really calming, and it had a calming effect. And I remembered that throughout. And when I acted in the Labour Court, I started in 2011. Then I was asked again to act in 2012. And straight from the Labour Court, Judge President Hlophe and DJP Traverso asked me to go act in the High Court in Cape Town. And immediately the same year, I was then appointed in December of that year, after close to 4 terms, as a permanent judge of that court. Thereafter, I was asked to act in 2015 in the Competition Appeal Court, and was appointed permanently in that court in 2017 when I came before this body. And in those 4 courts, I've written a number of judgments, and which have been interesting in a variety of matters and various aspects of the law. I got exposed in criminal law, commercial law, constitutional law, tax law, administrative law, obviously competition law. And I also got an opportunity of writing a judgment in maritime law, which was quite interesting for me, a matter that dealt with a very interesting question of what happens when a ship has been arrested in terms of the Admiralty Act. and consequent or after that, the owner of that vessel or that ship is then is then placed under business rescue. And as we know that the business rescue places moratorium on legal proceedings. And so I had to, in fact, analyze and interpret two types of legislation, that is the Admiralty Act as well as the Companies Act on the one side. And I had to find a way of making sure that I interpret those acts without violating the other. And then thereafter, I've written judgments in the Competition Appeal Court, and maybe I can mention some of the judgments that I've put in my pack, which I've written in the High Court. And one of those judgments is the Women Legal Center judgment, which dealt with the violation of rights of women and children that were caused or that were as a result of the non-recognition and non-regulation of Muslim marriages. In that matter, we had to actually traverse and go very deep into international agreements and international laws that South Africa had ratified, and also look into a lot of constitutional law cases and the history of how Muslim marriages were treated before. And we were of the view that clearly there was a case made that there were constitutional violation of rights of women and children. And that matter, and we felt that that matter had to be remedied by the state. And the matter went to the Supreme Court of Appeal. Supreme Court of Appeal agreed with us, indeed, on the violation, even though they gave a different remedy. Then I can also mention a case of Sonke Gender Justice, which is also a constitutional matter that dealt with whether or not the provisions of the Correctional Services Act, whether they were providing sufficient independence to the Judicial Inspectorate for Correctional Services, which we know is controlled by an inspecting judge. Currently, it's Justice Edwin Cameron who is in charge of that. So there was a challenge that was brought that in the manner in which it is currently structured, the Act does not provide enough independence for JICs to function properly. And so I found that those provisions were invalid to the extent that they did not provide adequate independence to the JICs. And the matter went to the to the Constitutional Court for confirmation. The Constitutional Court agreed with me, but just for one provision which they felt that could be read to be constitutionally compliant. So it did not to be struck. So
Judge, I can see you are ready. Let me rather stop here so that some of the issues could be raised with you by fellow commissioners. Let me give the president the opportunity, but before I do, I just want to take a list of commissioners who might wish to hear more from you. Colleagues, may I have your names, please?
Sepe. Lucas.
Matolo Lepu.
Bonard.
Mlambo.
JP, I think you're muted. CJ, sorry.
Who comes after Commissioner Matolo Lepu? It's okay.
Have you got Barnard there as well, CJ?
You come before Commissioner Matolo Lepu. Yes, I've got you, sir.
Thank you.
And you can add Schlemmer, please.
All right. Over to you, President.
Thank you, Chief Justice. Good evening, my sister judge.
Good evening, President.
Are you well?
Very well, President. And you?
I'm fine, thank you. I don't have many questions for you. First, a comment. Everyone who has sat with you at the SCA describes you as a quick study, very hardworking, eager to learn. You've just impressed everyone. And I'd like to add to that list that you think and write well, which I think are just precious qualities in a judge.
Thank you.
Did your experience at the Competition Appeal Court, help you in any way? Can you attribute these qualities to your time there? Because it appears that you have not struggled to adjust to the Supreme Court of Appeal.
Yes, President, my time at the Competition Appeal Court has definitely helped me because I had an opportunity of presiding because I became one of the senior judges of that court. So I had an opportunity to preside over matters. And I also acquired a lot of experience from the High Court because I got an opportunity to write interesting matters in the High Court. The JP gave me quite important matters, which I feel humbled that I was actually given an opportunity to write. That has helped me quite a lot. And as early as last week, there is a judgment that I wrote that had a competition angle in it, which came out last week. It's the question in that matter was whether the High Court had jurisdiction to hear a review application when the challenge was on the validity and the lawfulness of a complaint that has been brought against a party by the Competition Commission to the Competition Tribunal. And so the experience that I had from the Competition Appeal Court came in quite handy in that case.
You were unfortunate because your acting stint at the SCA coincided with the beginning of COVID-19
Yes.
lockdown. How did you find starting a new work environment on the virtual platform, and did that impede your execution of your judicial functions in any way?
Obviously, President was actually looking forward to physically sitting on the bench and not having my bench virtually from home. And but when it comes to my work, I was not hindered at all. My work was not compromised. I was able to, when we link, to ask questions from counsel like I would and get clarity like I would if I were in the High Court. And also the post-hearing conferences that we held, we had opportunities to express our views via the link properly, and where we get petitions on a weekly basis, and we're able to interact with colleagues. In fact, colleagues at the SCA welcomed me before we even started by phoning me and just inducting me on the way of doing things at the SCA and what to expect at the SCA. So, but my work, because we also have a virtual library, and when I need any extra research done, the researchers are there, and also my secretary is an attorney, so she's been able to do one or two researches for me. So I've not been compromised at all.
Good. Well, as you have mentioned yourself, you've written quite a number of interesting judgments, both in the High Court and now with the SCA.
Yes.
But I'm just going to comment on one judgment, maybe, well, in a criminal matter, which was not complex at all. But the important thing about it is that you made history and wrote it in your mother tongue, is Xhosa and English.
Yes.
Why did you think it important to do that?
I'm a proponent, President, of development of indigenous languages, because I think that Afrikaans and English are where they are now in terms of being court languages. At least Afrikaans was until recently, and the legalese, or the legal language, or in those languages has been developed by somebody. And I think it's upon us, when we can. Obviously, we can't do it in all matters. When we can, to write judgments in indigenous languages, especially language of the appellant and the person and language of the community from where they come. So because I think that provides access to justice in the sense that people get to understand the judgments of the court because they can read the judgment in their languages. But in doing so, I actually was inspired by you, President, because you had written a judgment, I think, in isiXhosa, which I actually admired, and I thought I want to do this because I think it's something that we need to do as judges.
And for the benefit of those who are not aware of your judgment, it's the matter of Andile Lungisa against the state that came before the SCA and then went to the Concord, I believe.
Yes.
Now, the BLA has questioned your readiness to join the SCA. And interestingly, they say you were appointed to the bench only in 2017, but then in that short space of time, you managed to act both at the Concord and the SCA. Is the write-up about you accurate? Are you a weak candidate?
I thought there was an error. I thought there must have been an error when I read that letter, because I thought maybe the author of the letter did not read my questionnaire. So I took it as that because I felt that that comment is actually unfair because it's not supported by the work and that I've submitted to the commission, which was given to the legal bodies for them to assess. And so I thought that that comment was actually unfair, and it did not point to any shortfalls or shortcomings that could be pointed out to say, for this particular reason, we think the candidate needs to act more. But I do take the compliment that I acted in the Constitutional Court on the lighter note.
Maybe it's a prediction of things to come. Who knows? Lastly, Judge Magindla Bokwana, let me see. No. Let me stop here. I've asked you enough questions. Thank you. Thank you, CJ.
Thank you, President.
Commissioner Tsepe.
I've been covered by the president, so I'll forego my time. Thanks.
Thank you, Commissioner Barnard.
Thank you, CJ. Judge,
CJ, I hope you have me on the list.
Good evening, Judge. I'd like to take you to the matter of the Cape Bar versus the Minister of Justice.
Yes.
And just make it's a nice matter, a good matter to go to, because it dealt with a dual court. You know, it was the Equality Court on the one hand and the High Court on the other hand.
That's correct.
And in that matter, at one stage, you made a remark to say that it's really difficult when faced with a large number of counsel before you. I think there was something like 16 advocates or 17 advocates at least in court. What was particularly difficult about that matter?
I don't recall that. Can you just read out that particular paragraph for me?
No. It was a remark made in court as observed.
I can't.
It was just in passing by.
I just simply honestly cannot recall making that comment. So I'm not able to answer that question because I can't recall that comment. You know, in court, you say so many things. And if it's not something that gets to be written down in the judgment, unfortunately, you're not able to go back and look at it. But if it was something that was said in passing, I can't really recall why that was made, because the judgment itself, I think maybe what we said at the end, if that's what you mean, is that we needed time to consider it because it raised important issues. We had a situation where there were arguments from the minister and the Legal Practice Council regarding the rationale of the scheme, the electoral scheme that was chosen. And the matter we set both as the Equality Court and the High Court. And so we had to look at PEPUDA and consider the provisions of PEPUDA as to whether or not there was unfair discrimination. And then we also had to look at the review application, whether or not there was rationality to the electoral scheme that was chosen by the minister and the LPC. Maybe that's what you are referring to, that we needed to take time to consider the matter.
Yes, thank you. Now, it's just when I thought of those remarks, I thought it's a similar situation. We have here a difficult task to choose between very competent judges.
In fact, I feel like counsel now, who actually sits in court and I get to ask questions. So I feel like I'm in that position.
Sorry about that.
No problem.
Now you know
Can I
what it
ask
feels
you
like.
I know.
As a last question, in that matter, which I suppose, although you said it didn't go about specifically about the people involved, it did have at the heart of it the election of a black female to the Cape Provincial Council, or the Western Cape Provincial Council. And what was strange in that matter is there was, of the 17 advocates, there was only one female advocate that appeared
Yes.
before you. What was your thoughts on that?
We actually did make a remark about that. That in fact, when we saw, we thought, wow, this is refreshing. That for the first time out of all the people that have appeared before us, we get to see a female advocate. And in a matter that dealt with matters that were important, matters of transformation. And so it was disheartening. I think that's why we made a remark at the end of that judgment, that it's not enough, or transformation is not just about putting women candidates in a council. The real thing that should happen is for women and black people to be given work and to be supported, mentored, and we felt that we should not focus on the wrong fights. We should focus on the real issues, which we thought that we should make that remark and remind the parties that that is what needs to happen.
Thank you very much. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner Barnett. Commissioner Matolo Dlepu.
Chief Justice, I hope you have me on the list.
Okay, so thank you.
CJ, same to me. I think I was number 1 or number 2.
Oh, not being called yet.
Okay, thank you, CJ.
And Lamula CJ.
And good afternoon, Judge.
Good afternoon, Commissioner.
I'm really happy to see you here.
Thank you.
And I really want to commend you about the work that you do.
Thank
and
you,
especially
Commissioner.
being an activist for women's rights,
Thank
especially
you.
assisting the Women's Legal Center and also Saula. So
Thank you.
all I wanted to say, I'm encouraging you to keep on doing it, and we'll be proud of you.
Thank you, Commissioner.
Thank you, CJ.
Thank you very much, Commissioner Matolo Dlepu. Honorable Nyambi.
Thank you, CJ. Evening, Judge.
Evening, Commissioner Nyambi.
Let me also join and commend you for that judgment you wrote in Xhosa and English.
Thank you, Commissioner.
But if you can expand a bit and explain what role, in your view, does language play when it comes to access to justice?
It plays a big role. It plays a big role, Commissioner. Yes, we currently have interpreters in court, and witnesses get to speak in their language, and what they say gets to be translated in English, because the language of the court is English, which is understandable, because if we have to read the record, especially when the matter goes on appeal, the judges need to understand, because not all judgments speak isiXhosa, for instance, which is my home language. It is my view that in some instances, if it is possible, where all members of the court are of the same language, if it is possible for the matter to be conducted in that language, that would be something that will actually contribute to access to justice in a big way. But I do understand the costs that are involved in translations, because if that matter goes up, it will have to be translated in English. So those are the impediments that we currently have, but I think we need to find ways of working around those challenges.
My last question, if you can share with us your understanding of the relationship between democracy and the rule of law.
I think they're intertwined. The rule of law is actually the founding value of the Constitution. And in terms of our Constitution, everyone is equal before the law, and all law and conduct must be consistent with the Constitution, and the courts are given the powers to hear reviews when reviews come before them. So rule of law is a founding value of our Constitution, which actually measures all conduct and all law that must be consistent with the Constitution. And democracy, we live in a democratic society that is open, which gives everyone a right to participate in our democracy in many various ways. That's how I can answer that question.
Once again, how I wish we can have more judgments in our languages. Thank you, Judge. Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable Nyambi. Prof.
CJ, I wanted to check if I'm there.
You were not. I will entreat you, Honorable Malema.
Thank
Prof.
I'm covered. Thank you, CJ.
CJ Lamula, I also just raised my name. I don't know if you heard me.
I have you, Honorable Minister. Honorable Lucas.
Thank you very much, CJ. Good evening, Justice Bokwana.
Good evening, Commissioner.
I was like reading the comment that is, or the objection that was raised by the Black Lawyers Association. And after you have indicated here that you have written a judgment on maritime law, I really also want to say that I don't agree with whoever is saying this about you. And the reason why I'm saying that, I just want to explain quickly. I had a short stint as a MEC of Environment, and we used to attend international events. And there is very few few people that is really knowledgeable about issues like maritime law and environmental law and so on. So I think you are fast becoming one of our experts in some areas.
Thank you, Commissioner.
And also the one on language has been addressed. I think it's enough. The one that I also wanted to mention was the issue on the Women Legal Centers judgment. But because in our experience, I was raising it here all the time about the issue that when we were having a countrywide program where women felt that there is no lack of compassion and accessibility in terms of particularly the law enforcement agencies as well as our courts. Now, just this year, the Parliament have actually amended the Muslim Marriages Act, and it is now waiting on consent from the President, which is groundbreaking. It's really groundbreaking. But we still have an issue with regards to customary marriages and the customary law, because there is still that kind of separation. Because I think Muslim marriages, whatever it is called, it's also part of customary marriage, religious marriage. There is many things that is still not, addressed. And I would love to know, just in short, what is your view with regards thereto? And I think also the issue of legal practices, that one have been addressed by Honorable Singh, I think. So I have been covered, but I would really just in short, since you have been very passionate about the work that you've been doing for Women Legal Center, what about the issues of customary marriages?
Thank you so much, Commissioner. I think customary law, I think we've all been saying this many times, that it's our law that is relegated to the back. And even though the Constitution says it must be developed, but that has been few and far between, and it's been only in cases, a few cases, marriage cases that come to court in terms of the Recognition of Customary Marriages Act, and the chieftaincy cases that come to the courts. So I think we need to do a lot more in terms of uplifting the law in that regard. And I think it's not just the judges. I would urge the legal profession, when they present cases to courts, to actually explore the angle of customary law, because the majority of us, I say us because I'm also an African woman, many of the disputes, including marital issues, are in terms of custom. And that is the kind of law that regulates people on a daily basis, but yet it's not the law that we have given focus to, and I think we need to do that.
Thank you, Justice, and thank you, CJ.
Thank you, Honorable Lucas. Commissioner Sigogo.
Thank you, CJ. Good evening, Judge. How are you?
Good evening, Commissioner. I'm fine, thanks, and you?
I'm good, thank you. The reason why I wanted to speak first on this issue was to put on record the genuine mistake from the Black Lawyers Association about its comment.
I accept that.
Yeah, so I've seen where the mistake emanated from. It is from in your questionnaire when you were listing your appointments in the judiciary. You put them separately without years, and then you went to another paragraph where you put years separately, 2013 and 2017.
Yes.
So then the scriber then went with 2017. So that was a genuine mistake, and
I understand.
we do not have an issue with your suitability. That
Thank
is
you
the
very
first
much.
issue.
I appreciate that.
Thank you. So then the main issue, the judgment which Commissioner Barnard spoke to you about.
Yes.
You wrote so many good judgments that I've read.
Yes.
But I must commend you for the judgment in the Cape Bar versus Minister of Justice.
Thank you.
Because I believe that judgment saved the Legal Practice Council.
Thank you.
Because the Cape case was the test case, and the Legal Practice Council was going to be challenged in almost all the provinces for its election program. So then I want to know from you, how did you see through that that case when you come to the resolution with your fellow panelists that the election mechanism of the provincial councils was not unconstitutional?
I think the starting point, as we mentioned in our judgment, I think in our introduction, was that it is not our function as the court to choose a scheme that we prefer. Our function as the court is to look at whether or not the scheme that has been chosen by the executive passes the constitutional test. And that was the issue. And so we look at whether or not the requirement of 50% male and 50% female and 50% of each of the races was rational. And we looked at the reasons that were given by the minister and the LPC, and we felt that they did pass the constitutional test. That is why we came to the conclusion that they were not unconstitutional.
Thank you very much.
Thank
you, CJ.
Thank you, Commissioner Sigogo. Honorable Minister.
Thank you very much, CJ, and good evening, Mbotwana.
Good evening, Minister.
Yes, I just want to take from where Commissioner Sigogo ended. Indeed, that judgment was very scholarly.
Thank you very much, Minister.
What I want to get from you is because in that judgment and in our discussions with councils, even prior to the judgment, our biggest worry was the thin line between what is in the act and and what was declared unconstitutional by the Concord, what is called the quota system. And you will have seen that the manner and the scheme of the Act, although it's not a quota system, but it allows for some kind of representation by all the parties and so forth. So my question is, how do you think we should move forward to advance transformation for the legal profession or for any scheme in the legal profession with its unique features and characteristics? As you are aware that the Legal Practice Act was an outcome of some kind of a compromise amongst the parties.
Yes.
So it does show that even most of the issues that we deal with will have to be that kind of an outcome. For example, one of the things that I asked, I think is Judge Matopo, is on the issue of the insolvency practitioners. Because it was a quota system, it was declared unconstitutional. But this one, although it's not a quota system, but we're a bit worried about that. So what is your view after having traversed that route? What could be your advice for us going forward, for the profession as a whole, but also for issues that come to us that we have to resolve in terms of transformation for the profession?
Thank you, Minister. I think that was a good starting point in my view. Now, not talking about the judgment, but just talking about the scheme itself, and not analyzing it in terms of the judgment. It was a good starting point because what it does is to say that all people, all stakeholders in the profession must come to the table and find a solution, because the Legal Practice Act enjoins the council and the provincial councils by extension to in fact transform and restructure the profession. And now, because I'm passionate about women, my topic is gonna slightly venture, but I think it will also assist in terms of transformation. I think the questions we need to ask ourselves, what are the problems? What are the barriers? Why is it that we're not getting to where we are, where we want to go to? I think we all say this, that we see young women graduating in numbers, and we're told that, I'm not sure, in some law schools there's actually a lot more women than men, and we get to admit them in court in numbers, but we never get to see them again appearing in court. And we need to find and ask ourselves the question, where are they? What is causing that? What is the problem? And one of the issues I think is the problem is the fact that the society is not yet trusting of women. The society does not see women enough as being suited for court work. And because of that, there's reluctance in giving work to women. So there must be education that starts at that level, that our society needs to change. Our society needs to know that women can be lawyers too and litigators, not just people that are good in drafting documents. And I see this as a chain, basically. I see this as a chain because I think everyone must buy into the transformational project. I see it as a chain because I think you need client first to be educated. Client, I'm only gonna focus on big business and big banks, which are the clients that mainly come to our courts, as well as government. Those are the biggest clients. And some of the work doesn't go via the state attorneys, I understand. They can, in fact, instruct attorneys directly in some instances. So clients need to change their mindset and the perception that they have about women. And I think we as lawyers have a responsibility of influencing that change and actually getting our clients to change. And from there, from the clients, then there's attorneys. And I'm going to say big law firms because that's where most of the work goes. They need to take responsibility of mentoring people. They need to make sure that the environment and the culture is made conducive for women to thrive. And they're not just given small tasks, but they get involved in complex work. And then moving from there to counsel, to advocates, that big firms need to give a chance to women and young and Black people that are at the bar. and trust them more. I always say this, because when I was in practice, this is what I used to say to companies. I'm not saying that take your work away from the people that you're currently instructing. But what I'm saying is that give me one file, because you can assess me from that file.
Judge, I get that you are passionate on the matter, but
Okay.
the CJ is gonna want us to
That's
move
fine.
on the matter.
Yeah.
My last question on the same topic that we're on, just to put you in our minds as the executive, is that on this matter in particular, as I've said, that obviously what worries us is that we do put policies sometimes. Implementation becomes difficult, or even when the policies are still being at the draft stage. As we speak now, the LPC, they are busy drafting policies that are aimed at the legal practice code or charter. But already a threat of litigation is looming by those who want to frustrate transformation. So why I say this judgment of yours was scholarly is that you are also brave as the judges of that court. Government there does not usually come back in that bench, but you took a kind of a decision that you were bold, and you could also see what is the intention of the legislation and how it is going to help in terms of the issue of transformation in the profession as a whole. So what do you think should be the groundbreaking position that will also enable us, the executive, so that when we take these kind of decisions, the courts are also able to see it through, that this is the vision and this is the direction that is in the interest of the country?
Unfortunately, I think each court will assess the case that comes before it. I'm not able to, in fact, tell you that this is what the courts should do, because I think each judge and each court will have to take a decision based on what's before them. And but in that particular case, we did look at the vision. We did look at what the minister and the LPC and the profession is trying to do, and we found that that was actually a good vision. But it's difficult for me to say that this is what the courts must do in order for them to move forward. But I don't know if I've answered your question.
Thank you. You have answered my question. I understand your difficulty. Thank you.
Thank you.
Honorable Malema.
Thank you very much, CJ, and good evening, Judge.
Good evening.
How many
Commissioner Malema.
arms of the state do we have?
3.
What are they and what are their roles?
We have the legislature, which is its role is to make law, and we have the executive, which role is to make policy, and we have the judiciary, which is there to interpret the law and the constitution.
What is a judicial overreach?
Judicial overreach is when the courts usurp the roles of other arms of government. For instance, if the judge were to give an order that says, well, I think the executive should use this budget for building schools instead of building bridges. That's just an example. In that matter, the court is actually getting involved in the policies.
Can judges make law?
Well, judges can't make law in the sense of legislation, but in some way, because the judges write judgments, they do change the course of the law in many instances.
President of the SCS said something about Andile Lungisa. I didn't hear. What happened?
That's the case that I wrote, the judgment that I wrote, and it was supported by 4 other judges.
He's my friend. Thank you.
Thank you. Thank you, Mr. Malema.
Thank you very much, Judge Mabinda Bokwana. You're excused.
Thank you very much, Chief Justice and the Commissioner. I appreciate the opportunity.
Thank you, Judge.
What about JP?
No, CJ, ready and able and waiting.
Thank you very much, JP. Good evening, Judge Matujani.
Good evening, Chief Justice, and good evening,
Are you
honorable
well?
commissioners. I'm ready to go, Chief Justice.
All right. Okay, please accept our apologies for keeping you waiting this long, sir.
Yes, the apologies accepted, Chief Justice.
Thank you. For how many years have you been a High Court judge?
I've been the High Court judge for the past 11 years. I've been an attorney for 18 years, and I've acted at the Western Cape High Court for 2.5 years. All in all, I have 31 years in the business of the law.
And for how long did you act at the Constitutional Court?
I acted at the Constitutional Court for 1.5 years, I think 6 terms.
What about the Supreme Court of Appeal?
Sorry, correction. I was at the Supreme Court of Appeal for 1.5 years.
And the Constitutional Court?
Oh, at the Constitutional Court, I acted there for 1 term.
And very briefly, just give us the highlights of how all this experience has prepared you for the SCA.
Chief Justice, I thought I should talk about the traditional route to a position of a judge in South Africa. You have to be, it's good education, good university, a practice that attracts lucrative commercial work. Then you acquire technical skills that qualifies you for appointment as a judge. If you are a white person in the old South Africa, you only had to be a prosecutor, a magistrate, attorney or advocate, attract lucrative instructions, which gives you the technical skills, and then you qualify to be appointed a judge. If you are a black, I'm going to talk about my lived experience. I was born and brought up in Soweto. I remember at matric, we didn't have a maths and science teacher, but I managed to secure a merit bursary to study mining engineering at Wits. I was admitted. The day before orientation, I remember, I was told that I need to phone a certain Gerrit Viljoen, who was the Minister of Bantu Education, to find out whether my application to study at a white university has been accepted. It was refused. At that time, applications to universities were closed, and I heard that the University of Zululand accepts walk-in applicants. That's how I ended up at the University of Zululand, where I did my BProc. I got a bursary that was administered by the university. I ended up doing LLB at the University of Zululand because at the time, my parents, who didn't have any formal educations, didn't have the means. I came to Johannesburg with my LLB degree from the University of Zululand, looking for articles. Big law firms, if you're a black from a so-called Bush University, would laugh at you. It wasn't easy to get articles. The Black Lawyers Association had placement schemes in terms whereof they raised funds overseas and paid stipend to black lawyers to take up article clerks. That's how I secured articles in a one-man practice. We couldn't attract lucrative commercial work. We could only do criminal cases. There was state of emergency. People were being arrested randomly. We did a lot of criminal defense work, public violence cases. And because, we're acting for poor people.
May I try to help you, Judge?
Yes, sir.
Please, I'm sorry to interrupt you. I'm very sorry.
Okay.
I was just thinking that because you are now applying for a position at the Supreme Court of Appeal, you may wish to focus more on aspects of your experience.
Yes.
That would demonstrate to us how equipped you are for an SCA appointment. Just the highlights. Some of the details will come out as commissioners put questions to you. I'm really sorry to do this to you.
I understand, Chief Justice.
I'm just trying to help you focus better.
I understand. The point I wanted to make was this, that the fact that we're denied opportunities should not be the reasons why we should not be considered for appointment in senior positions. Chief Justice, I believe that constant improvement is better than a delayed perfection. I registered for a master's degree at the University of Joburg, then it was called Rand Afrikaanse University. I then registered for another master's degree in commercial work with the hope that one could develop one's base of an experience and concentrate on commercial litigation, arbitrations, and insolvencies. I have to bring this up, Chief Justice. Our Judge President Malamba has initiated a pilot commercial court project. I'm the convener of that pilot project. We seek to attract commercial work to the High Court. The project is doing well, but I must say that of all the cases that I'm case managing, about 16, I'm yet to see a black counsel instructed by this big commercial firm to appear for them. I'm yet to see a black law firm. 20 years down the line, we will be saying, black people don't know commercial law. Black people cannot do arbitrations, insolvency practice measures, and acquisition. It's a concern that I thought I should raise, that we, black lawyers, despite the stumbling blocks that are placed in our path, we are ready. We want to be given a chance. We want to advance. We want these big commercial litigants to instruct black people. It's going to take time. My concern, as I said earlier, is this, that 20 years down the line, we'll be still be singing the same song. Back to your question, Chief Justice. I think I have acquired the necessary forensic skill after 31 years in the legal profession.
Thank you very much, Judge. President Mai, I'm going to ask a favor of you before I hand over to you. As the names are being mentioned, because sometimes I step aside when I have to, please just write them down as well so that you and I have a common list of who's going to put questions, and even if I'm not there, you're able to proceed with meeting. Thank you. Colleagues, may I have your names, please?
Muiman.
Who? Muiman.
Matorol Depu.
Nyambi.
Is that all?
Barnard.
The commissioners are tired, CJ.
Yeah, no, we understand. We still have a long way to go. I mean, we still have 3 more candidates after Judge Matojani. Over to you, President. Is there another colleague?
No, I just wanted to record that we're not tired. We only have do not have issues to raise with the candidate.
That's good to hear.
What is before us is very clear. Maybe there will be follow-up questions. Thanks.
All right. President, over to you.
Dodovo is spreading a rumor, CJ.
Is spreading a rumor?
Yes.
All right. Okay.
May I go ahead?
Over to you, President. Over to you.
Thank you. Good evening, Judge Matojani.
Good evening, President Maya.
You come from a division which piloted court modernization and systems such as case lines, and I have to say that you've shown yourself to be quite adept at the new technologies. And the SA is a newcomer to these innovations, and you had a big hand in helping demystify, allay our fears and persuade us to actually join the bandwagon, because most of us down in Bloemfontein are quite old, and technology is a big hoja.
Thanks.
So I just wanted to commend you for that and the role you played in guiding us towards the right direction. Can you just briefly explain the benefits, case lines, for example, means, especially in this new normal of running course on the virtual platform?
Yes. Thanks, President Maya. This is another initiative by Judge President Malambo, where he went out of his way to have all files digitized. And we ran a paperless court at the High Court in Johannesburg. And this came at the right time during the era of COVID-19, where we are able to conduct trials from our respective homes. Well, there are technical problems in that we didn't have the tools of trade, but through his relentless effort, most of us have now been provided with updated and up-to-date computers, which makes it easy for us to conduct courts visually. The system is cost-effective. We no longer have problems with files getting lost or misfiled. We no longer have physical files being moved from one point to another. Everything is done electronically. Recently, I was doing a lift to appeal. One of the counsel was in New Zealand, the other one in Cape Town, and I was here in Johannesburg. The system is working. It's working well, and it saves litigants expense, and I think it makes courts accessible to poor people. In Johannesburg, we have dedicated courts that have the necessary equipment to enable those who can't afford or who don't have the means to access the court, to come to court, and the court staff assist them in joining the proceedings from the court building.
Have you had the chance to write judgments at the SA, and if so, how many?
I have written judgment at the SCA. Unfortunately, I do not.
You don't have the exact number?
I don't have the exact number, but I have written
but it's quite a few, huh?
It's quite a few because we write 1 or 2 judgments per term at the SCA.
You recently co-wrote a judgment with Justice Bonan in a citizenship matter. It is the case of Minister of Home Affairs against Joseph. Now, co-writing judgments is not a common phenomenon, not just at the SA, but in all courts. May I ask how that came about and how you found that experience?
I don't know, but the matter was allocated to both of us. We worked together, we discussed the matter, we divided into 2. He wrote one portion, I wrote the other portion, and then we subsequently met and then finalized the judgment together.
And there was no problem there, you were able to work seamlessly together?
Yes, there was no problem. In fact, Judge Ponan was, he was helpful and willing to share his long experience at the SCA.
Everyone who has worked with you at the SCA has commended you for your work ethic. You are known as being a hard worker, which is why I am uncomfortable asking you this question. It's something we discussed previously, and it concerns a report that was made to me by a senior colleague who says he allocated you judgment writing responsibilities in a land restitution matter. That was in the fourth term of 2020. And he says he was quite disappointed with the draft judgment that came out. It was certainly not what he expected, especially from you. And it ended up needing a lot of rehabilitation. And then he says, more disappointing now was that on the day of the case conference, you appeared unsure. You actually had a series of drafts that had been exchanged as is usual. You know, people will make their comments and you incorporate and you recirculate. But now you actually had the wrong draft, which is unforgivable for a scribe, because it's your judgment. You are the one who should, make sure that your colleagues actually have the right document in front of them. So you appeared unready, and then after the conference, you recirculated something which had material that had not been discussed by the collective in the conference now, but then happily, ultimately, it was all sorted out. What happened there? Is it lockdown fatigue? What happened to you?
Maybe I should start by extending my apology to the senior judge concerned. This is a case of misunderstanding or miscommunication. I wrote a judgment, circulated it, and there was delay in having colleagues commenting on my judgment. I remember I had to send a reminder to them to say, it's now over 3 weeks and I haven't had anything from yourselves. So it was a panel of 5 judges. Then I received all the 4 comments. Now, I work from home. You have a laptop screen. I also have a monitor on the side. So as I was incorporating these suggestions, I was doing it online. I should have maybe, it's just that I don't have a printer at home. I should have printed all these judgments because they had tracked the changes. Maybe I should have, on hindsight, I should have printed all these judgments and went through their individual comments. So what happened was, I was working on my original draft and tried to incorporate their comments and suggestions. The senior judge had suggested, what I did there's this paragraph in the Plascon Even case that deals with dispute of fact in motion proceedings. I cut and pasted the whole paragraph in the judgment. The feeling was, as an appellate court, we can't just quote a judgment in verbatim. We should put it in our own words. So what I did was, the senior judge summarized that paragraph. And in the process of preparing the second draft, for some strange reason, I lost his tracked comments. And knowing that the concern was that we should use our own words and we should formulate our own words, I thought that I could do it myself. So I tried to summarize that Plascon Even principles. I circulated it, but before doing that, I found a second senior colleague for directions. I said to her, look, I'm battling to find this email that contains the formulation by the senior judge. And I asked the senior colleague if she could forward to me the email that came from the presiding judge. She advised me that to approach the senior judge directly. I did that, and he agreed to resend the formulation of the Plascon Evans rule. I incorporated that in my judgment, and I circulated the third draft. That's what I'm saying. It was a misunderstanding. It is regretted. I've never had problems in writing judgments, and I've never delayed in delivering my judgments. And I can confidently say that I have no problem with writing judgments. The
Yeah.
mistake is regrettable.
Thank you for that explanation. And I must just make clear that this senior judge was also, crestfallen, and he said he needed this to be raised with you because, we want, the court is under so much pressure right now, as you would have experienced with all the work and most of the senior judges leaving. So we are just spread too thinly. So people should, just take care of their business and not rely on others to look out for things that they, should be responsible for. Otherwise, we know your work. As I said, we know your work ethic, and you have proved yourself at the court and elsewhere. But thanks for the explanation.
Thanks, President.
That will be all, Chief Justice. Thank you, Judge Matochani.
Thanks, President.
Thank you, President. Honorable Moima.
Thank you, Chief Justice. Good evening, Judge Matochani. This side?
Yes, thanks.
The question that I want to pose to you is linked to the work, and the role that you played with regard to influencing the position of the new boss in charge of the Hawks. I noticed that in the matter that involved the Helen Suzman and Ntemeza, the Supreme Court of Appeal set aside the appointment of the Hawks boss in Ntemeza because the court said that the former minister Nhleko, in his appointment of Mr. Ntemeza, acted in bad faith because he did not take into account your judgment in the matter between Sibia and the Minister of Police. It's a matter around, I think, 2013.
Yes, I know.
That involved the rendition.
I know about the matter.
Yeah. Can you just give us a reflection in terms of your observation in terms of given that angle and how extensively you were quoted, the court can play a role in whipping us as lawmakers and political office bearers into line when somehow, in a manner in which we work on a daily basis, we disregard the rule of law, good governance, which involves the need to ensure that at all times we act rationally. We act in a manner that is accountable. We act in a manner that is transparent to ensure that the decision that we take must be informed by the sound reasons. Thank you, Chief Justice.
I think, in anticipation of other questions, I should say this, that as judges, we take an oath to be faithful to the Republic of South Africa, to uphold and protect the Constitution and the human rights entrenched in it, to administer justice to all persons alike without fear, favor, prejudice, in accordance with the Constitution and the law. Our judgments are based on the facts and the legal arguments that are presented before us. We we decide life issues. The issue is, what were the facts before me? What legal arguments were presented to me? What was my finding? I haven't reread the case, but I do know that the matter went to the SCA, and the SCA agreed with me, and some important principles were laid down in that decision. The point I'm trying to say here is the public has a right to expect that their matters would be adjudicated upon fairly, impartially, by a judge, without fear, without favor, without prejudice. And that's democracy that we all fought for. I'm sorry, I can't go into the specifics of that matter. I can't remember. But all that I can tell you is the judgment is based on the legal arguments that were presented before me. All the parties were represented. I had argument from both sides. I applied the law as I understood it. I wrote the judgment. What happened thereafter is really beyond me. I can't comment.
100% I agree with you. I think the point is that you found that the suspension by Ntemeza of Anwar Dramat and Sipia was done in bad faith. But I think my second question relates, don't you think that sometimes by so doing, by coming up with such judgment, which obviously has an influence in terms of how the executive operates, because in this instance, the executive wanted Ntemeza as the Hawks boss, and as a result of the decision by the court, which other people might have taken it as judicial overreach or judicial activism.
But
how do you balance that within the context of the separation of powers? Thank
my
you.
answer to you is this: those facts were not before me. I wasn't called upon to decide political issues. I had to address myself to the facts before me. Had I gone beyond those facts, my peers on appeal would have came hard on me. So, as a judge, when I decide a matter, and this has to do with the independence of the judiciary. As a judge, we are called upon by the Constitution to act fearlessly and according to our conscience, because we are accountable only to the law. All those, the noise on, it's really relevant. I don't know. I have nothing personal against Mr. Ntemeza. I didn't know that he was due for appointment or anything. I confined myself to the facts, the legal arguments that were presented before me, and I wrote my judgment. So that judgment obviously states the reasons why I came to a particular decision. An aggrieved litigant has a right. It's not the end of the matter. He has a right to take the judgment on appeal. He has a right to criticize it, tear it apart, tell the world how ignorant of the law I am. There's nothing wrong there. You have the right to demonstrate, vent your anger. It is to be expected that in any litigation, one party is going to prevail, and the loser is not going to be happy with you. He has a right to vent his anger, but you have to draw a line. You cannot make obviously false allegations against a judge that the judge is corrupt.
Okay, let me come in, Judge Mato.
Sorry, Chief Justice.
Honorable Moiman, do you still want the judge to go on, or do you have a sense that he has answered?
Yes, sufficiently canvassed the point that I was raising, Chief Justice. Thank you, Justice Matojani.
Thanks, Mr. Menon.
Thank you, Honorable Moiman. Commissioner Matolo Dlepu.
Thank you, CJ, and good evening, Judge Madojane.
Good evening, Commissioner Lepo.
All I wanted to speak to you about your judgment in Proxy Smart.
Yes.
You know, and what I must actually emphasize that it really saved the profession. I know that the profession was at tenterhooks regarding this issue of Proxy Smart. But what I wanted to understand from you, it was a perfect judgment. It was good. Do you think your experience as a conveyancer really assisted you in coming to that conclusion?
Yes, it did a lot. Yeah, my answer is it was good that I knew what was the issues, what's likely to happen if an individual, an entity can take over convincing work and employ convincers as clerks who just go and register document.
Thank you. Thank you, CJ.
Thank you, Honorable Commissioner. Honorable Nyambi?
Evening, Judge Matujan.
Good evening, Commissioner Nyambe.
As an experienced judge in the division here in Gauteng, you went to act in the SCA. I'm taking it from the president of the SCA, where you even apologized to the senior judge about
Yes.
the particular judgment. If maybe you can share with us your experience in terms of workload, collegiality in the SCA and your experience here in Gauteng so that we can have a sense.
Chief Justice, in Gauteng, we are a closely knit family. We are all collegial, and I really have no issues. My experience I was warmly received at the SCA. I know I'm expected to join the bandwagon and speak ill of the SCA top 6, but I was well received. There was a reception committee. They met with us. They explained to us their protocols, the do's and the don'ts, and I never had problem in going to any senior judge to discuss an issue that was bothering me. So I must say I was well received, and my experience at the SCA was enriching. You see, in the High Court, you write, it's your judgment, you deliver it, it's out of your hand. At the SCA, they actually appeal your judgment in your presence because some of these guys have been there for many years. And in most instances, the judgment that you are writing, they've written same judgment on the same issues. So it helps to engage them and debate with them. And look, there are always office politics. If you have nothing in your hands, you have time to follow these gossips and complain. I would say that it was an enriching experience. I enjoyed interacting, exchanging ideas, and benefiting from the long experience that those guys have in the division. I have no complaint.
Oh, I wanted to ask you this one question, but because we have canvassed the issue of the top 6, but now you are saying you don't want to join the bandwagon and speak ill about the top 6. Why are you saying that?
Maybe I should have said, I've heard a lot about the top 6. Even when I was invited to go to the SCA, I was warned to expect to be ill-treated, undermined, belittled, and all that. And I suppose maybe because of my years in the practice, I've developed a thick skin. So I don't think ill treatment by any judge would have had any effect on me or deterred me. I fight my battles. I don't think I would have been intimidated or allow a senior judge to undermine me.
Thank you, Judge. Thank you, CJ.
CJ, can I follow up?
Yes, please.
Judge.
Yes, Mr. Madam.
There is a genuine concern by your colleagues that they are looked down at, that senior judges are condescending on them. And even the leadership of the court confirms that. And then you come here and say you have no time for gossip, and when there is a legitimate concern of so many respected colleagues of yours, and when you come and say it's a gossip, you're dismissing it like it's not worth of our attention, because you'll agree with me that if there is such an attitude by senior judges on other junior judges, whereas female judges, it must be a concern to you and to all of us, and it cannot be dismissed as a gossip.
Yes, Mr. Madam, maybe I should withdraw the word gossip. I should have said, I don't have that personal experience. So, yes, there are talks that people have been ill-treated. I can't deny that, but it's not my personal experience.
Thank you.
Thanks.
Commissioner Barnett?
Thank you, CJ. Judge, very quickly, in the Fly Africa matter, you dealt with contractual damages, the SAFA versus Fly Africa.
Yes.
And in that matter, you made a finding, dismissed the claim. It was overturned by a full bench. And then in the SCA, again by a bench of 5 judges, overturned. Where do you think the full bench went wrong in that matter?
I didn't get that. The SCA confirmed my judgment. What happened was the full court set aside my judgment, the matter went on appeal, and the SCA agreed with me.
Thank you. I think the question was, where do you think the full bench went wrong?
I haven't read the contract, the case recently, but it was a contractual dispute. It involved an interpretation of a contract. Law, it's not an exact science. 2 + 2 will always be 4. But when we come to interpretations, one cannot say that this is the only and correct interpretation of a contractual clause. That's why in appeals to the full court, you would have 3 judges. As at the SCA, you'll have 5 judges. At the Concord, you'll have 11, and you have dissenting judgment. I think it was a contractual dispute. I interpreted the contract correctly. The SCA, the full court disagreed with my interpretation, but the SCA confirmed my interpretation. I can't remember what the issues were, but because it was some time back.
Thank you, Judge. Thank you, CJ.
CJ, am I on your list?
Thank you, Commissioner. No, you are not, Honorable Malema. Do you want to say something?
Yes.
Could you also add me, CJ, JP Mlambo?
Please go ahead.
Who, me?
Thank you, Jay. Who else? Apart from Honorable Malema and JP, who else?
Okay. I have just one quick follow-up question. Well, not a follow-up question, one question I overlooked when I was talking to him earlier.
All right, okay. Okay, all right. Honorable Malema?
Oh, thank you, CJ. Judge, I was reluctant to ask you about this case because somehow I'm involved, but we'll deal with it at a high level. The issue of Manuel versus the EFF quantum, which was upheld by the Supreme Court of Appeal in part, and then the quantum was referred back to oral evidence. How did you arrive at the conclusion that it was appropriate for you to award 500,000 without any of the parties leading any oral evidence? I know that Manuel is now appealing it to the Constitutional Court, but the Supreme Court of Appeal has referred that matter back to you and said there must be oral evidence led so that whatever figure you arrive at, it is on the basis of that evidence which would have been led at that level. Thank you.
You know, Mark Twain said that nothing spoils a good story than the arrival of an eyewitness. This matter is pending before the Concord, and I don't think that the Chief Justice is interested in my musings. So my simple answer to you, Mr. Malema, is that I cannot second guess the decision that is going to be made by the Constitutional Court. The matter is now out of my hand. I've said what I had to say, and if the SCA has partially upheld me, like you said, the SCA said the matter has to go for oral evidence. We don't know what the Chief Justice is going to say. So I'm constrained to really be seen to be second guessing what the decision of the Constitutional Court is going to be. I could be wrong, I could be right, I don't know.
Fair enough. Thank you, CJ.
Thank you, Honorable Malema. JP?
Thank you, CJ. Just a short one. Judge Matojane, am I correct that in Gauteng, even before you went to the SCA, the Concord and the SCA, and when you came back, you had already started leading full court benches in the division?
Yes, it's correct.
And you have written a number of, I would call, seminal judgments that have gone up to the Constitutional Court and upheld.
Yes, I have, JP.
I see. Thank you very much for that. Just one last thing. The president asked you about case lines. I was surprised you didn't make the remark that case lines, in terms of its conceptualization, is actually more appropriate for appellate courts than for trial courts. Am I correct?
You are correct. In fact, it would save litigants a lot of money to have counsel traveling to Bloemfontein and, securing accommodation. The case line work seamlessly. Legal representative.
No, thank you, Judge Matojane.
Okay, thanks.
Thank you, CJ.
Thank you. President?
Thank you, CJ. Just one quick question, Judge Matojane. I can't find your application form now. You have 2 master's degrees, don't you?
Yes.
One from UJ, the other from UNISA. But
yes.
What are they on? What were the focus of
the first
of this degree?
master's degree was, what do they call it? Per capita. In 1994, with the new constitutional dispensation, it was important for one to go back to school to study constitutional law. So it was coursework on constitutional law, law of evidence, I can't remember, and procedures. The second master's degree with UNISA is in commercial law.
Okay, that's what I wanted. Thank you very much, President.
Thanks, President Moya.
Thank you very much. Judge Matojane, you are excused. Thank you very much. And again, we apologize for keeping you until this late.
Thanks, Chief Justice. Thanks, Commissioners.
People are used to such things, but some of us don't eat after 8. That's why we are maintaining.
Oh,
Good evening.
CJ, I wanted to ask you to also admonish Mr. Malema, because he tends to ask a number of questions and you don't say anything about that. I was counting. He asked Judge Bokwana, I think about 8 questions, and you didn't say anything. So I demand 30 minutes.
No.
I'm no longer asking nothing. I'm done. I'm no one.
I'll tell you what he does. What the Honorable Malema does, he has follow-ups. But the beauty about his style of asking is that he's very direct and to the point. Something that most of us are incapable of doing. The result is in most of us, 1 question. You have Malema's 10 questions there.
Maybe we should adopt Mr. Malema's style.
CJ, the candidate is ready.
Good evening, Judge Moshe.
Good evening, Chief Justice. And good
How are
evening,
you,
members
sir?
of the commission. I'm fine. I'm
Yeah.
fine, Chief Justice.
I apologize to you for inviting you only this late. We're really sorry.
Yeah, no, it's all right. It's all right, Chief Justice. I accept the apology.
Thank you. For how many years have you been on the bench now?
10 years. It's 10 years on the bench.
And for how many years were you on the bench when you did that inquest?
I think I was 7 years on the bench because it was 2017. Yes, if I recall, it was 2017. I was 7 years on the bench.
And how? Thank you. And for how many terms did you act at the SCA?
It's for 4 terms, the whole year. I started in December 2017 to November 2018.
Very briefly, tell us how ready you are for this position.
Yes, I am ready. I've been to the Supreme Court of Appeal. And what motivates me to decide to go to the Supreme Court of Appeal is because of the number of matters that I wrote which went to the Supreme Court of Appeal where I was set aside. And I felt that perhaps we are not on the same page, and I may want to end my career there and make a contribution, in particular in regard to matters which we do not agree. There was one matter that I wrote, one judgment I wrote in 2013. It went to the Supreme Court of Appeal. It was set aside. And the party that was successful before me went to the Constitutional Court. The Constitutional Court set aside the Supreme Court of Appeal and upheld my judgment. And in the package that I've put in, there is a dissenting judgment that I wrote. We were 5 on the bench. I was the only acting judge. And the 4 permanent members took one position and I took the other. I dissented. And the matter went to the Constitutional Court. The Constitutional Court set aside the 4 members and upheld my minority judgment. So I believe that I have a lot to offer there in terms of ensuring that our jurisprudence grows, because if you have a situation where more and more judges are able to take a stand in regard to the principles they believe in, an independent stand, and assert it in the form of judgments, something that I've noticed has been very infrequent in the SCA. There are a few judges who've been doing that, but for the greater part, there seems to be a situation where you have judgments where all the judges are agreed most of the time. And I would wonder whether we will grow if people do not assert themselves. I wrote 2 minority judgments during the period of 1 year when I was there. And I felt that that's one area in which I want to make a contribution, so that then the culture must begin to develop, that judges must take an independent stand on issues and be able to articulate a stand. So that's the reason why I feel I'm glad to end my career there, because I have 5 years to go to my retirement. And I believe this is the appropriate time to make a move to the Supreme Court of Appeal.
Thank you very much, Judge Motley. Colleagues, let me just, before I hand over to the President, ask signification by those who want to speak or put questions to the judge.
Singh.
Dodo.
Over to you, President.
Dodo and Bofo.
Over to you, President.
Thank you, Chief Justice. Good evening, Judge Motley.
Good evening, Justice Maya.
I don't have many questions for you because we interviewed you very recently in April 2019
yes.
For a position at the SCA. All I'm going to ask you is whether there have been any relevant new developments in your career that you'd want to share with us since April 2019?
Yes, after the interview, in fact, shortly before the interview, the President of the Republic appointed me to assist Judge Makanya in the special tribunal. Is the tribunal that deals with matters of corruption. And after the interview and in discussion with Judge President Blambo, I went to Johannesburg to join Justice Makanya, who's the head of the special tribunal, to assist him to set up the systems. What I did there, I found that they had a draft. They drafted rules. But after Minister Lamola had published regulations, I then prepared a draft to amend the rules to bring them in line with the Act and the regulations. And I thereafter prepared for Justice Makanya to publish directives, practice directives, the first set of practice directives for the tribunal. And in the meantime, of course, I've been presiding on cases in the tribunal, including the Gauteng PPE. That's how it's known, but it's SIU versus Legla. I wrote a judgment which I delivered in December, and last week there were before me, some of them asking for leave to appeal. So
what would happen? Oh, sorry, have you finished?
Yeah, I just wanted to complete by saying that.
Yes, please.
We are appointed for 3 years, and our term ends in February 2022. Next February, yes.
All right. So if you were appointed for this position, you would continue until then?
Not necessarily, Judge Maya, because there are quite a number of matters that have been investigated by the SIU, which are running in the High Court. And some of my colleagues in the High Court have presided over matters of corruption. So it will not be difficult for the minister to find a substitute. And in fact, I believe that we have had one member, Judge Desai, who has since retired. And Judge Makaya was in the process of working out a representation to the president through the minister to ensure that we receive additional members to assist, because the SIU has indicated that there is a large caseload of matters that are now being finalized after investigation, which will be coming our way. But that would not stop me from leaving if I have to. As I said, there would be judges in the High Court who will step in without much ado. These cases are in the High Court, and they're being presided over by my colleagues there.
Okay. Is your health situation still under control?
Yes, it is. I have disclosed in the form that last year in August, I contracted this coronavirus. But fortunately, because I had the comorbidities, I recognized the symptoms quickly and I got medication. I never had to go to the hospital. In 8 days, it was already out and I was healed. Since then, I haven't had any problem.
All right. Okay. Thank you very much, Judge Martin. Thank you, Chief Justice.
Thank you.
Thank you, President. Honorable Singh.
Thank you very much. Good evening to you, Judge.
Good evening. Good evening.
Yeah, just two questions. One relates to your questionnaire. It's for the first time that I've seen a questionnaire with incomplete information. And if you look to items 13, 14, and 15, there is nothing at all that you've indicated there. The questions regard to publications, writings, and publications outside the field of law. Is there any reason why you've left that completely blank, or not even saying not applicable or whatever? Thank you. First question.
13, 14, and 15. Well, yeah, it must have been oversight, because in the one draft that I had, I wrote NA, 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 just like in 2019 when I came here for interview. The situation had not changed.
Okay, no, I just picked that up because it's completely blank there.
Yes.
Right. My second question relates to the question put to you by the Chief Justice and your reason that you've stated why you feel you need to go to the SCA. I want to put it to you that perhaps, like you said, because many of your judgments have been taken there and there's been, comments on your judgments, that it's payback time. I want to come there and show you guys how you should be doing your work. And I want to juxtapose that vis-a-vis the very, very important role you're playing in the special tribunal. And as we all know, corruption is cancer in our society. And do you not think that you could better serve the country by continuing on the special tribunal? And, who knows, that period may be extended to well after 2022, given the number of cases that are emerging at different fora, including the Zondo Commission. Thank you.
Thank you very much. The Commissioner, the special tribunal, the work that we do there, as I've pointed out, it is not specialist work. It's work that we've been doing even in the high courts. And I believe that I'm really not indispensable there. There are other judges who will step in and will be willing to assist. And as I said earlier on, I'm looking at the last 5 years of my career. I'm now 40 years in legal practice, and I had a checkered legal career, and I felt that I need to end it in the higher court, in the appeal court. The most important role I played in the special tribunal has been to set up the systems and the structures, that is the staffing and the procedures. I believe I have assisted Judge Makaya in that regard. He is also satisfied with it. All that remains is matters to be presided over, which judges in the High Court will be able to do. And or judges who are retired will be able to come in and assist. And it was never my wish to end my career in the special tribunal. I would like to make a contribution in the appeal court.
Thank you. Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable Dodovu.
Thank you very much, CJ. Good evening, Justice.
Yes, good evening.
Yes, I'm happy that you promptly responded to the science which made you to recuperate from COVID-19 infection. I'm happy for you.
Thank you.
Yes. Now, just tabulate for me at least 5 attributes of a good judge of the SCA.
Well, a good judge generally, and be it in the SCA, the Constitutional Court, or the High Court, should have judicial temperament, should be able to relate well with colleagues.
Just tabulate.
Yes.
Just list them, it's okay.
Judicial temperament, the ability to write judgments and write them well, the ability to function at the SCA in a team situation, especially coming from the High Court where you sit alone for the most part. At the SCA, you are one of the 5 most of the time, and you have to adapt to do that. And of course, the pressure of adapting to the system and culture at the SCA, in that you have to make sure that all your judgments are written and finalized before the end of term.
Okay. Okay, it's fine. You know, when I was growing up, I knew this attribute about judges, and I was taught that this is a good attribute, and I've not heard any judge talking about it. Can you just talk to me about that? An idiom that says, you are sober like a judge, which means that you are clear in your mind. You can see your way. And late people no longer talk about that. Well, what could be the reason?
I cannot speak. I cannot speak for people. I don't know why they wouldn't talk about that, because as far as I'm concerned, that idiom is still as relevant as it was before. And sober in my sense and understanding is that as an independent judge, you must be able to apply your mind independently without fear or favor, and also be able to have a sense of justice. And you must have a most important attribute. You must have integrity. That is our premium. Integrity.
All right, thank you, CJ.
Yes.
Thank you, Honorable Dodovu, even for the provocation. Commissioner Mpofu.
Thank you. Good evening, Judge Mutla.
Yes, good evening. Good evening, Commissioner.
How are you this evening?
I'm fine.
Thank you. Yes, no, I just wanted to ask you one thing. About the Timor inquest.
Yes.
Which you did, and I think the whole country was watching the developments there. But from a lawyer's point of view, if you could just share how, this was an apartheid murder that happened more than 50 years ago.
Yes.
And it was a matter where the evidence, even some of the witnesses had died and the evidence was stale and so on. So I have a special interest in pushing the boundaries of the law and taking new approaches. To what extent did you have to improvise, if you know what I mean, and deal with the special challenges that came with a matter like that, which is not your normal criminal case where you have a witness, this one did this, this one did that, or there's video evidence or whatever. That's the one part of the question. The second one is, we always say judges are human too. At a personal level, having to deal with something like that, which is like an apartheid atrocity of the highest order, how much of the judicial temperament that you're talking about, you had to tap into in order to deal with it, to try and distance yourself from to the extent necessary. Thanks.
Thank you very much, Commissioner Mpofu. When the judge president gave me that assignment, I realized early on that there was no precedent to follow. It was the first case of its kind in South Africa. And I knew, as I went through the motions, that every step I'm taking is setting a precedent, that there may be others to come, and my colleagues will have to follow that. So I took my time with everything. The first difficulty I had is that some of the documents had disappeared. And as you point out, some of the witnesses have long passed on. But what really was helpful was the full judgment of the magistrate was still there. And in that judgment, he had summarized the evidence of all the witnesses who testified before him at that time, including the medical reports by the late Dr. Lackman, who was representing the family. So those documents survived. And what was the fundamental flaw about that finding by the magistrate is that Mr. Timol was detained with a number of people who were held in the same cells in John Foster Square building. They were in the same cells and they were being interrogated in the rooms adjacent. Those people were never called and they heard what was going on. As he was being interrogated and tortured throughout, they heard every bit of the sound that came in there and the screams that came in there. And they were able to paint a picture together with the experts that the family called this time, who were able to reconstruct the body as they found it and the injuries that were post-mortem and those that could have come before he fell. And so it helped to give a balance, as well as the evidence of the members of the liberation movement, mainly the African National Congress, those who trained some of the witnesses that were still available. And also a strange thing happened while we were sitting. I received, as people were watching, the witnesses who were denying having tortured people during detention. The following day, I would get an affidavit from someone saying, this person interrogated me, he's not telling the truth, and he assaulted me during detention. Many evidence that, many affidavits that came in. The evidence was overwhelming. And that was the one part. The other part in maintaining composure in the face of all that was that when I started my career, I served articles under Maluleke, Siriti, and Moseneke. I was working a lot of cases with then Mr. Moseneke, the former, the retired Deputy Chief Justice. So I handled a number of political cases and I knew the extent of the torture of witnesses and political activists in detention. And I've seen photographs of people who died in detention during that time. So my mind went back to that period, and I was able to compose myself, and I kept telling myself, you've been here before. You have seen this happen, you've been here before. And I had to steady the proceedings to ensure that we were able to complete the work. The sad thing is that some of the people who came through during the hearing who also requested the reopening of their the death in detention of their next of kin, looked up to the High Court to open up additional inquests. And we had to explain that it was not up to the High Court to do that, it was up to the NPA to do that. And to this day, we're waiting on the NPA to come up with those cases. And so it wasn't easy, especially when I visited the rooms where they were being tortured. And in particular, the room where Timor spent his last moments. It wasn't easy. But I had to proceed and to finalize the matter.
Thank you, CJ.
CJ, a very small follow-up on this inquest question, if you don't mind. It's a very short one.
Yes, yes, JP.
Thank you. Judge Motley, you said your assignment of this Timor inquest was the first one. Now, what I want to check with you, subsequently, there was a Neil Agate inquest that's running in Joburg. I think it's about to be finalized, if not yet finalized.
Yes.
And the Esedimeni one has also been set up.
Yes.
The judges, they are both in Gauteng, one in Pretoria, one in Joburg.
Yes.
Have you been on hand to assist them?
Yes.
When they approached you?
Yes, indeed. I have had discussions before the inquest in Johannesburg started. I had discussions with the judge and I referred him to my report. And I shared.
And the one in Pretoria?
And the one in Pretoria, she contacted me by phone.
Well, I wanted that fact to come out, that it's one of the senior women.
Yes,
now running
she contacted me by phone.
Yeah.
And I sort of.
Thank you. If you've been on hand to assist and hand over
Yes.
skills, thank you very much. That's all.
Thank you.
CJ.
Thank you, JP. Thank you.
CJ Lamola, with your indulgence.
Oh, okay, Minister. I didn't have you down. Please proceed.
Yeah, no, I did not write. I just want to confirm what Judge Mudle just said about the tribunal. He has been very helpful there with Judge Bakaya, even in terms of the setup and the rules. And on these matters that he has just spoken about of the inquest, it was not an easy thing even from our side when we requested the JP, because we're worried about the information and so forth. But it does look like the matters are being handled very well. Thank you, CJ.
Thank you.
Thank you, Honorable Minister. Judges Wipara must say, I never had a chance to say, without going into any merits, I must say you handled that inquest with great wisdom and dignity. It was a pleasure to watch you dispense justice in the manner that you did. Thank you very much. You're excused.
CJ.
Thank you, CJ.
CJ.
Yeah, is that Honorable Malema?
I also want to thank the sober judge.
Thank you, Mr. Malema. Thank you.
You are excused, sir. Thank you very much.
CJ, the candidate is ready and waiting.
Thank you, JP. Good evening, Judge Rogers.
Good evening, Chief Justice. I mean,
How are you, sir?
I'm trying to look where the people are.
You won't find me there.
Oh, I see. All right. Yes, I'm apprehensive, but I'm as ready as I'll ever be.
All right. We apologize to you for keeping you waiting this long.
No, that's quite all right.
Thank you. For how long have you been on the High Court bench?
From January 2013, so I'm going into my 8th year now.
What about the Competition Appeal Court?
I was appointed permanently there in January 2017, so that's been about 4 years. I did act as an AJA there for several years before.
And for how many terms have you acted at the Supreme Court of Appeal?
My application says 6, but I am acting there currently for the first and second terms. So at the end of that period, it will have been 8 terms in total.
And tell us briefly how ready you are for the SCA.
In terms of being able to do the work and make a contribution, I believe I am ready. Through 8 terms there, I've found that I have been able to cope with the reading work, prepare well for appeals, work well with colleagues in finalizing judgments, also in dealing with the petitions that come our way. So in that sense, I am ready, I believe, and I do think that I can make a contribution there.
President, before you come in, President, let me just take the names of colleagues who are going to put questions to Judge Rogers. Colleagues?
Mpofu, Matonsela, Muimang,
Tepe.
Schlemmer.
Barnard?
I don't know whether you heard Schlemmer.
I wonder if it might be possible, just before other questions are asked, if I make 1 or 2 corrections or supplements to the information I provided.
Go ahead, Judge.
Yes. In the standard questionnaire in item 12, I omitted to mention an article that was published in 2019 in the Advocate. Its title was Argument and Opinion, Advocate and Expert, and it was a treatment of the ethical problems that advocates may have to confront when dealing with expert witnesses. In item 15, the book that I published, I'm sure it might have been more interesting if it was about a conspiracy in 1989, but it was in fact a conspiracy in 1895. In regard to the reserved judgments mentioned in 16.5 of the questionnaire, the Camps Bay judgment was delivered on the 15th of December, and the other 2 cases both on the 2nd of December. Yes, there are a couple of judgments I missed out in my list of cases, but I don't think you need to know about them. Thank you.
Thank you very much, Judge. President? President Maya?
I am here, CJ, sorry. Judge Rogers, good evening.
Good evening.
We interviewed you for the same vacancy just 2 years ago, so I don't really have any questions for you. I think you persuaded me that you are ready, to join the SCA, and you have a tremendous contribution to make, to the court then. I'll just point out that we have actually invited you back now for these extra 2 terms, precisely because of the contribution you make. And I know that you published a book in the meantime, Lawyers in Turmoil, which you just mentioned now, and I'm still struggling to finish it. I don't have time. It's a big book, but very, very interesting. Well done on this. I just want to raise one issue with you. This complaint that has been lodged against you by attorneys Pulu, Kulu attorneys, I'm not quite sure what they are called, with the JCC. Am I correct that its essence is that you refused Mr. Kulu's application for your recusal in one of his matters?
Yes, I don't want to, unless the Chief Justice indicates otherwise, wish to discuss the merits of that
To go into
complaint.
the merits, I understand that.
Yes, it's a complaint against 10 judges, of whom I am one. It arises it has its genesis in allegations that Mr. Kulu made in an affidavit for my recusal in a case where his firm was personally a litigant.
Yes,
and
that's all I want to confirm. Now,
if I can just,
yes.
May I just add that as far as I know, the complaint was submitted by Mr. Kulu in mid-February. The 10 judges have received no communication from the JSC about that complaint. I know informally from inquiry that it has been received, but we have received no communication about it. We haven't been called upon to answer it.
All right.
Or at least not yet.
Okay. Well, is there any reason why that complaint should stand in the way of your appointment? It is there. We may not know precisely what it's about, but it is there, and it's something that weighs heavily on one's mind. What should we do about it?
I'm personally absolutely persuaded that if you knew the circumstances and the facts, you would not attach any significance to the fact that the complaint has been lodged. It is against 10 judges. I am the second most junior of those 10. The other include Judges Davis, Meir, Bozalek. They are all judges of repute. We took great offense at allegations that Mr. Kulu made about us in an affidavit for my recusal. And in December last year, we lodged a complaint of professional misconduct against him with the Legal Practice Council. Although there was some delay, in March of this year, the Legal Practice Council has ruled that there's prima facie evidence of misconduct in accordance with our complaint, and Mr. Kulu has been called upon to respond to it. That complaint is before the LPC. The complaint that he lodged against us with the JCC came about 2 months later. And I believe very confidently that if I were able to tell you the circumstances, which I could do in a very few minutes, and which I would not dream of telling you one thing false, because this is a very public forum, you would be absolutely satisfied that you should not attach significance to it. But more than that, I'm really not in a position now to say.
Mm-hmm. No, that's enough for my purposes, Judge Rogers. Thank you. Thank you, CJ.
Thank you, President. Commissioner Mpofu.
Thank you. Good evening, Judge. I'm this side. Yeah.
Yes, good evening, Mr. Mpofu.
Good evening. Justice Rogers, I would just want to ask you one thing, but let me preface it by saying that, as a practitioner, maybe for the benefit of the people who don't practice in the courts, that I think it would be fair to say that the quality and quantity of your work speaks for itself, and it is of a very high standard. Now, having served the periods that you have mentioned here in the different courts, SCA, CAC, and then the High Court, you represent, at least to me, the opposite of what we said to one of the candidates in the Constitutional Court interviews. In that the kind of work that you have done would, in my estimation, be of some significant value to an institution such as the Constitutional Court. If I may ask you, I know it's an awkward question, is there a reason why you did not apply for the Constitutional Court and preferred the SCA? when at least this round there were vacancies in both courts as opposed to the last time you were here?
Mr. Mpofu, what I can firstly say is that I have no intention of seeking or putting myself forward for the Constitutional Court. I haven't acted there or been invited to act there, so I can't speak from personal knowledge. But my impression from speaking with people who have been there and from other anecdotal information, I believe my talents are perhaps better employed in a generalist court. I appreciate that now the Constitutional Court can hear non-constitutional matters of public
General
public importance. But nevertheless, the fact remains, for example, that the majority of generalist work will be decided at the SCA. And I feel that my skills are more suited to that. I work quickly through a lot of material. Although I did a certain amount of work in the public law sphere as an advocate, and I've done my fair share of reviews as a judge, I wouldn't say that at the bar, when somebody was looking for a top person to go to the Constitutional Court, I don't think my name wasn't the first on their list. And perhaps I've got less of a feel for it than I do for the general work.
Okay. Thank you. You do appreciate, though, that obviously you do that the Constitution permeates any other work, even the work that you'll be doing in the SCA. But I get
I perfectly understand that.
Yes. Thank you. Thank you, Sir.
Thank you, SC. Commissioner Madonsela.
Thank you, Chief Justice. Good evening.
Yes, good evening, Mr. Madonsela.
My question actually is related to the question that Mr. Commissioner Mpofu has asked you. The question is really, now that we have in the hierarchy of appeal courts, we have the High Court, sometimes the full bench is an appeal layer, the SCA, and then the Constitutional Court. What do you regard the role of the SCA to be in the hierarchy of appeal courts? And how would you feel that role?
I would, in practical terms, it will be the final court of appeal in most cases. But on matters of general public importance or on constitutional matters, it may very well serve as an intermediate court of appeal. In its function as an intermediate court of appeal, I think one of its tasks would be to present judgments which crystallize the issues as well as possible, because even if the SCA's judgments in such matters are not the final word, I think they can provide assistance to the Constitutional Court when it decides. And I think it's probably particularly important in the kind of case that may go further, that one should have at the SCA judges who are sufficiently strong-minded to, if necessary, state their opinion separately or dissent. Because if it goes further, those views in particular may be important, even if they're not upheld. So I certainly don't see that the SCA, like all courts, it is, as Mr. Mpofu pointed out, all law, common law, customary law, all of it finds its force now in the Constitution, and it does permeate everything, and it permeates the SCA's work as well. But the SCA is not likely to be the final word on the big constitutional questions, but it has an important role in perhaps getting rid of superfluous issues in the lower courts and presenting what is really the important matter for decision by the Constitutional Court.
The second question relates to your, please indicate if you can't answer this question for the reasons that you have explained earlier in relation to the other question that the President asked you. In the Western Cape has had its problems. I'm talking about Western Cape High Court. And there was an occasion, this was, I'm so sorry to just, There was an occasion when certain judges of the Western Cape refused to sit with another judge of the Western Cape. Were you part of that group?
I was.
And do you think that was appropriate?
We believed in good conscience that it was. We found ourselves in an impossible position. In subsequent, there was a complaint that was dismissed by the JSE, subsequently made against us for doing this by a Mr. Thabo Mkwakwa, who's quite an active political commentator on Twitter, but he lodged a complaint against us, and that complaint was dismissed. In responding to that complaint, we recognized that views may differ as to whether it was a position we were entitled to take. We felt we were entitled to take it. I accept that views may differ on that. In reality, what happened is that after we expressed that position, the judge president wrote to all the judges stating that he thought our attitude inappropriate, and he trusted that if we were allocated with the judge in question, we would not refuse to sit with him. Perhaps some real politic prevailed, because subsequent to that, he never allocated any of us with the judge in question. So push never came to shove. But what I can assure you is, and I think you know from the caliber of, I don't talk now here about myself, but Judge Desai, Mir, Davis, and others, Bozilik, we wouldn't have adopted that position unless we felt strongly in conscience that it was the right thing to do.
I have a limit of 2 questions. Thank you. Thank you, Chief Justice.
Thank you, SC. Honorable Muimam.
Thank you, Chief Justice. Good evening.
Good evening,
Judge Rogers. I just have 2 questions. The first one, if my memory serves me well, you refuse to interdict the swearing. You refuse to grant the interdict to prevent the swearing in of cabinet ministers following the late night reshuffling. I think it was in 2017.
Yes.
If you could probably just give a reflection as to why did you refuse? Did you think that it was going beyond what the court can do? And then the second one relates to the, if my memory also serves me well, I think the matter that involved the Democratic Alliance Motraining SABC, where the order was that for the board and also for the investigation to take place, the former CEO, Mr. Motraining, must be suspended. If you could probably just give a reflection to whether was that the role that the court was playing in terms of promoting good governance in the second instance?
Yes.
Thank you.
In the case of the cabinet reshuffle, as I recall, the cabinet was due to be sworn in later on a Friday evening, and I recall that I was the senior of 2 duty judges, and it came before me as an urgent application. And given the nature of the case, I made sure that the other duty judge who's now Judge Villa, sat with me. So we heard it as 2 judges. We had very limited time, but my recollection, I think that was a case that arose at some stage after the judgment of the Constitutional Court in the Otto case, where the Constitutional Court emphasized the strict limits on interdicting executive action. It seemed to me that the presidential act, or the act of selecting your cabinet and swearing them in, was so close to the heartland of executive action that it would take extremely powerful evidence. I didn't discount the possibility that with a smoking gun of fraud of some kind, one might be able to do something about it. But I felt it was really the sort of area where you'd have to have exceedingly powerful evidence. And on the limited facts we had, it didn't rise nearly to that threshold. I'm afraid my memory has gone a bit dim on the case of the DA versus Mr. Motsoeneng. That was again a case I sat with Judge Lekranji, and we refused leave, and as far as I know, it was not in fact taken any further. But except that it was clear that there was widespread rot in the senior echelons of the SABC. I haven't revisited the judgment. I think in a position like that, where one is dealing not with the president and his cabinet, but with a parastatal organization and the conduct of its senior executives, one is some distance removed from the heartland of executive power. And the evidence was certainly powerful enough there to justify the court's intervention. It was a review application. It wasn't, I think this is the other thing, it wasn't an interdict. It was to finally determine whether what had happened was lawful or not.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you, Honorable Moema. Commissioner Tsepe.
Thank you, Chief Justice. Good evening.
Chief Justice, Minister Lamula here requests to be added.
Thank you. Good evening, Judge Rogers.
Good evening, Ms. Chair.
Lovely to see you. Judge Rogers, I have two questions for you. The first one relates to item 20, which is in page 10, about your current position on the Competition Appeal Court. You say that you want to retain that position, or you're hoping to retain that position. I wanted to understand, why would you want to do that? Yeah.
I think it's been a problem with the Competition Appeal Court from inception, that it has lost good people to higher courts. Judge Dembuza, Judge Milan, Judge Zondi, Judge Mshlantla, a number of them have gone on, Judge Chiki, have gone on to higher courts. I think it's unsatisfactory that you have a Competition Appeal Court where within a matter of 2 or 3 years, you might lose good people to higher courts. But at the same time, I don't think you will attract good people to the Competition Appeal Court if you say, well, since you're there, the path is closed to you for any further promotion. So when I said what I did in item 20, it was not that for my own sake I desired to hang on to doing competition appeal work. It was that for the sake of the continuity of the court, I would be willing to take on 2 or 3 appeals in the Competition Appeal Court annually. And as I say, my assessment of the workload of the SCA is such that I think I would be able to do it if it were scheduled during recesses. Obviously, it would need to carry the SCA president's approval, and there may be a statutory provision which needs to be amended. I think at the moment the Competition Act says that a judge of the Competition Appeal Court must be a judge of the High Court. I had always understood that one was dealing with a case of the more includes the lesser, in the sense that, well, you have to at least be a High Court judge. That might be wrong, but I think it could be clarified so that judges in the SCA could, with competition experience, could from time to time sit in the Competition Appeal Court, and that is certainly something I'd be willing to do.
Or we shouldn't have amended the Constitution to take away the jurisdiction of competition matters from the SCA. And that was an aside, Chief Justice. I apologize for preambles. I know you don't like them. Just the last question, it relates to, I've noted the work that you do and quite grateful regarding training of advocates at the bar that you continue to do, and even the letter from the bar to that effect. What I wanted to find out from you is if there is any work that you do in terms of transfer of skills to judges, particularly Black judges and women judges in particular, in the work that you do.
I think it would obviously be paternalistic to take the initiative in anything of that kind. But I've frequently been approached by judges, including Black judges, both in the High Court and in the SCA, several occasions in the SCA, black judges have asked, who are the scribes, have asked me to review their drafts before they are circulated. And that also happens in the Western Cape. And I think people know that my door is always open to debate issues, and I do a lot. It's not a formal program of skill transference, but insofar as commenting on people's judgments and in that way, or debating issues with them without actually looking at their draft, I do that. And I can say I think from comments I've received and from encouragement I've received from African colleagues, for example, in the SCA, I believe they find that I'm able to do it in a way which doesn't appear condescending. And I'm able to raise my comments or suggestions or changes in a way which doesn't give them any offense.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you, Commissioner Tsepe. Commissioner Barnard.
Thank you, CJ. Just quickly, Judge Owen Rogers, I've seen in Carter matter, banking matters, you also referred to some other matters, and I've observed in court when you dealt with, still in the Cape High Court, even matters where the attorneys or the advocates are maybe on the wrong side of the law, you have a way of treating them with quite a dignified manner. What is your philosophy about litigants and particularly young practitioners that appear before you?
I think the days where there were judges that advocates were afraid of appearing before is not remotely compatible with the democratic era. It doesn't promote the administration of justice. Obviously, the more senior advocates, one can perhaps engage in debate in a slightly more robust way. But junior advocates or even more senior advocates who are diffident or not lacking in confidence, I think one must treat all people with dignity and respect, and particularly those sort of people need particular care. And if I may say, it also extends, as often happens in high court work, to litigants who appear in person, particularly in bond foreclosure cases. One often has the person whose eviction is sought appearing in person. And I think the way one deals with those litigants is also important. I also think it extends not only to how one deals with people in court. I think it also goes to what one says in one's judgments. I don't think there's ever cause to be cutting or derogatory about a judge in the quota quo or about an advocate in the case. All people will realize where they've gone wrong if they get overturned. It doesn't require any nastiness, and I don't think it has any place.
Thank you so much for that. Thank you, Chief Justice.
Thank you, Commissioner Barnard. Prof.
To your right, sir. Good evening.
Evening, Professor Schlemmer.
It's nice to see you. I think I was present at one of your very early interviews in the early 2000s and whatever it was. In any event, when I read your judgments, I'm quite impressed by the additional type of research that you do. And to that extent, I would like to know, we've heard from some of the other judges that they have to pay for their own access to data or to information. I see you are a member of the library, or you are responsible for the library in the Western Cape Court. Are the libraries in the Western Cape at the SCA sufficiently equipped to assist judges nowadays to be able to do proper research and to write scholarly judgments, as I like to call them?
The Western Cape has its own. I mean, we haven't had a qualified librarian in the Western Cape for about 6 years. So we have an administrative assistant who's effectively running the library. So when the selection of new books is something that falls to me, and budgetary constraints are obviously there. In the SCA, I have not served on any library committee. I've obviously use the library a great deal. I don't know how much better their budget is for purposes of acquiring material. I think they have from my recollection of the SCA library, they have a far more extensive collection of journals. Probably, strangely enough, a less extensive collection of up-to-date textbooks than the Western Cape High Court, but a better selection of journals. I think a great deal of the research that one does, as you know, there's just so much information now available on Safley and Bailey and Orstley and Canley. One can get at least all the law reports from around the world at the click of a button. Sometimes if there's an article that you want to read, you go online, you find, well, somebody's put it online and it's there. Otherwise, a researcher can, I've never found in the SCA, I haven't called for obscure material very often, but when I have, it's always been produced. I think they have arrangements with the Constitutional Court to get material.
Okay, so in essence, you think there is enough material available?
Yes.
Thank you very much. I'm covered, CJ.
Thank you, Prof. Honorable Minister.
Thank you very much, CJ, and good evening, Judge.
Good evening, Mr. Lamola.
Yeah, I see you want to take the Queen's badge from my silk colleagues here on my left, Commissioner Mpofu and Commissioner Madonsela. I want to ask you about this article that you wrote about the silk status. There's a striking paragraph there that strikes me very hard, because in one of the arguments you argue that one of the difficulties with the silk status, why you argue that it must be removed. I don't know if you still hold that argument, because it was in 2004 firstly, you might have changed, but you speak about the selection criteria, which is a bit difficult and so forth, which is what we are currently grappling with the Legal Practice Council and all the bars across the country. What do you think? Why do you think this silk status must be taken away if it's still your view? Do you think it can help us with transformation of the legal profession?
I'm doubtful of that. My personal view remains that I don't think that silk is a helpful system, but I've long since given that up as a serious topic to pursue, because the vast majority of members of the bar are in favor of keeping it. In regard to the criteria, I suppose it's a little bit like the work the Judicial Service Commission has to do. You have to evaluate people. But I think it's invidious where some advocates, say 10 or so senior advocates at a bar, effectively are evaluating their colleagues as to whether they are good enough to get a certain status. And I just find, I served on a silk committee 3 or 4 times, and I found it dreadfully difficult to apply. There were people that you liked, maybe you didn't know enough about them, but your impression wasn't that they were sort of above the ordinary, which is more or less what silk is meant to be for. I think as a means of transformation and improving the representativity of Black people, and particularly African people at the bar, and for that matter, women, I think there are other mechanisms that are likely to be far better than silk. And I think that has to do with training, financial support to help young advocates bridge the 2 or 3 years when they start out at the bar, when the income may be little, until they are on their feet. There are other briefing initiatives. Unfortunately, I know these initiatives have not been spectacularly successful, but I suspect that if you look at because I was asked at my last interview about the Cape Bar, I got information from the current chair of the Cape Bar, and it still looks depressing when you look at the demographics across the whole bar, which is about 494 members, I think, in the Cape, or even just the non-silk members, who I think are about 380. Unfortunately, what one doesn't see are the statistics for the demographics of people who have only been at the bar 10 years and people who have only been at the bar 5 years. Because when I look at the pupillage intake at the Cape, for example, about 60% of the pupillage intake this year, or sorry, that was in 2020, were black. And I expect that the representativity is improving at the lower rungs of the bar. But there are a lot of people, 20 or more years of experience, who will carry on practicing till they've been 40 or more years at the bar. That's not going to change by the sorts of initiatives I'm talking about. What we should be directed at getting young women and black people, particularly African people, into the bar and staying at the bar. That's the important thing, that they shouldn't fall away because they don't have money to survive.
So don't you think the reason the practicing advocates or the profession does not take this debate forward is because they want to preserve the status quo?
I don't think that, you mean specifically silk or transformation initiatives in general?
The silk one in particular, because I mean, one of the objectives of the Legal Practice Act was to fuse both professions and to come up with a number of initiatives. Some of them is what you're talking about. So as you're saying, there is no appetite for this debate. Is it not because you think they just want that whatever that is there must remain like that?
I've been out of bar administration for about 15 years, but from the information I have, the transformation committee at the Cape Bar, for example, I think is 12 people, and I think 8 are black people, not all African people, but black, and the rest are white people. The Silk Committee is likely to be that's the committee which assesses the silk applications and applies the criteria and makes recommendations to the Bar Council. And in my experience, the Bar Council always accepted the recommendations of the Silk Committee. That Silk Committee, in my day, and that was in 2004, was at least half black. So if senior practitioners are using it to keep other budding senior counsel out, it's across the board. But I personally don't think that is happening. I think the bar knows that it would be better off being able to show more people, more black people and more women coming through as silks. I think they know that it's a point of criticism. I don't think they're trying to keep them out.
Okay, no, that's fine. Maybe if you want to answer, you could still. I can state that on my table as we speak, I'm sitting with the silk that I'm processing for the president, and they are still depressing as they were depressing when you saw them so many years ago.
Yes.
Thank you very much, CJ.
Thank you, Minister. Judge Rogers, thank you very much, sir. You're excused.
Thank you very much.
Feel free to take off the mask.
Of course.
Are you well?
Very well, thank you.
Please accept our apologies for keeping you waiting until now. We're really sorry.
It's okay. I'm used to the graveyard shift.
Tell me, for how many years have you been on the bench now?
It'll be 11 in July.
And,
10 in July. 10.
Okay, all right. And how many terms did you act in the Supreme Court of Appeal for?
I've acted there, I think, for 7 terms.
Okay, just in your own words, tell us just how ready you are and why you should not be left out of the list of those to be recommended for appointment.
Well, I started off at the bar at the age of 24 because I couldn't get articles at that time, although I applied to 42 firms. They all wanted to know when I was going to get married and have children. So I then went straight to the bar, where I practiced as a junior counsel for 18 years, and then I was a silk for 15 years. So I was at the bar for 33 years. I believe that I will bring a lot of experience to the SCA. I have dealt with virtually every kind of matter possible, both in my practice and while I was on the bench. I began acting, in fact, in 1995, and I acted every 2 to 3 years for a period of time. So I gained a lot of experience on the bench as an acting judge in the Gauteng, well, it was then the Transvaal Provincial Division. It's now the Gauteng Local Division. So I have had a lot of experience in various aspects of the law. In fact, most of the ones that we deal with in the SCA, I have dealt with as a silk at the bar. I also went through and understand the gender issues that permeate the profession as a whole. I was just looking at some stats, and to date, the bar consists of 30% females. And with the SCA, since 1991, when Leonora van den Heerfer first served, there have only been 14 female judges out of 55. So I understand those sorts of issues. I believe that I bring, as I said, experience in various aspects of the law. I'm an accredited arbitrator and mediator, and I've used those mediation skills, in fact, in case management meetings that we have in our division, and settled the cases before they even have to go to trial. My practice at the beginning consisted mainly of pro bono work and pro deo work, which I did for many years, because there were only 6 women at the bar at that time, out of, I think, 250 men. And it took quite a while for me to work through all of those issues, being recognized. I did not want to only do family law, as is what happens with women at the bar. So I was a pioneer, I think. I strived endlessly for the rights of women and blacks juniors when they joined the bar. I have always worked towards racial and gender equality. It's been a real passion of mine throughout my career. And I believe that I would bring that sort of experience and those sorts of issues to the SCA. I'm also very proactive in the sense that, as the JP will hopefully concur, I changed or suggested to the JP that there were certain aspects of the practice manual that had to be changed. For instance, dealing with evictions and foreclosures, when there was no personal service, people were being evicted, having their homes taken away, when where there were just no rules being followed. And we formulated a totally different practice in regard to foreclosures and evictions. And it formed the part of the practice manual, which then the Rules Board adopted and now appears as Rule 46A. I also launched the pro bono office at the Johannesburg High Court in collaboration with the JP. And it serves for people who appear in court who don't have legal representation, and they can go down to that pro bono office. So basically, I feel that I have worked hard as a female. It took me a long time at the bar to succeed. As I said, there were only 6 women when I went to the bar. And I believe that I have been very, hopefully influential in attracting other females that came to the bar, and I'm very interested in training, as you would have seen from my application. I was the convener of the Advocacy Training Committee for the General Counsel of the Bar for 10 years. I developed many programs. I've done judicial training as well, both at the High Court and for aspirant judges, both on Judge Schwartzman's program and Judge Matopo. And I continue to this day to do advocacy training for juniors at the bar, for middle juniors, and for senior members of the bar. And I'm really passionate about the training and the building up of skills that will help in our courts.
Colleagues, may I have a list of those who would like to put questions to Judge Weiner, please?
Sigogo.
Madonsela. Mpofu.
Lucas.
Singh.
Thank you. President, over to you.
Thank you, Chief Justice. Good evening,
Where am I
Judge
looking at?
Weiner.
She's
No,
online.
I'm not there.
I
Look
know,
at the
but-
screen.
Oh, there you are. Sorry. I didn't see you there. Good evening, President.
I've been asked to limit my questions, so I'll ask you only one.
Yes.
You are 67 years old, although one just can't tell by looking at you. You look so good. Should that be a bar to your appointment, your age, that is?
Well, I think that it's all part of the diversity and inclusion debate. And what has happened is that age has become the one issue that no one pays any attention to in regard to discrimination. So I believe that I will bring to the bench, although I only have 5 years left. I have the experience, and as a mother and grandmother, and I have the compassion and maturity and candor, and I believe the wisdom that comes with age. My age is now also the fact that I'm only applying now is, as you know, I first acted in the SCA in 2019, and unfortunately there was no vacancies advertised in 2019, and then last year was COVID, so I'm 2 years older than I would have been then. I do believe that in the 5 years that I have left, I can contribute a lot. I do have the feelings of a mentor, and I'd like to help out. I've done the judges training, diversity training, and I've already helped out colleagues in the SCA who are acting and who have come to me with certain issues. And it's interesting because only last month, the United Kingdom has changed the retirement age for judges to 75. So one should hope that it would follow through, because aging is really just a state of mind. And I think that the intergenerational collaboration that would occur from having a diversity across age, gender, race is a way in which the judiciary can be strengthened. So I hope that in those 5 years, I would be able to contribute both in the sense of my judgeship and also in the sense of assisting acting judges and anyone else who needed my assistance. And one must just realize that age seems to be the final frontier of discrimination, which is also unconstitutional. And, you know, one has to look only at people like Ruth Bader Ginsburg, who sat until she was 86 and wrote the most scholarly judgments. Her dissents were fantastic and led to a lot of legislation being changed. So, and we have actually an example in our court, because last year, I think, no, in 2019, Justice Glodlaw was 67 when he was appointed. So I believe that I can bring both age in respect of wisdom and experience, as well as the gender issue, because there are still gender issues in the transformation of the judiciary.
Thank you, Judge Wiener. Thank you, Chief Justice.
Thank you, President. Commissioner Sigogo.
Thank you, CJ. Good evening.
Good
and
evening.
How are you?
Fine, and you?
My question as well is on your age.
Yes.
And maybe on a different perspective.
Sorry, just could you repeat that?
On a different perspective.
Yes.
Taking into account that if you are appointed and you are to leave very soon because of your age, this commission will be forced again to sit and consider another person. And another aspect will be, we believe when you go to the SCA, your salary will be increased, and when you go to retirement, you will go to retirement with a new salary, and you will have worked for this new salary, which will take you to retirement for about 3 or even if less than 3 years.
No, I'll work still for another 5 years. I have 5 years left to retirement.
Okay, so for these 5 years, so
yes.
And
I've acted for 2, so
do you think
7 years
that will make financial sense, taking into account our struggling economy for now?
Well, I suppose that's a good question. If I was going for 1 or 2 years, but there are 5 years. I mean, you people have all been sitting up for 2 days. That's long. Imagine how long 5 years is. And I think I can achieve a lot in 5 years. I think that 5 years is actually a lengthy period of time, and it will also make room for a younger, maybe less experienced judge to come through at that point after I've served my 5 years. It's the mandatory retirement age, as I say, and I would certainly be willing to work on later than that, because I don't believe that my contribution is only limited to those 5 years. At the moment, that's the mandatory age for retirement, but perhaps we'll follow the UK way and extend the mandatory retirement age to 75, or even let judges sit some for life as they do in the USA. But I don't think that's a good thing at all. I think there does come a time when one needs to retire and step aside, leaving room for others to then fill our places.
CJ, thank you. Thank you very much, Judge.
Thank you.
Thank you, Commissioner. I can't resist the temptation, Judge Weiner. A colleague of mine in the US told me of a judge in the Ninth Circuit Court who's 99. He puts a question to counsel, he gets an answer and says, who asked you that question? So, being a judge for life could be problematic.
I haven't reached that stage yet.
Advocate Madonsela.
No, my only question was on age as well. I mean, it has been covered fully by both the president and my friend, the commissioner, Mr. Skoko. Except to mention that Judge Weiner, you have really to note that and confirm that you have really contributed a lot in trial advocacy. I was there all the time throughout all the programs, and would like to thank you for that. Yeah.
Thank you.
Chief Justice, I've just got a small follow-up on this age question.
Yes, sir. Yes, please go ahead, JP.
Thank you. Judge Weiner, there's a view that in the judiciary in particular, the older the judge gets, the more resourceful and productive they are. What's your response to that?
I agree with that. If I look in our division, for instance, the older judges contribute an enormous amount. They do a lot of the training, the lecturing. They have got the experience. That is, it takes a long time to get the sort of experience where you feel comfortable dealing with virtually every sort of case. You also feel comfortable if there is something unusual in a case in going to another colleague. Whereas when you're very young, you don't want to appear stupid. So you don't want to go and ask colleagues about certain things. But I have absolutely no qualms, both in the Joburg court and in the SCA. If something is complicated or I'm struggling with something, I will go and ask a colleague for assistance. And I think that's something that comes with age and wisdom and...
Okay, thank you, Judge Weiner. Thank you, CJ.
Thank you, JP. Advocate Mpofu.
Thank you. Good evening, Judge.
Good evening, Commissioner Mpofu.
Yes. Yeah, well, you'll be happy to know I'm not going to ask you about age.
Thank you.
Yes. What I really want to highlight is this. I mean, you and I have known each other for a long time. 26 years ago, we traveled to London to be trained in advocacy skills. And we were the guinea pigs, the first group of people to be trained in, and then we had to come here and train other advocates and judges and so on in things like the art of cross-examination and other skills. Now, you've been involved in that work since that time. Since
1996,
until January 1996.
Yes.
I know this because Bafana were playing their first game in AFCON, which I missed.
Well, I went to the final in that year.
Yes, so did I. But I just want you to talk about the contribution that you have made personally. And, it's a lot of sacrifice in transforming the lives of young advocates and old ones for that matter. In that particular field. But the more pointed question is whether in your 11 years as a judge, you've been able to effectively see the fruits of your labor in enhanced advocacy skills from the bar, as it were, and whether you are able to recognize the quality changes. And also whether that experience of advocacy training has assisted you as a judge, not just observing others. And I said I'm not going to talk to you about age, but I am now, which is that I just want to say, knowing the kind of training that you've had, and I'm just amazed at one of the key things is preparation, of how well prepared you were on this question of age. It's clear that you are anticipating it, and you've made very good points, including the fact of actually pointing out that it is actually one of the criteria for discrimination. yesterday we were saying here that Section 174(2) of the Constitution only talks about race and gender, and I think you rightly say that there could be other factors
Yes.
for diversity on the bench. Thank you.
Yeah, so
Your observations on the bench?
Oh, on the bench, yes.
Of the advocates first, and whether it has assisted you.
I have definitely noticed a difference. You can actually see when someone's been for advocacy training and when they haven't. I mean, all pupils have to be trained. So we've trained pupils for the last 20 odd years and have seen those pupils, and then they come to, we've got advocacy training junkies, if I can call them that they come to the first pupillage workshop and they can't wait for the next one, which is for baby juniors. Then there's one for middle juniors. Then there's one expert workshops, and they just keep going and just keep coming to these workshops. And it has been simply amazing for me to look at the development of these young people who have turned their lives around literally, because they arrived absolutely green and have devoted themselves. And a lot of those who we've trained over the years are now advocacy teachers, because we've trained them to become teachers, and they then train the younger pupils as well. So I have seen a big difference, and it makes an enormous difference as a judge when you have excellent counsel in front of you who've prepared well, who've done proper heads of argument, who are asking the right questions in leading a witness and asking the right questions in cross-examination, such as, they must never say in cross-examination, I put it to you. So yes, I'm very proud of and passionate about the advocacy training that I've instilled. I did, for 10 years, I was the convener for the GCB, and I did develop many programs for pupils, juniors, and experts. I went to many workshops overseas at my own expense, and brought back some of the teachings, and have involved many colleagues that you have met as well, Mr. Mpofu, from the English bar, the Hong Kong bar, Malaysia, Australia, Ireland, Zimbabwe. So we've also trained around the continent. We've trained in Zimbabwe, Botswana, Lesotho, and we've had Kenyan judges here at our workshops. So it is an incredible group of people who are advocacy trainers, because we all do it for nothing, and just for the love of the profession and the love of excellence in the profession. So it's one of the things that when I started doing advocacy training, it suddenly became a real passion for me, because as you know, as an advocate, we literally live in mortal combat every single day. We're fighting someone all of the time. And with advocacy training, we're actually encouraging and creating excellence, and not seeing people being brought down. We're seeing them being lifted and rising. So it's been one of the most satisfying parts of my career.
Well, thank you for all that work. Thank you. Thank you, Chief Justice.
Thank you, Senior Counsel. Honorable Lucas.
Thank you very much, Chief Justice.
Yes.
Good evening, Justice Wana.
Good evening, Commissioner.
I think I don't want even to speak about your age, just to say that you are well preserved.
You know what they say, wine and cheese get much better with age.
Something like that. So, but the issue that I wanted to raise is to say that with your age, your wisdom and experience, the issue of mentoring, I think, is something that become very important.
Sorry, just repeat that, the issue of?
Mentoring.
Mentoring, yes.
And you have raised it. And even the fact that I can see that from time back, even in your write-ups, that really there is activism in making sure that you empower women, and young women in particular. So
yes,
I have been consistent asking candidates this around these issues, and particularly around the gender divide. And so, because I must say that, and it's not deliberate that I ask the women or the female candidates, because I must say one of the male candidates yesterday, in fact, I was quite impressed with his compassion for the
Yes.
fact that we need to really develop our women, because like you have, the stats that you have raised is even a confirmation of what we've been speaking about.
Yes.
So I want to just to commend you on the work that you are doing, and I really think that you still have a lot to offer. It's just that I don't think if I reach that age, I would still be so active the way you are. Thank you. Thank you very much.
If I can perhaps just answer that, and also to say that I am very involved with gender-based violence activities. I've given a lot of webinars on it, and we've there needs to be cooperation between the police, between the lawyers, between judges. And I strongly believe that there should be gender sensitivity training for judges and magistrates, because the way in which victims are made to go through secondary victimization in courts is simply unacceptable. And it's one of the things that I have suggested. In fact, I'm in contact with, and I'm going to speak to Sajay about it, the trainers who are at Women and Men Against Child Abuse, and they run training courses for people who have to deal with these sort of things. And it has to be a combined effort between the police forces, between the judiciary, and the prosecutors. And I believe it's really essential if we're going to tackle gender-based violence at all.
Honorable Singh.
Thank you very much, Chief Justice, and good evening, Judge Weiner.
Good evening,
I
Commissioner.
see there's been a lot of reference to age in the questions that various commissioners have asked you. I just hope President Maya will pass the same compliment to me that she passed to you, because I'm born in the same year as you.
You look very
so
good for you. You look very good for our age.
So let's leave that aside. I just want to ask you, with regard to judgments that have been successfully appealed, you've listed 4.
Yes.
Are there more judgments that have been successfully appealed, and how did you react to these judgments that were appealed successfully?
So far as I'm aware, there are only these 4. I think that Judge Wallace was in 3 of them. So I reacted in the way they were quite seriously complicated matters. The first one was about Section 5.3 of the Admiralty Jurisdiction Regulation Act. Now, in Johannesburg, we don't deal with maritime law. So this was a special case where they were dealing with security for costs, which is why it came in front of our court. The appeal really went on whether the onus was discharged on a certain issue. I said it had been. The appeal court said it hadn't. In fact, there was Judge van der Merwe dissented on that matter, and I congratulated him on his dissent. Then there was the Faria case, which was quite complicated, because it was an RAF matter where there'd been a joint minute by the experts agreeing that general damages were payable. On the day of the trial, the RAF objected to the RAF 4 form, saying that they were not accepting it. And at that stage, the Duma case had just come out, which said that basically the RAF can object up until the last minute. But what had never been decided was what happens when experts have signed a joint minute when they agree. I found that having done that, the RAF couldn't come at the last minute and say they are now objecting. So what the court found was that neither in Duma nor in another case was the fact that there was a joint minute prepared by experts from both sides agreeing. And so but they did find that the RAF could take as much time as it liked, but this led to the regulations being revised, and that in terms of the revised regulation, the RAF is given 90 days within which there was no period before, he was given 90 days within which to accept the serious injury case. Then there was Benhouse Mining, which was a tax case. I found one way, the justices of the Supreme Court of Appeal found another, as there hadn't been a proof in terms of Section 36(7)(c) of the Act. It was just after I was coming for my first appointment, and when I met Judge Davis, and I said to him, very nice way to welcome me by overruling my judgment. And he said, sometimes judges go wrong. So I said, which judge, you or me? And then there's the last one, was State versus McQuena, where there had been non-compliance with a certain provision of the Criminal Procedure Act. And I referred the matter, I found that there was non-compliance, but referred the matter back to the same magistrate. And I was overruled on that point, that it should have gone to a different magistrate. So those are the 4 cases as far as I'm aware.
Thank you very much. I'm very glad that you take these appeals in the spirit, the upholding of these appeals in the spirit in which is intended.
Absolutely.
My second question relates to these allegations by a newspaper where the JSC was involved in the spokesperson. Can you just lead us a bit into that?
You're talking about the Raymond Challam case. Well, in that case, there was a headline, in fact, in the Sunday Independent one Sunday saying the judiciary is corrupt. The informant to the journalists was Raymond Challam, who had tried to become a judge. He came before this body, I think in 2013. He was rejected, and he then started accusing both the JSE and various judges of being biased and corrupt. He then, so that was their source. I might say that Mr. Challam has now been struck off the roll of attorneys inter alia for these statements. He spoke of various judges. My incident was he had come before me in a defamation case, and the other side pleaded qualified privilege because the defamatory remarks had been made in affidavits in the court, in correspondence with the Supreme Court of Appeal, correspondence with the Constitutional Court, because he kept taking these matters on appeal. It went on for about 5 or 6 years. They came in front of me, he came in front of me, and the other side was taking the point of qualified privilege. Mr. Challam walked in with documents from the floor up there and wanted me to read each and every document to see the defamation that had been committed against him. The other side argued that qualified privilege, if that succeeded, then that was the end of the matter. So I then decided, I said, I will hear the qualified privilege issue. If I find that it's not a situation of qualified privilege, I will hear all the evidence. I found that it was a qualified privilege matter, and I dismissed the claim. And I wrote a judgment on it, which the Sunday Independent didn't look at, so they didn't actually know what had happened. It's not so much that he accused me of corruption, but he basically said that I'd taken the file and that I didn't refuse to listen to him, and I therefore shouldn't be a judge because I don't listen to parties. You know, the letter was written. I spoke directly, immediately to Justice Malamba, and in fact, I was acting in the Supreme Court of Appeal at the time, so I spoke to President Meyer, and a formal complaint was made with the press ombud by the JSE spokesperson, Mr. Ndubi, and everything was set out in the formal complaint. The response was that the IOL, that's Sunday Independent, etc., had withdrawn from the Press Council, and therefore there was nothing that the Press Ombudsman could do. I took advice from certain of my colleagues, including the JP and Justice Meyer, President Meyer, and other judges, and as to whether I should sue for defamation, and they all just advised me to step back from it, don't get involved in this sort of thing, and that very soon it would be discovered that Mr. Challam actually had certain challenges. And I adhered to that advice, and subsequently he was struck off the roll. So that's the incident that I refer to in my application.
Thank you very much for clearing that. Thank you very much, Judge Weiner, and thank you, Chief Justice.
Thank you.
Thank you, Honorable Singh. Judge Weiner, thank you very much. Once again, apologies, and you are excused, ma'am.
Thank you so much.
CJ, should we take into account that she supports Liverpool?
Terrible.
Is that a
Wrong
good
team that's going to go against her.
Yeah.
Is it? The JP and I have these conversations. He supports Arsenal. I support Liverpool. We're both having a shocking season. Thank you very much.
Thank you,
CJ.
Judge. Thank you. Thank you so much.
Thank you, Judge.
Colleagues, I think let